Honourable members, the Speaker.
I acknowledge the Ngunnawal and Ngambri peoples who are the traditional custodians of the Canberra area and pay respects to the elders, past and present, of all Australia's Indigenous peoples. Almighty God, we humbly beseech thee to vouchsafe thy blessing upon this Parliament. Direct and prosper our deliberations to the advancement of thy glory and the true welfare of the people of Australia. Our Father, which art in heaven, hallowed be thy name. Thy kingdom come, thy will be done in earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, for ever and ever. Amen. Order, if members can leave the chamber as quickly and as quietly as possible. And I call the clerk.
Government business, notice number 1, suspension of standing and sessional orders.
Give a call to the Leader of the House.
Thanks, Speaker. I move the motion relating to the time and order of business for this sitting in the terms in which it appears on the notice paper. Speaker, this is a very unusual suspension. For different security reasons, there are exercises that have been run around this building for as long as the building's been here, where at different points alarm bells ring and things like that, and people have to leave the building or leave different parts of it. We've done that in every part of the building. Even the Senate has done one, but we've never had an exercise of that form in the House. So tonight, for those of you who have been preparing your speeches for the adjournment debate, you're no longer on it. What will happen at 7:30 is the House will suspend for a lockdown exercise and then resume at the conclusion of the exercise and adjourn immediately. The exercise covers the whole House of Representatives wing of the building, which knocks out band practice as well. They didn't tell me this when I was moving it. Part of the program of routine emergency exercises in Parliament House. It's the first time an exercise has been done while the House is sitting. The Senate, as I said, have conducted a similar exercise last year. The timing of 7:30 was chosen to cause as little disruption as possible to the sitting day. But for those who were scheduled for the adjournment debate tonight, this motion will also extend the adjournment debate on Thursday by 30 minutes to make up for it, so that the speeches are still able to be delivered.
I'll put the question. Those opinions say aye. Against no. I think the ayes have it, and I call the Leader of the House.
Speaker, I declare that, unless otherwise ordered, the following bills are referred to the Federation Chamber for further consideration. 1. The National Health Amendment Technical Changes to Averaging Price Disclosure Threshold and Other Matters Bill 2024 the Administrative Review Tribunal Miscellaneous Measures Bill 2024, the Family Law Amendment Bill 2024, the Crimes and Other Legislation Amendment Omnibus No. 1 Bill 2024, and the Treasury Laws Amendment Reserve Bank Reforms Bill 2023 at the adjournment of the debate on the motion for the second reading of each bill. 2. The Australian Naval Nuclear Power Safety Bill 2023 and the Australian Naval Nuclear Power Safety Transitional Provisions Bill 2023 at the adjournment of the debate on the motion for the second reading of the Australian Naval Nuclear Power Safety Bill 2023, and 3. The Parliamentary Workplace Support Service Amendment Independent Parliamentary Standards Commission Bill 2024 at the adjournment of the House for this sitting.
Call to the member for Bendigo.
Thank you, Speaker. On behalf of the Standing Committee on Employment, Education and Training, I present the committee's report entitled Study Buddy or Influencer, an inquiry into the use of generative artificial intelligence in the Australian education system, together with the minutes of the proceedings, and ask leave of the House to make a short statement in connection with the report.
Is leave granted? Give the call to member for New England.
Leave is granted.
Leave is granted. The member for Bendigo may proceed.
Thank you. On behalf of the Standing Committee on Employment, Education and Training, I am pleased to present our unanimous report, Study Buddy or Influencer, an inquiry into the use of generative artificial intelligence in the Australian education system. Gen AI has started to impact the Australian education system as well as the future of work in our country. It is not something that might be used. Gen AI is already being used in different degrees across our education system. It is the committee's view that the uptake of Gen AI in education sector should be a national priority, and for various reasons. When the use of Gen AI as an education tool is used appropriately, it can provide equitable access to students and educators and teachers alike. Mr. Speaker, the committee has recommended that Gen AI be used as an education tool and integrated into Australia's national curriculum, where these tools can act as a study buddy for all students and used in terms of appropriate content. It is critical for the integration of Gen AI technology in schools. These tools need to be fit for purpose, relate to the Australian context, sensitive to gender and cultural considerations, and trained on data that is based upon our national curriculum. This is why the committee has recommended this. It needs to be based on our national curriculum. The committee's report identifies these exciting opportunities for the adoption of Gen AI in education. We identify that Gen AI can help drive better educational outcomes for some of Australia's most vulnerable students. Indeed, students from low socioeconomic areas, students from non-English speaking backgrounds, those students with disabilities or have learning difficulties, students from regional and remote areas who may struggle to have access to subjects otherwise, First Nations students, all stand to benefit most from the rollout of this technology if done appropriately. Speaker, whilst I have highlighted the important opportunities presented by Gen AI, the committee is mindful of the risks with this new technology. The committee heard evidence on the risks presented by Gen AI and has considered how the education system can enact sufficient guardrails and safeguards to protect users, especially minors. I would also like to remark on the technology-related reforms already implemented in the education sector by the government and say that they will help protect the safety and well-being of our Australian children, but we must go further. I'd like to draw particular attention to the reforms being undertaken by the E-Safety Commissioner to protect children from deepfake and cyberbullying, all which can be exacerbated through the use of Gen AI. The committee also heard about additional risks in relation to the technology itself. Of particular importance is the need to protect users, especially children's data, to ensure that educational providers do not select Gen AI products or tools that store students' data offshore or sell them to third party. This is an area that needs critical attention. The integration of Gen AI will not affect schools, will not only affect schools but also tertiary education and the Australian education workforce and the future of work. Gen AI has broad implications for the design and implementation of assessments, academic and research integrity. The higher education sector is struggling to address the misuse of AI in assessments, another area of critical and urgent attention required. It is therefore imperative that students are adequately trained to use Gen AI technology appropriately and ethically, particularly when it comes to the integration into classrooms as well as assessments. Mr. Speaker, the committee has made 25 recommendations in this report. These recommendations focus on how schools can maximise the opportunity of education-specific Gen AI tools, promote quality EdTech products, support the implementation of Department of Education Australian Gen AI in schools framework, integrate AI literacy into the next school curriculum review when it occurs, and develop strong safeguards and standards and frameworks for the use of Gen AI in our education system. It's important to state that these recommendations are fit to regulate the application of AI in the education sector today. However, we acknowledge that as AI technology is developing and evolving, the committee may need to review these recommendations at a later date. Mr. Speaker, during the inquiry, the committee visited 2 schools who use Gen AI differently, and I'd like to take a moment to thank Pymble Ladies College, an independent school, and the Grange Peter 12 College, a public school, for sharing their experiences with the committee. The committee also heard that the Grange College will likely be reliant upon guidance from the Department of Education and government grants for funding to roll out technology in its school, whilst the committee heard that Pymble Ladies College has already successfully integrated Gen AI into their curriculum and is well positioned to share their expertise with other schools. It demonstrates again the digital divide that we have within our schools, and Gen AI presents an opportunity for all governments to work together to address that divide. These findings and recommendations contained in the report were informed by over 100 submissions and 15 public hearings, including 3 interstate public hearings in Victoria and New South Wales. I'd like to thank my committee colleagues for their work in this inquiry, and evident in the fact that this is a unanimous report. I'd also like to extend my thanks to our expert panel and the committee secretariat for the work that they've done on this report. I would like to thank the individuals and organisations that made submissions and participated in public hearings, especially to the students who shared their experience. In conclusion, Gen AI presents an exciting opportunity, yet is high-stakes risks for the Australian education system. If managed correctly, Gen AI in the Australian education system can be a valuable study buddy and not an influencer. Mr. Speaker, I commend the report to the House.
I'll just get the member to move. Oh, is the member for Longman seeking the call? Just need to get the member to move that the House take note of the report until after the member for Longman has spoken. So he has the call.
Mr. Speaker, firstly, can I thank all the members of the committee and the chair, the member for Bendigo.
And I'll just get you to seek leave. Sorry, member.
Sorry, I seek leave to speak on
Is
this.
leave granted? Leave is granted. The member for Longman will proceed.
Thank you, Deputy Speaker. Firstly, can I thank all the members of the committee and the chair, the member for Bendigo, for their valuable contributions and probing questions. Can I also thank all those who sent in submissions and gave evidence either in person or electronically. Lastly, I'd also like to thank all the APH staff, including the technical media staff and the hard-working secretariat staff, led by Fran Denny, who worked tirelessly on what must be said was a complicated yet very enjoyable and intriguing subject. AI in the Australian education system, or study buddy or influencer as it's now been named. I tried to approach this inquiry from the perspective of not just the Deputy Chair of the committee or an elected Member of Parliament. I tried to see this from all the different perspectives, that of the student, the teacher, the business owner, an employee, a parent of the student, as well as just a concerned citizen that may not be any of the above. One of the great challenges we face as legislators is getting the balance right, and this is where we all have differing views, even with our own party members. This, of course, is one of the major benefits of the committee process, that hopefully with 6 to 12 committee members with different cultural, educational, geographical and vocational backgrounds, we can be challenged in our thinking and come up with a report that addresses the concerns of all of these different cohorts in our community. For me as a former small business owner and as a parent and grandparent, my greatest concerns were around getting the balance right and ensuring that future generations of Australians, from a business and employment point of view, weren't left behind the rest of the developed world in a highly competitive global market. Balanced with, when I put my parent and grandparent hat on, ensuring that AI wasn't used by either governments, individuals, corporations or other organisations to coercively nudge our younger people in a particular direction. And after 18 months of listening to evidence and submissions, I must say that these concerns have not abated and in fact have only increased in their intensity. I've now seen the potential power of this technology and, of course, used in the correct manner will improve productivity, which is so important in business, particularly in a country like ours where we have some of the highest, if not the highest costs, as far as employee costs, energy costs, red and green tape, and the cost of tenancy, not to mention other costs associated with doing business like insurance. But we must ask ourselves, at what cost will these improvements in productivity come? Will it risk critical thinking? If problems are just submitted to platforms like ChatGPT and the like, and answers are just churned out according to the algorithms and parameters that the human developers of these platforms decide, where will students learn to simply figure things out for themselves? Not to mention that this is where the moral issue of coercive control comes in, because if the same answer is being given to the same question, if there is one dominant platform, do we risk our individuality and basically become sheep? Or could it be worse, and we have platforms that answers are always skewed to the left or the right, depending on what platform is being used? I've observed firsthand the development of social media platforms and YouTube, where I personally only receive recommendations that are all the same. This, of course, pushes people almost unknowingly further left or right in their thinking, which I think is very unhealthy for us as a society, as neither far right or far left ideologies are healthy for individuals or society as a whole. Balance is always the key. I also have concerns around the validity of the information. It must be remembered that AI only draws its conclusions from the most common consensus from mainly the internet. In fact, ChatGPT was brutally honest about its own failure to present the correct information when I asked it if ChatGPT had been around in 1500 AD and I asked it if the world was flat, what would the answer have been? The very honest answer I was given was, as the general scientific and religious belief of that day was the earth was flat, ChatGPT probably would have said the earth was flat, which we all know is incorrect. Apologies to any flat earthers out there. Which brings me to my final comments. Whilst I have real concerns about generative AI, they are somewhat curtailed by what I can only describe as my delight in the current generation who have in some ways been forced to have one of the best BS filters of all time. This generation have been bombarded almost since birth with information on devices handed to them, in many instances way too early for young developing minds, in my opinion. Ironically, as often happens, this negative practice has developed this positive outcome of a filter that I believe will hold them in good stead as they navigate this brave new world that will increasingly include more and more machine learning in our everyday lives. My final words to all are, constantly ask the question, what is the source of this information I'm receiving? And question the information given and don't take it as gospel. I commit the report to the House.
And I give the call to Member Bendigo.
I move that the House take note of the report.
The debate is adjourned and the resumption of the debate will be made an order of the day for the next sitting. Member for Bendigo.
I move that an order of the day be referred to the Federation Chamber for debate.
I'll put the question. Those opinions say aye. Against no. I think the ayes have it. And I give the call to Member for Bendigo.
Thank you, Speaker. On behalf of the Joint Standing Committee on Treaties, I present the Committee's Report 220, PNG Security Relations and ILO 187, and I ask leave of the House to make a short statement in connection with the report.
Is leave granted? The member for New England?
It's granted.
Leave is granted. The member for Bendigo may proceed.
Thank you, Speaker. I am pleased to make a statement on the Joint Standing Committee report, Treaties 220, PNG Security Relations, ILO 187. This report focuses on the J. Scott inquiries into the agreement between the Australian Government and the Government of Papua New Guinea on the framework for closer security relations and the International Labour Organisation's Convention number 187. The Promotional Framework for Occupational Safety and Health Convention. This report also includes the Committee's consideration of two minor treaty actions. The Australian PG Closer Security Relations Treaty aims to create a framework to deepen the security cooperation between Australia and Papua New Guinea, a close bilateral partner. The treaty creates obligations for the two countries to work more closely together on mutual security interests. The agreement reflects the long-standing cooperation, shared history, proximity and common strategic outlook. Australia and PNG already have a strong partnership, which includes a maritime border. The agreement addresses both traditional and non-traditional security threats. For example, traditional areas of security include defence, policing, border, and maritime security. But the agreement also seeks to expand the concept of security in non-traditional areas such as cybersecurity, climate change, violence against women and children, and critical infrastructure. Specific obligations in the agreement focus on areas such as mutual security cooperation, status of forces, security consultation, and the protection of information, plus settlement disputes. Issues raised in the public hearings include Australia's bilateral relationship with PNG, security focus of the agreement, individuals covered by the agreement, the treaty's expansion of the concept of security, and finally, critical infrastructure, including cybersecurity issues. The second treaty in this report is in relation to the International Labour Organisation Convention 187, which improves work health and safety outcomes by ensuring that ILO members, like Australia, have national policies in place to promote safe and healthy work environments and advance the rights of workers. By ratifying this treaty, Australia shows it is committed to protecting workers from occupational harm. Australia's high workplace standards are demonstrated by the fact that we already have the policies, systems and programs in place required by this treaty. Ratification, therefore, will not require any additional obligations, funding or future treaty action, but demonstrate Australia's resolve to ensuring workers' safety. Ratification of Convention number 187 places Australia in a small group of countries who've ratified all 10 fundamental ILO conventions. This positions Australia as a global leader of the promotion of international labour standards and will help improve workplace health and safety outcomes within Australia Pacific, something that we should all be very proud of. Two minor treaty actions in the report are amendments to the International Convention on the Standard of Training, Certification, Watchkeeping for Seafarers, and amendments to the 1996 Protocol to the Convention on the Prevention of Marine Pollution by Dumping Waste and Other Matters, 1972. The Seafarers Amendments will ensure Australia's training, certification and watchkeeping standards are consistent with international standards, and the dumping amendments will help remove sewage sludge from the marine environment. The committee resolves that binding treaty action be taken for both major treaties and minor treaty actions. Speaker, on behalf of the committee, I commend this report to the House.
I have received a message from the Senate informing the House that Senator Rennick has been discharged from the Parliamentary Joint Committee on Human Rights and that Senator Goodell has been appointed a member of the committee. And Senator Rennick has been discharged from the Parliamentary Standing Committee on Public Works, and Senator Kovacic has been appointed a member of the committee. I call the clerk.
Government business. Order of the day number 1. National Health Amendment, technical changes to averaging price disclosure threshold and other matters Bill 2024. Resumption of debate on second reading.
The question is that this bill be now read a second time to give the call to the honourable member for New England.
Well, thank you very much, Mr Speaker, and I want to commend this. I note that also at 7:30 tonight with the security issue happening and the evacuation of the building, I bet you there'll be more people on the streets of Ada Vale spinning plates than there will be in this building by the time they call that evacuation. The National Health Amendment, technical changes to averaging price disclosure threshold and other measures, Bill 2024, clarifies the operation of the National Health Amendment Enhancing the Pharmaceutical Benefits Scheme Act 2021. The 2021 amendment provides improved pricing arrangements and more reliable supply for older and low-cost medicines that can be more susceptible to medicine shortages. This is related to minimum stockholding requirements, which require companies to hold a minimum of either 4 or 6 months of stock for certain PBS medicines referred to as designated brands. As part of this measure, the Australian government supported the investment by the medicines industry in managing supply chain risks through the MSR through one-off price increases to improve the viability of low-cost medicines. In addition, designated brands are protected from price disclosure reductions through thresholds, which ensure that price reductions occur only when there is significant discounting in the market or where there is a sustained discounting over a period of time. The bill before us today clarifies the operation of the Act, which relates to designated brands subject to the price disclosure thresholds. The bill includes only technical amendments, which are intended for the avoidance of doubt and do not alter the operation of the existing provisions which have been in effect since the 1st of July 2022. While the Federal Court dismissed the case, this amendment addresses the potential risk that the timing of a price disclosure reduction could be invalid. The Coalition will support this bill because it clarifies the provisions of the 2021 Amendment Act, which was brought in under the former Coalition government and forms part of the important strategic agreements we made with the pharmaceutical industry. Whilst we support this bill, we are disappointed by the Albanese government's lack of action on the Health Technology Assessments Review, which also formed part of our strategic agreement with Medicines Australia. This review is grounded in the belief that whilst we need affordable medicines and treatments available here in Australia, we also need to ensure the timely access as new developments become available. That balance between affordable and timely access is critical for those patients who do not have time to wait. The government was supposed to release the final report of the HTA review at the end of the last year, but it has now been sitting on the Minister's desk for over 2 months. The Coalition understands that there is significant interest across the sector and patience to see outcomes result from this important review. It is beyond time that this report is released publicly and followed by an adequate government response. Australia's HCA system must be evolved to keep pace with advancements in medical technologies seen across the globe. We know that patient lives depend on it. It has also become clear that we are falling behind the rest of the world, where other countries are able to make approvals at a greater speed than we currently do here. Australia's current HCA process were not designed with the current technological advancements in mind and need to be updated for the modern realities of healthcare. We need to evolve our systems to keep pace with the rapid evolution of technology so critical for the care of Australian patients. Addressing this issue would have wide-flowing benefits for patients, their families and the entire healthcare system. This is critical right now as Australia's healthcare system faces significant pressures at every point. Our hospitals are overrun, ambulances ramping as at record highs in states across the country. Primary care is at crisis point, with Australians facing record challenges in getting access to affordable GP appointments. It has literally never been harder or more expensive to see a doctor. In many regional hospitals, there isn't even a doctor. If the nurse breaks her arm, she has to go to another hospital because there's no doctor in the hospital. In other areas, such as Muswellbrook, there is no obstetrics. a major town with no obstetrics, so people have to go to Tamworth or Maitland if ladies wish to have a baby. And workforce shortages are impacting almost every area of the system, whilst the government refuses to take action. There needs to be real action to ensure that all Australian patients have access to that care they need, when they need it, where they need it, including by addressing the challenges with affordable and timely access to new medicines and treatments. This should make the HDA review an urgent priority for the government. This bill also reflects the importance of stockholding requirements, as shown by the recent severe medicine shortages that are occurring under the Albanese government's watch. The recent shortage of saline IV fluids in Australia has posed a serious risk to the operations of our healthcare system. Saline IV bags are absolutely critical to the emergency healthcare provided to patients in Australian hospitals. But doctors in every hospital around our nation were told to ration the amounts being used for their patients. This cannot go on. When asked about this issue in question time last month, Mr Gallagher admitted that the Albanese government had been aware of the impending shortage since May 2023. They appear to do nothing about it. It was shocking to hear the minister confirm that the government had known about the impending shortage for more than a year and failed to take action. The Albanese government refused to show leadership on this national shortage, and instead lied, deflected and refused to take responsibility, something they've become quite apt at doing lately. Overseas drug regulators, including the FDA, the European Medicine Agency and the New Zealand Pharmac, confirmed that they have minimal to no issues with their national supplies. So the government had more than 12 months' notice of an impending shortage, and no other country around the world has experienced supply issues on the same scale as Australia. This was clearly a crisis of the government's own making. It's emblematic of them creating their own disturbance, whether it's to the economy or to medicines or to health. And it demonstrates the importance of ensuring we have effective measures in Australia to safeguard Australians' access to essential medicines. So once again, the opposition will support this bill, which forms part of the important strategic agreement that the Coalition achieved with Australia's medicines industry for the benefits of patients across Australia. I commend this to the House.
I thank the honourable member, and I call the Minister.
I move that debate on this bill be adjourned to a later hour this day.
Order. The question is that the debate be adjourned and the resumption of the debate be made in order of the day for a later hour this day. Those of that opinion say aye. To the contrary, no. I think the ayes have it. Clerk.
Government business, order of the day number 2, Administrative Review Tribunal, Miscellaneous Measures Bill 2024, resumption of debate on the second reading.
Order. The question is that this bill be now read a second time, and I call the Honourable Leader of Opposition Business.
Deputy Speaker, I rise to speak on the Administrative Review Tribunal Miscellaneous Measures Bill 2024. This bill is yet more evidence, if any be required, that the Attorney-General is simply not very good on administrative detail. This is the Attorney-General's third attempt at putting in place adequate legislation to abolish the Administrative Appeals Tribunal and replace it with the Administrative Review Tribunal. His first attempt was introduced almost a full year after he first announced he was going to do it. He introduced the first two bills in December of 2023. That was the first attempt, but he was a bit sloppy and he didn't quite get it right. Just 2 months later, he had to have another go. So in February of this year, he made his second attempt. He introduced another bill which made changes to the first one. And then he made a deal with the Greens to try to limit scrutiny of the legislation and to push it through with a degree of urgency. But again, he'd been a bit careless, a little bit hazy on the details. The fact is, the Attorney-General is pretty hopeless without an instructing solicitor. So now we're on to attempt number 3, a so-called Miscellaneous Measures Bill. This is legislation that amends attempts numbers 1 and 2, and there is a certain irony to this attempt, because the legislation he passed through his first and second attempts has not yet even commenced. The government has announced that the Administrative Review Tribunal will now commence on 14 October. Clearly, at some point in the winter break, after he'd rushed off to Government House for the royal assent and announced a commencement date, the Attorney-General must have had the horrible realisation that there were yet further problems in the legislation that he'd drafted. And suddenly, the Attorney-General was in a great rush to introduce legislation to make yet further changes. We know he wants this bill to pass before the Administrative Review Tribunal is up and running. Presumably, this is to prevent his mistakes from spawning even bigger problems. The net result is that the Attorney-General, the member for Isaacs, is now racing to clean up his own mess before he hits his own deadline. Perhaps the Attorney-General should have paused to take a breath to try and get things right the first time. Better still, perhaps he should have practised what he certainly loved to preach in opposition and tried some proper parliamentary scrutiny and openness. If we'd had a proper inquiry instead of the sham process that the Attorney-General foisted on the Parliament, perhaps the issues in this bill would have been identified and addressed properly at the time. We'll never know. It is worth spending a few minutes reflecting on what exactly this bill is trying to achieve. This bill is part of a package of legislation that is intended to abolish the Administrative Appeals Tribunal and replace it with the Administrative Review Tribunal. As the Shadow Attorney-General has said in the other place, debates over this package of legislation should be framed by asking two simple questions. What did Australians have before these Administrative Review Tribunal bills, and what do they get afterwards? Before the Administrative Review Tribunal bills, Australians had an administrative tribunal that reviewed government decisions. After the Administrative Review Tribunal bills, Australians get an administrative tribunal that reviews government decisions. At a cost of $1 billion. Before those bills, Australians could apply for merits review of a government decision that affected them. Afterwards, Australians can apply for merits review of a decision that affects them. Before the Administrative Review Tribunal legislation, we had a body of tribunal members, roughly half of whom were appointed by a Labor government. Afterwards, we'll have a body appointed entirely by a Labor government. What we learned from the whole grandstanding palaver of the Attorney-General's approach to this issue is it would seem that the letter R is the most expensive letter of the alphabet, because the budget papers make it very clear that to change from the AAT to the ART is costing Australian taxpayers $1 billion. This may just be the most expensive recruiting and rebranding exercise in Commonwealth history. The Coalition has repeatedly said that we are not opposed in principle to reforms to Australia's system of administrative review. We have said that we recognise there are areas where there's a legitimate need for reform and improvements could be made. But the question we have now is for every Australian taxpayer, and a question brought right to the front of our collective minds, and certainly should be, by this bill. Do taxpayers think it is worth spending $1 billion of their money to establish a new body that does the same thing as the old body did? It's a question that every Australian mum or dad who's having to stretch to pay their insurance or power bills might want to turn their mind to. It's a question that every Australian who has a mortgage and who knows that the Albanese government's reckless spending is fuelling inflation and keeping interest rates high for longer might want to turn their mind to. Indeed, there are other questions we could ask. What is it about changing a single letter on the letterhead and replacing half a cohort of tribunal members that is worth $1 billion of taxpayers' money? For every member in this place, and I'd suggest that is every member, who cares about women's safety, why is it better to spend hundreds of millions of dollars on a new tribunal rather than that money going directly to women fleeing domestic violence? And for members from Western Australia, and particularly Labor members, an obvious question is why would you support spending more money on a new tribunal than is being spent on the transition to the live sheep in export industry? And for every member of this place who values good process, an obvious question is why is it acceptable that the sloppiness and repeated patch jobs from the Attorney-General are taking up so much of the precious time of this Parliament? What are the pressing issues in this bill on which the Attorney-General wants us to legislate with urgency? Let me quote from the explanatory memorandum. Quotes, "The bill would make further amendments to 52 Commonwealth Acts, including the ART Act, to update references to the Administrative Appeals Tribunal in legislation that has passed or been introduced to Parliament since the introduction of the ART Act, and to make technical amendments to support the efficient conduct of tribunal review and ensure the legislation operates as intended." Close quotes. To be clear, we are amending the bill this Parliament passed just in May of this year, which has not yet commenced. We are making changes by reason of the bill that is now before the Parliament to 52 acts. It must be acknowledged, if we are to do our best to reflect positively on the Attorney-General's dismal performance, it must be acknowledged that at least he's doing better than he did at earlier stages of this farcical and convoluted procedure. After he introduced the primary Administrative Review Tribunal bill, the Attorney-General introduced 2 tranches of consequential amendments legislation. His first consequential amendments bill changed 138 acts. His second consequential amendments bill changed 110 acts. This time he's down to 52. It may be that when he next rushes in here urgently demanding that we legislate to fix up some other mistakes that he discovers, that we may be asked to deal with just 10 or 20 different acts of the Commonwealth Parliament. We will simply have to wait and see what further the Attorney-General may be desperately seeking the assistance of this House to deal with. The Coalition would probably have a little more sympathy for the Attorney-General if this were not a problem that he insisted on creating for himself. As we said, when the first 3 bills were rushed through the Parliament after the Attorney-General did a grubby deal with the Greens, at that time what was before the Parliament was 692 pages of new primary legislation and 760 pages of explanatory materials. Those bills at the time were intended to directly affect the 67,000 or so cases which at that time were before the Administrative Appeals Tribunal. The Senate inquiry into those bills was a perfunctory process. It was a Labor-dominated committee. It permitted just 6 hours and 55 minutes of committee hearings. This committee was prepared to spend less than a single day of work examining the legislation to establish the Administrative Review Tribunal. That equates to less than 40 seconds per page of legislation. It is hardly surprising, then, that the committee failed to pick up some obvious errors in the bill. As a piece of work, it was rushed, sloppy and unimpressive. It is worth mentioning some of the specific technical changes in this bill because they do highlight the point about sloppiness. A central responsibility of the Administrative Appeals Tribunal is dealing with migration and protection visas. One of the key issues corrected by the bill now before the House also relates to migration and protection visas. Of the 76,514 matters before the Administrative Appeals Tribunal as at 31 July this year, 66,241 of them are in the Migration and Refugee Division. In other words, It's 87% of the Administrative Appeal Tribunal's current caseload. You would think, therefore, that the Attorney-General would take the time to get this right before rushing ahead. It's worth pausing just to examine these numbers in a bit more detail. The Attorney-General's amendments abolishing the Administrative Appeals Tribunal and establishing the Administrative Review Tribunal passed the Parliament on 28 May this year. Government statistics show that just 3 days later, as at 31 May this year, the Administrative Appeals Tribunal had 69,312 cases on hand, with a median time to finalise of 38 weeks. In the 2 short months since the Attorney-General passed his reforms, trumpeting efficiency amongst other things, as at 31 July 2024, the caseload was sitting at 76,514 cases on hand, with a median time to finalise of 53 weeks. Since the Attorney-General's reforms, the performance of our administrative review system has gone materially backwards. The Attorney-General, in just 2 months, has increased the backlog by more than 10%, and he's increased the wait time by almost 40%, adding an extra 15 weeks to the time required to hand down a decision. It will now take you more than a year to get an answer out of the Administrative Appeals Tribunal. Let me highlight the substantive issue here, and that is dealing with the Migration and Refugee Division of the Administrative Appeals Tribunal, and an issue which will shortly affect the equivalent jurisdictional area in the Administrative Appeals Tribunal, and that is the issue of whether or not the Tribunal has jurisdiction to hear the matter. Whether a review application becomes another case that adds to the Tribunal's burgeoning workload or not. The amendments in Part 12 of the bill now before the House reveal a potential problem in the Administrative Review Tribunal legislation in relation to this particular critical issue. You might very well think that one of the first issues you would want to be clear about in establishing a new review body is exactly which cases it has to deal with. That would particularly be so if you are talking about the area of jurisdiction which makes up 87% of the Tribunal's workload. Apparently, though, that did not happen. It is worth reading directly from the explanatory materials for the provision of the bill which amends subsection 348(2) of the Migration Act, which concerns the jurisdiction of the Administrative Review Tribunal to review migration and protection decisions. To be clear, we are not talking about the version of section 348 of the Migration Act that the Coalition drafted and which is currently in force. We are instead talking about changes to the version drafted by the Attorney-General, which was rammed through the Parliament in May and which is due to become law on 14 October this year. The Attorney-General, during his winter break, as I referred to earlier, evidently realised there was a problem with his drafting, and so he is now moving to fix it in item 119 of the bill before us today. The explanatory materials state as follows, quotes, "This item repeals and replaces subsection 348(2) of the Migration Act to explicitly state that the Tribunal must not review an application made under sections 347 and 347A of the Migration Act that is not properly made," close quotes. And I'll continue to quote. Quotes, "The effect of this amendment is that the Tribunal will not have jurisdiction to review an application made under Part 5 of the Migration Act if it is not properly made. This sits alongside existing subsection 348(1), which provides that the Tribunal must review an application which has been properly made. Together, these provisions put beyond doubt how the Tribunal is to deal with applications for reviewable migration decisions and reviewable protection decisions," close quotes. What is the effect of these changes? It certainly sounds as if there were significant doubts about whether the Tribunal was required to hear a case or not. It sounds as if the Tribunal might have been required to review an application even if the application was not properly made. That is the risk that this provision in the bill seeks to close off. You do not have to be a genius to realise that if a tribunal is forced to review applications that are improperly made, you are potentially creating a very big loophole. You may be creating a pathway for people to remain in Australia simply while their case is resolved, simply by lodging an incomplete or incorrect application. And if you were in a position where you were told that simply by lodging paperwork, even if it were incorrect, you could stay in Australia for an extra 53 weeks, you might very well decide that it was a good idea to lodge that paperwork, even if it was incorrect. Is this what we are dealing with here? We simply do not know, but it warrants careful examination. The government may wish to describe this bill as containing simply technical and machinery provisions, but time and time again, the Coalition has learnt, through experience, that we simply cannot trust this government and this Attorney-General to get the basics right. This bill requires scrutiny, and the opposition intends to examine this bill in detail to help the Attorney-General to help himself. I thank the House.
I thank the Honourable Leader of Opposition Business, and I call the Minister.
I move the debate on this bill be adjourned to a later hour this day.
And I'll put the question. All of those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Clerk.
Government Business, Order of the Day number 3, Family Law Amendment Bill 2024, resumption of debate on the second reading.
The question is that this bill be now read a second time, and I call the Honourable Leader of Opposition Business.
Thank you, Mr Deputy Speaker. I rise to speak on the Family Law Amendment Bill 2024. As the Shadow Attorney-General has observed, there are a few topics in the Attorney-General's portfolio which touch more directly on the lives of ordinary Australians than family law. Every year, thousands of Australians will find themselves going through the pain and sadness of separation, and in a small proportion of those cases, disputes will be decided by a judge in Australia's family law courts. As we have said before, we should aim for a system that resolves those disputes as quickly and cleanly as possible. Where children are involved, we should at all times prioritise their best interests. And we in this place need to be cognisant that there are many, many couples across this country who will go through separation processes without going through the courts. In the debates on this topic last year, the Shadow Attorney-General spoke about separating couples who are making decisions in the shadow of the law. And on this side of the chamber, we take that shadow of the law very seriously. We know that not every case is decided by a judge. We know that not every person going through one of the hardest times in their life will be able to afford a lawyer. We know that well-intentioned changes can backfire, and we know that mounting costs and delays can entrench and inflame the hurt that comes with a bad separation. So our approach to this bill is sober and it is cautious. There are parts of this bill where we welcome the concessions the government has made to orthodoxy and common sense, and there are parts where we have questions. In many places, we agree about some of the problems this bill tries to address and the general intent of what the government is trying to do. But we need to understand impacts on the ground and impacts on families. Do these changes work? Do they make things better for Australian families going through the pain and sadness of separation? Do they make things easier, or do they add complexity and delay? We make no apologies for being cautious about these issues. We've seen how cynical the government has been in this area in the past. We saw how last year the government was preparing to ram through a surprise amendment, laying the pathway to demerging the family courts. They were seeking to undo one of the most successful measures in family law in the last 10 years, which has made a measurable improvement to our family law system, reducing the pressure on tens of thousands of families. We saw it just last year, how Labor was prepared to disregard the expert advice of the Australian Law Reform Commission and rewrite critical provisions in the Family Law Act to erase the decades of bipartisanship and pragmatism that underpinned parenting orders in our country. We saw that Labor was prepared to drastically undermine and rewrite what it means to make decisions in the best interests of the child. We saw how Labor repealed a requirement, or sought to repeal a requirement, that a court consider the benefits of a meaningful relationship with the child's parents and other significant people in the child's life where safe to do so. Labor said the court just needed to consider the benefits of a relationship. They described the change as minor. On this side of the House, we take a more cautious approach. We are not satisfied that removing the requirement that a relationship be meaningful is a minor change. Similarly, we think caution is the right approach to this bill. This bill has 5 schedules and deals with a range of issues in each schedule, but in the interest of time, I will touch on just a few key points. The first schedule in the bill deals with how the courts approach property settlement for separating couples. The government's stated intention here to codify existing common law principles that have been worked out through the case law but aren't in the Act. We know that the family courts have broad powers to deal with property settlements. We know that family courts routinely deal with the financial impacts of domestic and family violence when making property settlement orders. For both married and de facto couples, they take into account, quotes, any fact or circumstance which, in the opinion of the court, the justice of the case requires to be taken into account, close quotes. There is a line of cases that establish a type of claim called a Kennan claim, which allows a court to adjust a property settlement where one party has demonstrated violent conduct towards another, the conduct had a discernible impact on the other party, and the contributions of the affected party to the property pool were made substantially more difficult due to the violent conduct. So there is existing law allowing for the family courts to deal with the effects of family violence in property settlements, but it is not in the Act. And for those who are going through a separation without appearing in court, it will not be immediately apparent how the court would deal with those issues. There is widespread agreement that this is a matter needing to be addressed. Senator Henderson, when she was the member for Corangamite, recommended that this be addressed. The extensive Joint Select Committee inquiry that was chaired by the former member for Menzies, Kevin Andrews, with Senator Hanson as Deputy Chair, made clear recommendations that the Family Law Act should better reflect the impact of family violence on property settlements. So there is broad agreement on the issue. In fact, the Coalition started consultation on this issue before we left office. The question is about the solution. The government has made it clear it intends to codify the existing law. So, do the provisions of Schedule 1 merely codify the existing law, or are the effects more far-reaching? Are there unintended consequences? It is not just the Coalition asking these questions. In relation to the exposure draft of the bill, the Australian Bar Association said it understood the intention was to incorporate the approach set out in the case law, but that, quotes, in so doing, it is important to ensure that the codification process does not result in unintended changes to those principles or provide scope for argument about whether and what changes were intended to be made, close quotes. This is a point well made by the Australian Bar Association, and there are legitimate questions here that it is appropriate for this chamber to explore. Schedule 1 of the bill also sets out express provisions which allow the courts to make orders about family pets as part of a property settlement. This may be surprising to some who are not familiar with the field, but it is a genuine issue that courts deal with in family law cases. On occasion, parties will be involved in lengthy disputes about pets, and we know that on occasions these disputes can be difficult for all involved. As with other forms of property, courts have broad discretions to deal with pets and will be influenced by a range of factors. For instance, courts will consider the best interest of the child in relation to the arrangements for a pet in cases involving children. So at first blush, including provisions that set out the principles courts will apply to deal with pets is not objectionable. But it was not part of the exposure draft process for this bill, so we will welcome a sensible exploration of whether the provisions work as intended. The second part of Schedule 1 that is worth touching on briefly is about the principles that courts apply in property settlements. This is an area where Labor has, to its credit, made significant concessions and moved back towards a more sensible approach. I say back towards a sensible approach because this was an issue first canvassed a year ago as part of the exposure draft process. And in that exposure draft process, there were notable omissions. There was no mention of the best interests of the child, for instance, or of making orders that safeguard children, as opposed to parties, from the impacts of abuse, neglect or family violence. So we cautiously welcome the government's decision to take a different approach and instead apply the principles that govern child-related proceedings, principles which have stood as good law since 2006, so that they will also apply to property settlements. The second schedule in this bill is about establishing a framework to regulate children's contact services. These services have existed as part of the family law system since the 1990s and provide a location where children can maintain contact with parents or family under supervised arrangements. However, these services do not currently have to meet consistent quality, safety and operating standards. Both the Australian Law Reform Commission and the Joint Select Committee, chaired by Kevin Andrews, recommended establishing a regulatory regime that would allow these services to be accredited, and the Coalition accepted that recommendation. We agreed that children's contact services should be subject to accreditation rules, but reserved our position in relation to the criminal offences for services that operate unaccredited. Therefore, in principle, Schedule 2 of the bill accords with the Coalition's policy position, save in respect of criminal offences. Amongst other things, Schedule 3 includes a range of provisions dealing with protected confidences. These are, quotes, communications made in the course of professional confidential relationships, close quotes. In practical terms, we're talking about medical records, psychological and psychiatric counselling notes and the like. On occasion, these types of materials can make their way into evidence where there is limited or no probative value for the court. The Coalition's long-standing position has been that there must be an appropriate balance between protecting sensitive medical and other records from going into evidence, while also recognising the importance of parties being able to rely on relevant subpoena material and ensuring that decision-makers have sufficient evidence before them to inform their decision. The Shadow Attorney-General has said this publicly on more than one occasion. This is the government's second attempt at legislating a protected confidences regime. The first attempt was withdrawn at the exposure draft stage after strong feedback from the legal community that it was unworkable. So it is appropriate that this version is also scrutinised to ensure it is fit for purpose. Briefly, the fourth schedule includes general provisions that repeal and replace the existing costs regime in the Family Law Act, deal with rulemaking by state family law courts and valuing superannuation benefits. The fifth schedule sets out a review mechanism. There are a number of complex issues raised by complex questions raised by the headline issues in this bill. As I mentioned, there are other changes to the bill which I have not spoken to now, but which will be equally worthy of an in-depth consideration through a committee inquiry, because we know the potential impact of these sorts of provisions on Australian families. As I said at the outset, the Coalition agrees about many of the problems and issues this bill seeks to address. We welcome those parts of the bill in particular where Labor has built on the work the Coalition commenced in government or has adopted positions which align with the Coalition's position. The appropriate way forward is to look at these measures carefully so that we understand their impact on families before committing them to law. We will continue to be sensible, cautious, sensitive and pragmatic in these areas. I thank the House.
I thank the Honourable Leader of Opposition Business and I call the Minister.
Thank you, Deputy Speaker. I move that debate on this bill be adjourned to a later hour this day.
And I'll put the question. All of those of that opinion say aye. To the contrary, no. I think the ayes have it. Clerk.
Government Business Order of the Day number 4, Crimes and Other Legislation Amendment, Omnibus number 1 Bill 2024, resumption of debate on the second reading.
Order. The question is that this bill be now read a second time, and I call the Honourable Leader of Opposition Business.
Thank you, Mr Deputy Speaker. I rise to speak on the Crimes and Other Legislation Amendment Omnibus No. 1 Bill 2024. This Omnibus Bill makes a range of changes to our criminal law investigation and enforcement apparatus. It is a bill that has received appropriate scrutiny through the Parliamentary Joint Committee on Intelligence and Security, which recommended some minor changes. It is a bill that the Coalition is pleased to support, subject to those recommendations. There are 5 schedules to this bill. The first schedule would amend the Crimes Act, the Proceeds of Crime Act and the National Anti-Corruption Commission Act to enhance the legal framework relating to the seizure of digital assets. The proposed amendments would expressly clarify that a warrant may authorise the seizure of digital assets and that an executing officer is able to access a person's digital wallet and transfer its contents as a means of seizing the digital asset. We know that criminals are increasingly sophisticated and use cryptocurrency as a way of storing and distributing the proceeds of illicit activities. Evidence before the Parliamentary Joint Committee on Intelligence and Security has made very clear that this is an issue frequently encountered by the Australian Federal Police. Indeed, the AFP made the point to members of the Parliamentary Joint Committee that it had restrained more than $41 million in cryptocurrency across the 2022-23 financial year alone. In one large-scale disruption of a money laundering operation in 2023, the AFP executed 13 warrants and charged 10 alleged offenders, with approximately $215 million in criminal assets restrained to date, including over $30 million in cryptocurrency. So there is no real argument about the scale of the problem or the need to have adequate powers to issue search warrants for and seize digital assets such as cryptocurrencies. Currently, under the Crimes Act, police are permitted to seize certain items discovered in the course of executing a warrant. To lawfully do so, the officer must believe on reasonable grounds that the item is evidential material in relation to the relevant offence and seizure is necessary to prevent concealment, loss, destruction or its use in committing an offence. Unfortunately, these thresholds are no longer adequate in the age of digital assets and cryptocurrency. To illustrate, where large sums of physical cash are found during the execution of a search warrant, it may be relatively easy for an executing officer to form the belief on reasonable grounds that the funds are tainted property, that's to say the proceeds of crime, and that seizure is necessary. The same cannot be said of digital assets like cryptocurrency. The mere holding of large amounts of a digital asset is unlikely on its own to be suspicious. There would need to be a level of analysis to develop some understanding of the source of those funds and the reason for holding digital assets that presently have a large value. Amongst other reasons, this is because there are sometimes legitimate reasons to hold digital assets that have a large value. For instance, the value of the asset may have changed significantly since it was obtained, noting that cryptocurrencies are notoriously volatile and changes in value are common. On the other side of the ledger, if police cannot take immediate action, the risk is high. Unlike physical assets such as cash, criminals can remotely and near instantaneously move a digital asset beyond the reach of law enforcement via an online transaction. To deal with these issues, Schedule 1 of the bill proposes a lower threshold for lawfully seizing digital assets. To seize those assets, an officer must reasonably suspect that the digital asset is evidential material and seizing the digital asset is necessary to prevent the digital asset's concealment, loss or destruction or its use in committing an offence. This threshold is appropriate given the unique challenges created by the discovery of digital assets in the course of executing a search warrant. Schedule 2 of the bill relates to the Proceeds of Crime Act and its interaction with digital currency exchanges. The Proceeds of Crime Act gives law enforcement agencies broad powers to monitor, freeze, restrain and forfeit proceeds and instruments of crime. This includes investigative and freezing powers in relation to financial institutions. The proposed amendments to the Act would extend those investigative and freezing powers in relation to certain digital currency exchanges. Importantly, this expansion of the Proceeds of Crime Act retains existing safeguards, including independent oversight by magistrate, limitations on the time during which orders made under the Act can operate, and powers to vary a freezing order in appropriate cases. The net effect is to ensure that freezing and monitoring orders under the Proceeds of Crime Act can be applied in relation to Australian-based cryptocurrency exchanges in the same way as to traditional financial institutions. The Coalition considers that this is appropriate and will help to keep laws governing the investigation and seizure of proceeds of crime workable in the modern technological environment. Schedule 3 to the bill would amend Section 4AA of the Crimes Act to increase the value of a Commonwealth penalty unit to $330 with a commencement date of 1 July 2024. We understand that the government intends to move amendments that would change this commencement date so that the new value comes into effect after the bill commences. Penalty units set the maximum financial penalty that can be awarded by a court for an offence. Ordinarily, the value of penalty units is indexed every 3 years in accordance with CPI. The value of a penalty unit at the time the Coalition left office was $222. This is now the third time in less than 2 years the Albanese government has increased the value of penalty units. In fact, there's been a 49% increase in the value of Commonwealth penalty units over 18 months. On 1 January 2023, they increased from $222 to $275, an increase of 23.9%. On 1 July 2023, they increased from $275 to $313, an increase of 13.8%. And on whatever date this measure comes into force, the value of a Commonwealth penalty unit will lift by a further 5.4% to $330. The government explains the rationale for this latest increase as follows, quotes, "The current penalty unit amount does not act as an effective deterrent for the most serious offending," close quotes. Are we to infer that when this government took the decision to increase the value of a penalty unit just last year, that they ended up with a number that was 5.4% short of the threshold required to effectively deter serious offending? The reality, of course, the transparent reality, is that this is a revenue measure for the Albanese government. The Coalition does not object in principle to the increase in maximum penalties by courts for those convicted of crime, but we do note there is a slew of regulatory offences, such as a failure to lodge a business activity statement on time, for which the Australian Taxation Office will impose a penalty equivalent to one penalty unit for each period of 28 days or part thereof that the return or statement is overdue. So it should not go without comment that the Albanese Labor government has slugged small businesses with a 49% increase in penalties for late paperwork in less than 2 years. Schedule 4 to the bill would amend the Telecommunications Interception and Access Act to clarify the functions of the Communications Access Coordinator in the Attorney-General's Department and create the position of Communications Security Coordinator in the Department of Home Affairs. This is essentially a legislative change that reflects the changes to administrative arrangements under the current government and the transfer of functions between the Department of Home Affairs and the Attorney-General's Department. While there are no concerns about the specifics of the measures in this schedule, they are symptomatic of a broader concern. That concern relates to the concentration of national security operational functions in the Attorney-General's Department, the same department that exercises oversight of those functions. It is a model that gives rise to legitimate questions. Schedule 5 of the bill deals with information sharing arrangements under the Telecommunications Interception and Access Act. It amends the arrangements applying to state-level bodies which oversee state-based integrity agencies. To be clear, this is not the integrity agencies themselves, such as the Independent Commission Against Corruption in South Australia. It is the oversight bodies for these state agencies, the inspectors who are there to ensure that the state integrity agencies exercise their powers appropriately. Evidence before the Parliamentary Joint Committee on Intelligence and Security concerning the state-based oversight bodies made it clear that limitations in the legislation are causing difficulty for those bodies in discharging their functions. These limitations arise because, under the Telecommunications Interception and Access Act, the oversight bodies are only able to receive information for a quotes permitted purpose, quotes, close quotes, or a quotes eligible purpose, close quotes. but the definitions of these terms do not capture all of the functions that the oversight bodies are meant to perform. The changes in Schedule 5 were welcomed by the Parliamentary Joint Committee, with one minor recommendation, which we understand the government intends to address in amendments to this bill. Subject to that recommendation being implemented, the Coalition welcomes these changes. Finally, Mr Deputy Speaker, it is worth commenting on an additional matter. We understand that in addition to the matters considered by the Parliamentary Joint Committee in relation to this bill, the government intends to move 2 additional amendments. The first is to push back sunsetting arrangements for secrecy provisions in the Criminal Code by 18 months. They are currently due to sunset on 29 December this year, and the amendment will push this date back to 29 June 2026. We have no objection to this in principle. It is in no one's interest for Commonwealth secrecy offences to lapse without a replacement being ready to go, and it is apparent that the Attorney will not be in a position to pass his proposed changes to Commonwealth secrecy provisions before the 29 December deadline. The second area is a definition of the term hors de combat in the Dictionary of the Criminal Code. This is a term that, roughly speaking, describes when a person cannot legitimately be targeted in military operations. We understand the government is repealing and replacing the definition to address a long-standing drafting error dating back to the 2000s. We have been advised by the Attorney-General's Office that the gist of the error is that the definition uses the word "and" when it should use the word "or." We understand that rectifying this defect avoids a potential unintended consequence, but this is a technical change that does not change the intended effect or operation of the definition. The Coalition is prepared to rely on the advice and assurances provided to us by the Attorney-General's Office about the intent and effect of the change, and we will support it on that basis. I thank the Parliamentary Joint Committee on Intelligence and Security for its work in relation to this bill and commend this bill to the House.
I thank the Leader of Opposition Business and I call the Minister.
Thank you, Deputy Speaker. I move that debate on this bill be adjourned to a later hour this day.
And I'll put the question. All of those of that opinion say aye. To the contrary, no. I think the ayes have it. Clerk.
Government Business Order of the Day number 5, Australian Naval Nuclear Power Safety Bill 2023, resumption of debate on the second reading.
Order. I understand it is the wish of the House to debate this order of the day concurrently with the Australian Naval Nuclear Power Safety Transitional Provisions Bill 2023. If there is no objection, there being no objection, the Chair will allow that course to be followed. And the question is that this bill be now read a second time, and I call the Honourable Shadow Minister for Defence.
Thank you very much, Deputy Speaker. These Australian Naval Nuclear Power Safety Bills enable a critical part of AUKUS. AUKUS, as we know, is a multi-generational nation-building task that has bipartisan support on both sides of the House. It was a coalition government under Prime Minister Morrison that founded AUKUS with US President Joe Biden and then UK Prime Minister Boris Johnson. And since the change of government here and in the UK, AUKUS has progressed. And it's great to see that, because speed is of the essence. By the early 2030s, Australia needs to be sovereign ready. We need to be able to own, operate, maintain a nuclear reactor which will sit inside the Virginia-class submarines that we're purchasing from the United States, and also be able to operate our own submarines, SSN AUKUS, which will be produced here in Australia. Speed is of the essence, so we support this bill and in principle support sensible amendments following the Senate scrutiny by the Senate Select Committee for Foreign Affairs, Defence and Trade, which reported in May. This is vital to our long-term defence capability. Having these Virginia-class submarines, they're the best in the world. They are the apex predators of the deep, and they will help keep Australia safe. And importantly for our regional partners, it will help to uphold our collective peace and prosperity. We enjoy good relationships with our neighbours, and it's really important that they understand that AUKUS is about our collective security, not just Australia's, the US's and the UK's. So it's in the best interest of our nation that we see AUKUS succeed, and we're going to need a lot of young Australians to get involved. We need the submariners of the future, we need the apprentices, we need people to start small businesses that will build out the supply chain. A lot of that work will happen in Perth and Adelaide. HMAS Sterling will be where our submarines operate from, but we'll also build our SSN AUKUS in Osborne in South Australia. And then across the country, we need resilience, and the way we achieve that is having a dynamic supply chain. And to quote Premier Malinauskas in South Australia, we have 6 states, 2 territories. This is one mission for all of us, and each state and each territory has a role to play. And so I'm excited to see what this does for Australian businesses as we rebuild Australian defence industry. So we're headed towards the Sovereign Ready milestone in the early 2030s. We've got the nearest gate, which will be 2027, which will be the establishment of Submarine Rotational Force West, just to the north of my electorate of Canning. I'm very proud to represent a number of Royal Australian Navy members who are submariners themselves, but also a growing number of people who are involved with AUKUS itself. One of the dads at a soccer match a couple of weeks ago was telling me how he's a fitter. He's 30 years old, a former Army engineer, and he put his name online to consider becoming part of the AUKUS project. He got a phone call within 24 hours with basically a job offer and the possibility of living in Hawaii for a certain period of time, which I've got to say is a pretty nice offer and a well-paid job too. And these are the sorts of jobs that we'll need for 30 years. So for families who are feeling the pressure from FIFO work, I know a lot of families just in my children's classes at school who dads mainly spend half the year away on mine sites. The opportunity to work in defence industry in Perth itself is very enticing, and so I encourage people to consider those pathways offered by AUKUS. But what this bill does is it establishes a nuclear safety framework. It will provide the regulatory framework for establishing AUKUS, and if we are to operate these nuclear submarines, if we're to operate facilities, if we're to handle material, then those activities need to be regulated. And so what this bill does, it establishes a regulator within defence itself, and it will be governed to the highest standards because we need to demonstrate to the United States and the UK that we can be trusted with their sensitive intellectual property, these reactors, and that we are building up the capability to make sure that the whole enterprise is safe and secure. And that's what these bills do. So it's a big step forward for Australia so that we can operate these nuclear submarines. And it's a part of several tranches of legislation required to implement and support AUKUS. So as I discussed already in my remarks, this bill establishes a framework to ensure Australia promotes, regulates and maintains the highest level of nuclear safety in relation to our future submarines. Its focus is on regulating activities on Australia's own nuclear-powered submarines and facilities. It does not apply to conduct on board the UK and the US. The past few weeks has been great for Perth because we've had USS Hawaii, a Virginia-class submarine, and USS Emery S. Land, which is a submarine tender. It's the first time in Australia's history that we've had a US submarine do maintenance within our ports, or our port, and that's what happened at HMAS Sterling. And embedded in both boats, or both vessels, were young Australians who've been training with the Americans. I met a young naval officer who'd conducted and completed successfully their nuclear submariner course for officers, and he was entrusted with parking the boat alongside the wharf there at HMAS Sterling, which is a big honour, and he did it to a good standard. The CEO of the boat told us. It was great to see a lot of young sailors also on USS Emery S. Land, the tender, which is like a floating factory basically. It's amazing the sort of logistical power that these vessels have, and they're doing their bit to keep US submarines running. So it was great to see all those things, and of course that's why these bills are being enacted, because we need to have a framework so that as these visits step up leading to 2027, and when we start to have a more permanent presence of US submarines, UK submarines from 2027, and then from 2030 when we get our own Virginia-class submarines, this framework needs to be in place so that we can do our things safely. So, in short, Deputy Speaker, we support these bills. We want to move faster. I think there is definitely room for improvement with the government. We want to see more investment into WA sooner. There's a lot of outstanding issues around HMAS Stirling. I've met with the local governments in the area. There's obviously a housing shortage. We're going to have a lot more people moving to Australia from the US and the UK, but also we're going to see more naval personnel into the AUKUS catchment area, which is the city of Rockingham principally, but also the surrounding local government areas as well. So we need more houses built, and that's a task for the local and state governments, but it definitely needs federal leadership. And we're calling on the government to do more about the housing shortage. There's also a general infrastructure deficit in Western Australia. Our hospitals have ramping hours through the roof, much higher than when the Labor state government came to power in 2017. And so we want to see more investment in our hospitals, particularly the Rockingham Hospital and the Peel Health Campus, both within the AUKUS catchment. And we'll service the families who move to WA to work at HMAS Stirling or in the AUKUS supply chain. So we need more investment in our hospitals and, of course, congestion. We've had 1.4 million people come to Australia since Q1 of 2022, and we're feeling it. A normal journey up to Perth probably takes about 70 minutes on a given morning. It's now taking 90 minutes, and that's just too long. There's a productivity cost. People aren't at their desks or at their factories or their place of work doing the jobs they are paid to do. And there's also a cost to family life. No one wants to spend any longer sitting in traffic away from their family. So investment in roads is critical, and that's particularly around HMAS Stirling. A lot of locals are worried about the level of people who are going to, the amount of people who are going to be driving through, but also the big trucks to do a lot of the building. So we want to see more houses, more investment in hospitals, and more investment in roads and other supporting infrastructure. There's a lot to be done, but we are going to support this bill because we believe it's in the best interest of Australia, of the US and the UK, and of course our region, because this is about collective security. And we did have young kids up there, but securing their future wherever they are, behind me now. This is about their future as much as the present. Thank you.
I thank the Shadow Minister and I call the Minister.
Thank you, Deputy Speaker. I move that debate on this bill be adjourned to a later hour this day.
And I'll put the question. All of those of that opinion say aye. To the contrary, no. I think the ayes have it. Clerk.
Government Business Order of the Day number 7, Treasury Laws Amendment, Reserve Bank Reforms Bill 2023, resumption of debate on the second reading.
Order. The question is that this bill be now read a second time, and I call the Shadow Minister, the Shadow Treasurer.
Thank you, Deputy Speaker. Deputy Speaker, the Coalition will not be supporting this bill. The Coalition has engaged in this process seeking to reach a bipartisan position for over 18 months. However, unfortunately, after the Treasurer and Labor surrogates used the past week to wage war on the Reserve Bank, we cannot support these changes. We believe in a stable, credible, capable, independent Reserve Bank of Australia. I've consistently and clearly raised the issue of the transition of the existing board members to the new interest rate setting board. The government's amendments leave open the option, unfortunately, for a stitch-up of the Reserve Bank board, and it seems increasingly clear that that was actually the motive behind the government's approach to these reforms all along. Recent public comments, not only from the Treasurer but other senior Labor figures, are attempting to blame the RBA for their own economic failures. And indeed, what they have had to say is deeply unsettling. Considering those recent events, the Coalition has serious questions about the government's commitment to the continued independence of the Reserve Bank. We have deep concerns about the motives of the government when it comes to appointments. And we saw that with the first two appointments, indeed, Deputy Speaker. On the very day that the review was issued, which laid out a very clear process for appointments to the board, the Treasurer completely ignored the process, and his consultation with us, and there is a convention that there should be consultation with the opposition on these appointments. His consultation was to let me know about his decision. Well, that isn't consultation. And it was very clear from the beginning that the Treasurer simply saw this as a way of implementing his sack and stack strategy, and it was a stitch up. It was a stitch up from the start. Now, the government has been at war with the Reserve Bank for the last week, and it began, of course, with the Treasurer blaming the RBA for, quote, smashing the economy. Smashing the economy? Well, that's because he smashed the economy, Deputy Speaker. I suppose you go and look for whoever to blame if you smash the economy, and that's exactly what this Treasurer has done. He ignores the fact that the government has many levers to beat inflation, to bring down interest rates, to deliver that low inflation, strong economy we all want to see. We all want to see. He has many levers. He has many levers. He can focus on managing his spending habit. He can focus on getting immigration in line with our housing supply. He can focus on getting rid of red tape, approving major projects in this country. He can focus on energy policy that's going to bring down the prices. I see our shadow energy minister here who knows how badly the government has failed on that policy. All of these are policy areas he can focus on, all of which can help to deliver that low inflation, lower interest rate, strong economy we all want to see. But sadly, Deputy Speaker, this Treasurer has ignored all those levers and he's focused on blaming the Reserve Bank. And he was backed in by the Prime Minister, by members of the government front bench, backed in by Labor-aligned commentators like Stephen Conroy, Stephen Koukoulas, all backing him in. Well, we'll get to Wayne Swan, and then he was backed in on Friday by the ALP President,
and
Wayne Swan.
This debate is interrupted in accordance with Standing Order 43. It will be resumed at a later hour, and the member will have leave to continue speaking when the debate is resumed. Are there any statements by honourable members? Give the call to the member for Flinders.
Thank you, Madam Deputy Speaker. I rise to give a shout-out to the member for Fairfax, who came and spent an excellent day in Flinders with me last week. Starting at SPX, formerly known as Sealight, a brilliant Australian company which makes 70% of the world's maritime and aviation navigation equipment, kitting out the world's defence forces with airfield in-a-box innovation, among other things, all run from a few huge garages in Somerville. They're giant marine buoys and aviation markers moulded at high temperatures, powered by gas the state Labor government wants to cut. Then we visited the magnificent Red Gum Barbecue, where our only B Corp certified restaurant wants to put solar panels on the roof, but its landlord, United Energy, won't let them, requiring them to have diesel generators on site for when the power stops. Diesel generators then became the theme of the day as we visited a number of sites from which 11 diesel generators power the Mornington Peninsula over the summer months, including one hosted by the beautiful Gazola family who are in the gallery today. And when we finally got to Sea Road Ferries to hear about their plans to electrify the nation's busiest ferry fleet, the power was out. So we pushed on, getting briefed in the dim light of the early evening, and it would have been quite hilarious if it wasn't so indicative of this government's hypocrisy when it comes to energy and climate change. Despite their policies, the peninsula is powering on, but without any help from them.
Member for McEwen.
Thank you very much, Deputy Speaker. Jennifer Jacobs served in the Royal Australian Navy from 1983 to 1985. She suffered severe abuse and received the maximum payout under the provisions of the Defence Abuse Response Task Force. She survived on a DVA gold card for the abuse that she suffered. She lived in Melbourne, was the Secretary of the Victims of Abuse in the Australian Defence Force Association. That's how Jennifer described herself. Yesterday, the Royal Commission into Defence and Veteran Suicide delivered the final report to the Governor-General, concluding the 3-year inquiry. Sadly, yesterday, I also learnt that Jennifer passed away after a battle with cancer. She wrote to me in July saying, "Doctors informed me that cancer will be finished by September." I think it's like politics, though. You've got to wait till you believe it when you see it. I can't say thank you enough to all the people who supported me at this difficult time. Jennifer was a fierce advocate and someone who wholly supported others when times were tough. The amount of times that she came to my office, working hard to support all those victims of abuse and trying to find a way through to actually get a positive result. No one I know had the strength of Jennifer for what she did. The motto of the association was a voice for the voiceless. Jennifer, you were the voice, and you know many of us in this place heard you and heard you loudly. Vale, comrade, may you rest in peace with our pain.
Member for Wide Bay.
Thanks, Deputy Speaker. As a nation, we are rightly proud of how our Defence Force personnel and veterans have served our nation, keeping us safe and securing our freedom. Honouring current and former members of our Defence Force is part of Australia's identity, but tragically, Australia hasn't supported our veterans in their time of need nearly as much as we commemorate their sacrifice. The former coalition government, with Peter Dutton as Defence Force Minister, recognised that service personnel and veterans were being failed by the country they risked their life for, and we responded by initiating the Royal Commission into Defence and Veteran Suicide. The Royal Commission found that the number of defence and veteran suicides between 1997 and 2021 is upwards of 3,000 men and women. It's clear that the system that is supposed to support our diggers in their time of need has failed abysmally. The words "thank you for your service" are absolutely meaningless unless we have a properly resourced Veterans Affairs system that gives veterans the support they need when they need it. I thank everyone who contributed to the Royal Commission and urge the government to work with the Defence and veterans and their families to implement this finding with the crucial urgency that the issue demands.
Member for Holt.
Thank you, Deputy Speaker. On Sunday, over 100,000 Australians of Macedonian descent celebrated the independence of North Macedonia after the dissolution of Yugoslavia in 1991. This Independence Day honours the resilience of Macedonian people and culture, which flourished despite centuries of foreign rule. From the Ottoman-era streets of Bitola to the ancient beauty of Lake Ohrid, your country continues to inspire admiration across the world. As the chair of the Parliamentary Friendship Group for the Republic of North Macedonia, I have worked closely with Ambassador Biljana Stefanovska to promote Macedonian culture in Australia. This includes supporting Macedonian language schools, which play a vital role in keeping Australian-born Macedonian children connected to their heritage. I have had the privilege of visiting your country twice since being elected to Parliament, seeing its beauty firsthand. Each destination I visited revealed a unique aspect of Macedonia's beauty, blending history, nature, and culture into an unforgettable experience. To all Macedonians in Australia and around the world, happy Independence Day.
Member for Wentworth.
I have watched and listened to testimonies from the Royal Commission into veteran suicides with utter disbelief. The figures laid out before us are not just troubling, they're utterly heartbreaking. It is tragic that we are losing an average of 3 veterans to suicide every 2 weeks. Since 1985, Conservative estimates put the total number at 2,000 veterans who have taken their own lives. The weight of this crisis is felt across generations. Each veteran lost to suicide leaves behind not only a grieving family, but also a community deeply impacted. Some of those were present yesterday in Parliament. After more than 50 formal inquiries over 30 years, we are still facing these devastating issues. Our servicemen and women, those who have sacrificed so much to protect us, have been systematically let down by the very institutions designed to protect and support them. I want to take this opportunity to thank those veterans and families and friends of veterans that contributed to the heartbreaking testimony to the Royal Commission. And the veterans and veteran families in my community, I say that we hear you. I hear you. I've spoken to community groups and veterans in the past 24 hours. The government has committed to considering and responding to the Royal Commission, and my community urges a thorough, substantial and speedy response. In particular, the final recommendation to establish a new statutory entity to oversee system reform across the whole defence infrastructure is critical to make sure that we make a lasting difference to veteran and defence suicides. We owe veterans more than our gratitude, we owe them our action.
Member for Macon.
Thank you, Deputy Speaker. Last Sunday, along with Olivia Savas, the state member for the seat of Newland, and Tea Tree Gully Mayor Marika Ryan, I attended a dedication service at the Tea Tree Gully St John's Lutheran Church for 3 newly constructed social houses in Ridgehaven. The service was led by Pastor Rolly Stall, who delivered an excellent and very appropriate sermon for the occasion. The housing project was initiated by members of the Tea Tree Gully St John's Lutheran Church a decade ago, but a series of obstacles and then COVID delayed the commencement of the construction until 2023. The 3 well-designed and constructed houses will become home to 6 people with a disability. I understand that 4 of those people, Nathan, James, Andrew and Bradley, have already moved into their new home. The project was made possible because of the determination and collective efforts of several people and organisations, and in particular the support from Lutheran Disability Services. My congratulations and compliments to the Tea Tree Gully St John Church community for their social conscience in delivering this project, which responds to both the needs of people with a disability and the social housing shortage that currently exists. The housing project is a terrific example of what can be achieved when good people come together and show initiative in meeting a desperate social need.
Member for Curtin.
Thank you. The polyphagous shot hole borer was first detected in Australia 3 years ago near my electorate of Curtin. Given the threat to Australia's biosecurity, it's been part of a national eradication plan since 2022. This plan relied on chopping down host trees to try to stop the spread. Since then, about 3,500 trees across Perth have been removed, with Curtin hardest hit. We've removed about 18 football fields of canopy cover across Perth, when we already have one of the lowest canopy covers of any Australian city. Now, this sacrifice would have been worth it if it actually worked, but due to a combination of slow and incomplete eradication response and a lack of understanding about the pest, the plan has failed. The borer has now spread across Perth in 170 different host species, including native species. We don't know enough about this biosecurity threat. We do know not all host trees are dying. We know the beetle can travel further than first known. And we know that the economic cost of this pest in California is estimated at nearly $16 billion. We need a better plan and urgent action. The National Management Group must transition to a management phase. It must allocate funding so we can research how it's spreading and how to stop it or slow it. This is a pest of national significance, and we must learn how to manage it effectively and stop chopping trees down in a vain attempt to eradicate it.
Member for Bean.
Deputy Speaker, in this House we rightly talk about the importance of teachers and strategies to encourage more students into the teaching profession. It's a path I nearly took. That's why it's particularly sad to lose suddenly a teacher and community builder like John O'Kane. I first met John when he was a high school student in the 90s and I was a Callow relief teacher. Over the years, I had many a chat with John when my sons were students at Marist College, Canberra. Friendly, empathetic, and always interested in the development of students, what made them tick, and how he could bring out the best in them. In a career spanning a couple of decades, John was the leader of the Marist College English department, a gifted teacher with a sharp intellect, passionate about the Pogues and Joyce, a kind and generous man who cared for all who shared his path. John was a former student at Marist, was the Markhouse Dean for a decade, was involved in many and varied activities across the life of the college. He shaped the lives of hundreds of students for the better and was beloved by all the teaching and support staff. Condolences to Sarah, Burton, Caledonia and Amber Rose, James and Mary, and to Carl, Deb, Gabby, Peggy, Nick and Phil, all across the O'Kane clan and the Canberra Irish diaspora. He will be greatly missed.
Member for Fairfax.
Thank you, Deputy Speaker. For anybody who believes that the Sunshine Coast as a lifestyle capital is immune to the housing crisis afflicting this nation, be very aware that we are hurting. Over the last 12 months alone, rental prices have increased by 27%. 27%. Is it any wonder that we have some residents of the Sunshine Coast on full-time incomes sleeping in their cars. We have couples, both of whom are earning full-time incomes, who are presenting themselves to charities, to low-cost food outlets, because they simply cannot afford to put food on the table. According to IFYS, 1,000 residents of the Sunshine Coast are now homeless, every single night, sleeping homeless. For 2 years, this government has overseen a housing crisis that has worsened, and it has a human impact. No new money, no new homes, no initiatives for renters. Show some leadership.
Thank you, Deputy Speaker. In coming weeks, people across the Blue Mountains, the Hawkesbury and Nepean will learn the final plan for Western Sydney Airport flight paths. Along with many people in my community, I'm not looking forward to it. It will have a finality about it. When Tony Abbott chose Badgerys Creek in 2014 as the site for a 24/7 second Sydney airport and the direction of the runway was decided in 2016, there was a looming deadline for an end to the silence that descends on our community at night. After a decade of fighting off some of the worst of the proposals, such as the merge point that would have seen 100% of incoming flights over Warramoo, Blaxland, Mount Riverview and Glenbrook, I think we will still be disappointed in the outcome. While designers have listened to our feedback, the response is that aircraft noise is shared more widely, which impacts even more people. But the aircraft noise, especially at night, still won't be fairly shared across all of Sydney, east and west. I want to thank everyone in my community who's engaged in the lengthy consultation process. Your voices were heard. I want to warn you, though, that our fight is not over and may take many, many more years. I'll continue this fight for greater protections for our sensitive World Heritage environment and for everyone who lives within that region, because we deserve the best possible outcome from these flight paths.
Member for Barker.
Madam Deputy Speaker, if there's one definable difference between the two sides of this chamber, it's this. On this side of the chamber, we get regional communities and we understand agriculture. In contrast, it's becoming blindingly obvious that Labor doesn't value the economic or the social contribution that regional communities make to our nation. Now, full disclosure, I was born in a regional community, I grew up on the family farm, and I've drenched my fair share of sheep. And so I know what blood, sweat and tears goes into the work they do. And I find it utterly insulting that those opposite can't treat our families, farmers and our regional communities with the respect they need. Banning a sustainable, profitable and ethical live sheep export industry, for me, is crossing the line, and I, for one, won't stand for it. What's next? I dread to think. It's quite evident that the Albanese Labor government is more about playing the politics of inner city votes than the long-term sustainability of growing our regions. It's little wonder that confidence in the federal government has collapsed amongst the ag sector, with now just 1 in 10 farmers saying Canberra is listening to them and had a positive plan for their future. So today I join calls from others to ask those opposite to start listening. It would have been a good start to send the Prime Minister out the front of the building today.
Member for Canberra.
Thank you, Deputy Speaker.
Members of the gallery, just remind you don't get to participate in our discussions here. Member for Canberra has the call.
Thank you. On Friday, I had the honour to attend the launch of the Australian Brain Cancer Foundation at the ANU. Led by founder and CEO Milena Skepev, the ABCF is a Canberra-based charity for brain cancer, which has been established with the generous support of their founding partners and will change many lives. It will support researchers and clinicians to raise awareness, provide access to information and take a multidisciplinary approach to better understanding brain cancer. Brain cancer is an incredibly cruel disease and takes the lives of more people under 40 than any other cancer. ANU head brain cancer researcher, Professor Leonie Quinn's research focuses on the underlying factors of brain cancer through the generation of genetic models, and she's brought together a fantastic team of the best and brightest in research and medicine in this area who will work as part of this foundation. Professor Quinn has also inspired Zara, Melena's daughter, and her best friend Miller, two young Canberrans who now want to be scientists and doctors when they grow up. They have been making earrings and selling them and have raised over $30,000 to support this, which is already being put to use to support women researchers at the ANU to go to conferences and the like and pursue their incredibly important work. I know that the ABCF will achieve many great breakthroughs and changes for the lives of people suffering with brain cancer.
I give the call to the member for Braddon.
Thanks, Deputy Speaker. In Queenstown on Tasmania's rugged west coast, they're so tough they play footy on gravel, not grass. The football ground is actually gravel. And they have a reputation, it has a reputation of being the most feared ground in Australia. The home of the mighty Queenstown Crows. This year the Crows raised the trophy at the Darwin Football Association 24 Premiers. Unless you live in the bush, unless you live in that region, you can't comprehend how important our sporting clubs are to our valuable communities. And you wouldn't know that often these communities rely on just one or two industries to keep them going. If they lose one, then it's simply devastating, and that's what's happening on the West Coast. Because the Albanese government refuses to support the two key industries in their region, mining and agriculture. Since day one, Labor has refused to make a decision on MMG's tailing facility at South Marionake. They've done everything they can to shut down Macquarie Harbour and the agricultural industry. I promise the West Coast that a Liberal government will do whatever it takes to ensure the ongoing viabilities of these two valuable industries, because unlike Labor, we get what communities need. We understand how important they are. And welcome to those from Keep the Sheep up there in the gallery. Out of my Burnie Port, 843,000 fat lambs live to Victoria each year. So well done on your efforts today. Good to see you.
Yeah. Member for Solomon.
Thanks, Deputy Speaker. I present the voice of a young Territorian to Parliament, and I quote, "Hello, my name is Sienna and I'm 16 years old from Darwin. As a South Sea Islander Australian, not many people know about us, and when my dad organised the first event in Darwin for the 30th anniversary of our recognition, I was proud and happy to celebrate my heritage. But I also realised that the history of our people and what happened to them is something I know very little about. All I know is that our ancestors were taken from Vanuatu during the blackbirding. I find it hard to connect to something that isn't talked about, including my ancestry. I believe all Australians need to learn about our history and what we've contributed. If they did, it would help me and the other South Sea Islander people connect to our roots and be proud of who we are. I hope one day I'll be able to go to Vanuatu and connect with my family from there to learn more about where we come from and our history. I'm asking Parliament to raise awareness about Australian South Sea Islander heritage." End quote. So thanks very much, Sienna, and I'm glad that I could give voice for you to our federal parliament today. And well done to your father, Patrick, who organised a fantastic event to commemorate 30 years ago when Paul Keating, as Prime Minister, said that South Sea Islanders are a separate cultural group.
Times by member for Bowman.
Since the October 7 attacks, the government has granted at least 3,000 visas to Palestinians, mostly visitor visas. On average, these approvals have been completed within a single day, in some instances within an hour. While this government is issuing tourist visas to Gazans as quickly as they can be emailed, my office is being inundated with requests for support from Australians who cannot have their family members visit them due to overzealous rejections. A respected Lebanese Australian business owner in my electorate employs 40 staff. While the partner visa of his new wife has been assessed over the next 2 to 3 years, the government has rejected her tourist visa applications. A beloved local couple of South African origin have been left heartbroken after their son's tourist visa has been rejected despite multiple prior visits to Australia without incident. When the nuns of the Carmelite monastery in Ormiston sought to bring a couple of their Thai sisters to visit as part of a long-standing cultural exchange program, these applications were twice rejected. So we have a situation where the Sisters of the Carmelite Order are deemed to carry too much risk by this government, yet for those coming from a terrorist-controlled war zone, we are seeing thousands of tourist visas approved, in some cases within an hour. What an absolute joke. This unfair and inconsistent approach is putting Australia's security at risk. And more importantly, of course, or just as importantly, it's insulting the hard-working Australians who happen to have family members or other connections overseas.
Member for Bennelong.
Deputy Speaker, recently I visited Cressy Road Early Learning Centre in Bennelong. It was a joy to spend time with the children and their teachers who were full of energy and creativity. And the highlight of my visit, Deputy Speaker, was receiving this wonderful tie that they painted and gave me. I promised them I'd wear it in Parliament today to show how thankful I am. The children and educators gave me this gift because they wanted to say thank you to the government for the work we've done in early childhood education in only 2 and a bit years in office. In our first budget, we made early childhood education cheaper, delivering cheaper fees for families across Bennelong and the country. And then, of course, most recently, we've delivered a 15% pay rise to our early childhood educators. On this side of the House, we believe that these educators are some of the most important workers in our country. They deserve more than thanks. They deserve a pay rise. Our reforms will mean that the average educator will be paid an extra $103 a week, increasing to $155 per week at the end of 2025. It'll mean that people won't need to leave the sector for better pay. It'll mean that early educators will be able to afford to buy or rent a bigger place to live, and it'll mean that the sector will be able to find more workers to teach our children. Pay rises change lives. Early education changes lives, and we are a government that was elected to get wages moving again, and we're doing just that.
Member for Deakin.
Well, Labor's housing crisis is just getting worse. In Australia, we've seen under Labor's watch fewer homes being built. We've seen fewer homes being approved. We see less first-home buyers. But what has been the response from those opposite? Well, we're spending $32 billion on housing. We now find out that of that so-called $32 billion of money allocated to housing, only 1/10 of that has been directed to anything that would increase housing stock. And of that, we're not even sure if even $1 of that has gone into building a new home. The government can't even confirm if a new home has been built. No wonder we have seen the housing crisis in Australia getting worse. Rentals and those renting have seen their rents increase by 22% since this government came into power. And what is the grand strategy of this government? Increase migration to 1 million people over the first 2 years whilst we're building fewer homes. Australians know that the reason why they are facing higher rents, why fewer Australians are able to get into their first home, and why affordability is worse for Australians is because of the woeful performance of this government, and they have absolutely no answers, no new ideas, no money, and that's why the housing crisis will just get worse until we throw this government out.
Mr Speaker, I had the opportunity to host the Minister for Health and Aged Care, the Honourable Mark Butler, in Aston last week, announcing 7 additional Medicare urgent care clinics across Victoria. After 9 long years of cuts and neglect under the Liberals and Nationals, the Albanese Labor government is working to deliver a stronger healthcare system for all Australians. That is why I'm very excited that we now have a bulk-billed Medicare urgent care clinic in Bayswater. This clinic is open 7 days a week with extended hours for all those times you need urgent but not life-threatening care from a nurse or doctor without the need to visit an emergency department. In the 2024-25 budget, the Albanese government provided $227 million to expand the Medicare urgent care clinic program. The 7 existing state-funded priority primary care centres will transition to the Albanese government's Medicare urgent care clinic network following a request from the Victorian government. The urgent care clinic clinic in Bayswater will reduce the number of attendances to local EDs. This is great news for Maroondah Hospital, where a third of presentations to the emergency room are for non-urgent and semi-urgent issues. Located at Mountain High Shopping Centre, 7 to 13 High Street, Bayswater, the Maroondah Medicare Urgent Care Clinic is open 8 a.m. to 10 p.m. every day for people in my community.
Member for Groom.
Thank you very much, Speaker. It was an absolute privilege to go out the front of the lawns of Parliament House and listen to the concerns of farmers who'd gathered there, some who are here with us in the gallery here today, to hear their concerns about the policies that this government have enacted that have made their lives worse. It's been 40 years since the farmers have had to come down and rally around this place, but we're back in that same place again. And I was very proud to stand with the Leader of the Opposition, Peter Dutton, as he stood up and he confirmed we'll continue listening to farmers, and he gave our commitment to continue to support them. It was great to stand next to the Leader of the Nationals, who stood by his record as Agriculture Minister, and we will continue to do that. And on a number of issues, on live sheep exports, on biosecurity taxes, on water buybacks, we are there for regional Australia, for the agricultural community. But you know who wasn't there, Speaker? Do you know who wasn't there out the front of Parliament House? Our Prime Minister. Our Prime Minister was not there listening to the concerns of the agricultural industry, not a single member of the Labor Party. They can get a bit agitated now, but they couldn't get agitated enough to go out and listen to Australians. Loves to go to Beef Week, put on the Yellowstone cosplay, the hat, the RMs, pretend for the photo shoot that he understands regional Australia, but when it comes to listening to your concerns, he is not there. He and the Greens are giving you a preview of what the next government will look like. A minority government led by Green principles, a Labor Party that refuses to listen to the agricultural sector.
Time's expired. Member for Hawke has the call.
Thank you, Deputy Speaker. The Albanese Labor government is getting on with the things that matter. Boosting wages, cutting taxes and bringing inflation under control. Working Australians have always been able to count on a Labor government to champion their rights, secure better conditions and fight for fairer pay. We're funding a 15% wage increase for early childhood education workers and care workers to ensure that this benefits both workers and families. Services receiving this increase will cap their fees, lifting wages while lowering costs for parents. We're also strengthening protections for workers by closing loopholes that allow for underpayment and unfair practices. We've introduced world-leading minimum workplace standards for gig workers on digital platforms such as rideshare drivers and food delivery riders, because everyone has a right to stability no matter where they work. Our focus has always been on real wage growth for those that need it most, unlike the opposition who never once argued for a real wage increase while they were in charge of Australia. We're delivering wage rises. We're delivering tax cuts for every taxpayer. Labor will always fight for working Australians. We want Australians to earn more and keep more of what they earn.
Order. The member for Wright. In accordance with Standing Order 43, the time for members' statements has concluded. If members can take their seats as quickly and as quietly as possible, I'll call the Prime Minister.
Thanks, Mr Speaker. I inform the House the Minister for Health and Aged Care will be absent from question time today, and the Minister for Infrastructure, Transport, Regional Development and Local Government will answer questions on his behalf.
Move to questions without notice. Are there any questions? I give the call to the Honourable, the Leader of the Opposition.
Thank you very much, Mr Speaker. My question is to the Prime Minister. The Coalition announced in June our plan to stop young children from gaining access to harmful social media content. The Prime Minister has been incapable of taking action on this important issue for months. Yesterday, Premier Malinowskis said he'd had enough of waiting for the Prime Minister to make a decision. Now, today, in a rushed and ham-fisted way, the government's made a partial announcement of a policy without detail.
Just the Leader of the Opposition will pause. There is far too much noise. I cannot hear the question. The Leader of the Opposition will give him the courtesy of beginning his question again.
Thank you, Mr Speaker. My question is to the Prime Minister. The Coalition announced in June our plan to stop young children from gaining access to harmful social media content. The Prime Minister has been incapable of taking action on this important issue for months. Yesterday, Premier Malinowskis said he'd had enough of waiting for the Prime Minister to make a decision. Now, today, in a rushed and ham-fisted way, the government has made a partial announcement of a policy without detail. Why is the Albanese government hopeless at everything?
Order. Members on my right. The Minister for Climate Change and Energy. Order. The Member for Hunter. The Treasurer. The Prime Minister has the call.
Mr. Speaker, in the question the Leader of the Opposition has just asked, he lied about Peter Malinauskas. He did not say that. He did not say that.
Just going to get order. I'm just going to get the Prime Minister to withdraw that part of his answer.
The alleged quote from Peter Malinauskas,
Order.
the Premier,
Order.
the Premier of South Australia.
We're just going to get the Prime Minister to withdraw.
I'll withdraw.
Yeah.
The alleged quote in the question, so thought through in the question from the Premier of South Australia, Peter Malinauskas, was just not true. I've been working with the Premiers and Chief Ministers. The Premier...
Order. The Leader of the Opposition has asked his question. No, the Leader of the Opposition has asked his question. Order. There is far too much noise. We're not starting the day with that level of interjections from the Leader of the Opposition down. We are going to handle this matter with respect. Has the Prime Minister concluded his answer? The Prime Minister will be heard in silence for the remainder of the answer.
Thanks, Mr. Speaker. The Leader of the Opposition's angry rant rather than question about a new minimum age for access to social media that my government has announced that we will introduce legislation by the end of the year, that we have in our May budget funded the trial of age verification technology to make sure that we actually get this right. You need to trial the technology. This is something that has been a scourge of young people in particular throughout the Western world. It is something that governments are grappling with throughout the Western world, because we know that too often social media isn't social at all. This is about giving children a childhood and giving parents peace of mind. And I want young Australians to grow up playing outside with their friends, off their phones, and onto the footy fields and the netball courts. That's what I want, and that's what parents want as well. And I find it extraordinary that those opposite come in here on an issue like this and seek to yell and rant angrily, but that characterises everything they're about. And when it comes to detail, from an opposition that want nuclear reactors around Australia with no costings, no plan for how they actually would occur, just saying that they will be...
Order. The Leader of the Nationals, just everyone cool it. Yeah. Prime Minister, in continuation.
Thanks, Mr. Speaker. Setting a new national minimum age for social media will support parents and teachers. We all know that technology moves fast and some will try to find their ways around these laws, which is why we need to get it right. None of that is an excuse for inaction. That's why my government will introduce legislation into this Parliament this year.
Has concluded. The call to the honourable member for Macarthur.
Thank you, Mr. Speaker. My question is to the Minister for Communications. Parents in my community are telling me they are worried about the harms children are experiencing online. How will the Albanese Labor government's proposed minimum age for social media help protect young people and support parents?
Give the call to the Minister for Communications.
Thank you, Mr Speaker, and I particularly acknowledge the member for Macarthur as someone who has been involved in children's health his whole life, because the safety and mental health of our children is paramount. And we know that interacting online can be a great way for children to connect, to learn about their world and develop skills for the future. But we also know from the research that social media and unfettered content that exists across many of these platforms can cause harms, and they can affect mental health, healthy body image. There can be unsolicited contact from strangers, some at the most extreme and concerning for all of us. Parents are looking for real solutions to what is a legitimate national concern about harmful online environments and addictive behaviour on social media for children. So, Mr Speaker, the Commonwealth is providing national leadership to ensure children are better protected from online harms and that parents are supported. And our government will introduce legislation this year to enforce a minimum age for access to social media and other relevant digital platforms. Now, as the Prime Minister said, we know that technology moves fast, but we have to do all that we can to protect children in this area. And legislation on this issue will be informed by engagement with National Cabinet, engagement with the E-Safety Commissioner, and draw on recent work by former Chief Justice French. And this builds on the Albanese government's age assurance trial, testing technologies and implementation approaches that will inform our policy design. It's an important step towards ensuring that all Australian children can use the internet in an age-appropriate way that supports them, supports their learning and their positive development. Now, Mr Speaker, in my home state of New South Wales, mobile phones have been banned in schools. And the feedback from teachers has been very positive. Children are playing more, you can hear more noise and chatter in the playground because they're not spending that time absorbed on their phones. The government has been prepared to do our share, and we have, in our first term, done more to act on the social, economic and harms to democracy than any other government in the last 10 years. We've taken decisive action on a number of fronts to minimise online harms and concerns around social media, including bringing forward the review of the Online Safety Act by 12 months, amending the basic online safety expectations so that platforms must place the best interests of the child at the centre of their products and services. We funded joint digital literacy programs in every school in partnership with the Alana and Madeline Foundation, and we quadrupled ongoing base funding for the E-Safety Commissioner to do their important work. Fundamentally, as we develop the legislative approach, we will focus on ensuring government is not telling parents how to raise children, but we expect platforms and online services to do their fair share because this burden or responsibility doesn't just rest with parents.
Concluded. Give the call to the honourable member for Banks.
Thank you, Mr Speaker. My question is to the Prime Minister. The Prime Minister announced in May that the government would fund a trial of age verification for children accessing social media. Can the Prime Minister confirm that the trial has not started and that the tender document for the technical trial was issued today?
Order. Members on my left. Order. The Deputy Leader of the Opposition. The member for Fisher. No interjections before any answer begins. The Prime Minister has the call.
Thanks, Mr Speaker. There were 3 stages in the preparation of this. The first 2 stages are done. This is stage 3 of issuing the contract to make sure...
Order. The Leader of the Opposition.
To make sure that it's got right.
The Attorney General.
Those opposite...
Order. Just... Order. Look, members on my right, it works 2 ways. There's far too much interjection. Yelling is not going to help me hear the answer. So everyone take a lesson. If it continues on, there'll just be a general warning and people aren't going to remain here for question time today. Prime Minister has the call. Order. We'll move. Order. Has the Prime Minister concluded his answer? No. Just there'll be silence for the remainder of the answer. The Prime Minister has the call.
Thanks, Mr Speaker. The government funded this trial in our May budget. The Minister and the Department have been working through the first two stages, the third stage, to make sure that the tender, you need to know what you're putting a tender out for to make sure the technology has got right. We've also been cooperating, of course, with the E-Safety Commissioner, a body for which we quadrupled funding, quadrupled. Now, social media has a social responsibility to have its social licence, and we want to make sure, arising out of this age verification, that we're able to move forward in a way which no country in the world has been able to solve this problem. We are seeking to be the best in the world, and that is why you have to actually get it right, not fund a car park where there's no train station. Make sure you actually get it right. And I'm surprised that those opposite seek to make this a partisan issue, because I think this is an issue. This is an issue which is of concern for all parents, because social media is causing social...
The Deputy Leader of the Opposition, for the remainder of this answer, so listen carefully, there'll be no more interjections from you just for the remainder of this answer, because I want to hear the answer.
Social media is causing social harm. It can be used as a weapon for bullies, a vehicle for scammers, worst of all, a tool for online predators. And that is why we are ensuring that we will get the legislation right. I've said as part of the announcement that we will consult across the Parliament, because I don't think this should be an issue in which we are yelling at each other. I think this is an issue in which we should be yelling at social media companies to do the right thing. And that is what I seek, and I hope that the Parliament has the maturity to do that.
Order.
9 years.
The Leader of the Opposition. The Leader of the Opposition. This is just order. The Treasurer. This is a serious issue, and we need to do better. So I'm asking everyone in the House to show some restraint, ask questions respectfully, and listen to the questions respectfully as well. Prime Minister in continuation for 20 seconds.
Mr. Speaker, government may not be able to stop every threat on social media, but we do have a responsibility to do everything that we can to help as many young Australians as we can, and we can't let the perfect be the enemy of the good. This is a change that will change our country for the better. It follows our quadrupling of funding for the E-Safety Commissioner and the other work that we have done in this area. That's why we need a national response.
Call to the honourable member for Dunkley.
My question is to the Minister for Youth. What is the Albanese Labor government doing to keep children and young people safe online, including through its proposed minimum age for social media?
The member for Lindsay will leave the chamber under 94A. Continually interjecting like that and before the minister is highly disorderly. The Minister for Early Childhood Education and the Minister for Youth has the call.
Thank you, Mr. Speaker, and I thank the wonderful member for Dunkley for her question. Mr. Speaker, the safety and security of Australians is a priority for this government, as it should be, and that includes the safety and security of young people and children online. We know that social media can be used for good. There's no question about that. Now, as the Minister for Youth, I've heard from young people through our youth consultations and through our youth engagement program. In our survey of 4,600 young people, mental health featured second as their greatest concern. And young people tell me that while they value social media for the connectivity it affords them, they are also highly, highly attuned to the negative impacts it has on their mental health, on their social and physical well-being.
Social media is associated with poor mental health, with eating disorders, with depression, with anxiety, with self-harm, with cyberbullying, with poor sleep quality, among a plethora of other things. That social media is harmful to children and young people is not contentious. I think we can all agree on that. Young people know it, parents know it, teachers know it, youth workers know it, researchers know it, and we know it. We know it. And that's why we're doing something about it. This is a topic that is discussed at barbecues, it's discussed in the schoolyard, and it is discussed among young people themselves. The Albanese Labor government is going to introduce a minimum age for access to social media and gaming platforms. And we know we need to get this right. We need to bring children, we need to bring young people and parents along with us on this journey. But there is work already underway. In May, we announced funding for an age assurance trial exploring age verification technologies to protect children from being exposed to harmful online content. And I've been working with the Minister for Communications, Minister Rowland, to ensure that young people are engaged in the development of that trial. We're also making sure young people and families have the tools to use social media safely through initiatives like the digital literacy programs in schools, through a partnership with the Alana and Madeline Foundation. We've quadrupled funding to the e-Safety Commissioner, making sure that that commission has what it needs to keep Australians safe online. Mr Speaker, children deserve a childhood. They deserve a childhood free from the harms that, unfortunately, social media brings with it. They deserve a childhood where they can play freely, where they can grow up with a strong identity and a strong sense of belonging. A childhood free from bullying, free from anxiety and free from depression. We want to ensure that children in Australia get that childhood.
Before I call the honourable member for Calare, I'll just do some acknowledgements. I'm pleased to inform the House that present in the gallery today is Mr Michael Kemp MP, New South Wales State Member for Oxley, as a guest of the member for Cowper, and also the Honourable Mia Davies, Member for Central Wheatbelt in the Western Australian Legislative Assembly. Welcome to you both. Give the call to the Honourable Member for Calare.
To the Prime Minister. The decision by the Minister for the Environment and Water to make a Section 10 declaration over the McPhillamys mine project near Blaney has been met with widespread shock, anger and concern in our local area. These concerns include a lack of transparency, lost jobs, the timing of the decision with state and federal environmental approvals already given, the contrary opinion of Orange Local Aboriginal Land Council and the impossibility of moving the dam within existing mine boundaries. Will you meet with me to discuss this, and will you now consider reversing this decision?
Give the call to the Prime Minister.
Thank you. My door's open to every member of the House of Representatives, as the member for Calare knows, as other members here know as well, including members on both sides of the chamber. The question as to the detail, though, under the way that the EPBC Act operates, of course, the Minister has responsibility, and I'll ask her to respond to the question.
Good. And the Minister for the Environment and Water has the call.
Thanks so much, Mr Speaker, and I want to thank the member for Calare for his question. I've got a lot of respect for the member for Calare, and he has indeed been to my office to discuss this project with me, and he brought with him Scott Ferguson, the Mayor of Blaney, and I was very pleased to meet with the Mayor of Blaney as well. Mr Speaker, I understand that the company in question want the cheapest, most cost-effective option for the building of their tailings dam. That's them doing their job for shareholders. Me doing my job for the Parliament and the people of Australia is applying the law on the basis of the evidence before me. There were people who wanted to stop this whole project. There were people who wanted to go ahead completely unchanged. I haven't taken either of those courses. What I've said is that the tailings dam can't be built on the headwaters and springs of the Belubula River, and that if the company want to come back with an alternate design, they've told me they've looked at 4 sites, they've told me that they've looked at 30 different design options, they can do that. This is a 2,500 hectare site, and my Section 10 declaration applies to 400 hectares of that 2,500 hectares. That's about 16% of the existing site. So I haven't blocked the mine. My decision protects the headwaters and the springs of the Belubula River. Just incidentally, I would say to the House, I've actually ticked off more than 40 mining projects. This is not about a mining project. It's about making sure that when we tick off on mining projects, that they do have all of the necessary approvals based on the evidence in front of me as the decision maker. What I certainly wouldn't do is do what those opposites seem to be doing, which is saying we don't need to look at the evidence, we don't need to read the reports, we don't need to hear from the experts. We're just going to tick it off because we like the look of it. That is not the way to make decisions, and it's exactly that attitude that led to the problems that those opposite had with robo-debt, car park rorts, sports rorts, secret ministries, au pair visa scandals, Origin 360, the Leppington Triangle, Jamlands, the visa privatisation scandal. I mean, the list goes on and on. What people want is consistency.
Concluded. Give the call to the member for Macquarie.
Thank you, Speaker. My question's to the Prime Minister. How will the Albanese Labor government's proposal for a national minimum age for social media protect children, help parents and teachers and change our country for the better?
Give the call to the Prime Minister.
The member for Macquarie for her question. And indeed, this is about giving children a childhood and giving parents peace of mind. This is an important reform whose time has come. What we have done here is to engage with the E-Safety Commissioner, engage with our department to make sure that we can make a difference for the legislation that we want to introduce into Parliament this year so that it can become the law of the land. Now, many parents and others can already, of course, make decisions about their families to restrict their access to social media or indeed to restrict their access to devices. But by making a national law, it will assist them because we know that peer group pressure is really important for young people at that age. We know that a decision of a national minimum age will support parents and will support teachers because the banning of mobile phones in schools when it's been implemented by state governments has received extraordinary support. The state governments are, of course, out there campaigning as well, and we had a discussion about this at National Cabinet on Friday. I welcome the fact that the Premier, Malinowskis, had the former Chief Justice of the High Court, Justice French, to do a 276-page report, and we discussed making sure that there is a national approach so that we don't end up with different approaches across different states, and that's been welcomed by Premier Malinowskis. And indeed, I quote, I table his media release of today, Premier welcomes national support for social media ban for children. This is an issue, of course, that does cross state borders. Social media does have a social responsibility and it needs a social licence in order to operate as well. Some people have said that it will be difficult because people can change with VPN numbers have escalated in places like the United States where this has been tried, which is why we need to make sure that we absolutely get it right. That's why you do a trial which is funded in the May budget to make sure that we get it right. You do the research, you do the work, and then you can have the legislation and create the law to protect our children.
Give the call to the Leader of the Nationals.
Thank you, Mr Speaker. My question is to the Prime Minister. In the gallery today are farmers whose livelihoods depend on the live sheep export industry. If the government continues with its ban on live sheep exports, Sudan is one country that will take up Australia's share of this market. Prime Minister, who has higher animal welfare standards, Sudan or Australia?
Go to the Prime Minister.
I thank the Leader of the National Party for his question, and I met with the leadership of the National Farmers Federation once again earlier this morning to discuss this issue, just as I have had constructive discussions with sheep farmers here in Canberra and with their families in Kalgoorlie. One of the things that I pointed out was that when the Leader of the National Party came into government in the first year, in 2014-15, 2.1 million sheep were exported by sea at a value of $224 million. In the last year, in which they held office, there were 475,000 sheep were exported by sea at a value of $80 million. Over the decade the Liberals and Nationals were in government, live sheep exports by sea decreased by over 1.5 million head. That is just a fact of what occurred. At the same time, exports of sheep meat have escalated to some $4 billion of value. So,
Order. The member for Hume. I'll take a point of order from the Leader of the Nationals.
Relevance, Mr Speaker. It's a very tight question about who had higher animal welfare standards, Sudan or Australia. We're a minute and a half in. I would ask, Mr Speaker, for your ruling. Is the Prime Minister being relevant?
Yeah, I understand your point of order, and I appreciate that that's the question that you're seeking an answer for, but you did also... No, well, if you're talking about live sheep export and you're talking about the government's position on what they've done about that issue, you didn't simply just ask the question about Sudan, you had a preamble there. So whilst the Prime Minister is able to talk order, yeah, but he's being directly relevant. So we just need to make sure the Leader of the House...
Mr Speaker, just with rulings you've given previously, with respect to when you're actually making a ruling, respect completely members will come to the dispatch box and raise a point of order, but the constant arguing back from the Leader of the Nationals on something as simple as the relevance rule, where everybody in the room knows this ruling has been given before, it's just absurd.
Disrespectful to the chair.
Well, what I try and do is when people are on their feet and raising a point of order, I show them respect by listening carefully to what they say. I simply ask that the same be shown to me. Prime Minister in continuation.
Thanks, Mr Speaker. Australia's lamb and mutton exports were worth $4.5 billion in 2022-23. They're escalating in places like the UK. We have, hopefully we'll have an announcement soon about an agreement with the UAE, whereas live sheep exports by sea were less than $77 million in that first year. Less than 0.1% of Australia's estimated agricultural production in that year. We're giving certainty to sheep producers and the supply chain by legislating the phase-out and investing.
Sorry? Order. I'm just going to ask everyone to remain silent for the remainder of this answer. The Prime Minister has the call.
We're giving certainty to sheep producers and the supply chain by legislating the phase-out. We're investing $107 million to support an orderly and well-planned transition away from what is an already declining trade. That is how you provide support for people. Those opposite know that this trade will not resume. They know that it's been passed by the House of Representatives and the Senate, and they are playing politics rather than rather than delivering.
The Leader of the Nationals has submitted the MPI today. He may have forgotten about it, but I haven't. So, I assume he wants to debate the topic that he raised, which is making noise about. So he can do that after question time. He'll have that right, but that's only going to be extended if he ceases interjecting for the remainder of question time. Member for Spence has the call.
Thank you, Mr Speaker. My question is to the Minister for Veteran Affairs and Defence Personnel. As we mark World Suicide Prevention Day, why is swift action on the Royal Commission into Defence and Veteran Suicide report important?
Call to the Minister for Veterans Affairs and the Minister for Defence Personnel.
Thank you, Speaker, and I thank the member for Spence for his very important question, and I recognise his advocacy for the veterans in his community and acknowledge his service in our Australian Defence Force. This morning I joined Lifeline and my colleagues, the member for Cooper and Senator Stewart, at the Out of the Shadows walk to remember those lost to suicide and reflect on the work ahead. Veteran suicide is a national tragedy. That's why we supported the establishment of the Royal Commission into Defence and Veteran Suicide. The Australian Institute of Health and Welfare has confirmed some 1,677 known cases of suicide amongst serving and ex-serving personnel between 1997 and 2021. Some 3 years and thousands of submissions later, the Royal Commission has handed down their final report. It's the culmination of the most significant inquiry conducted into suicide and suicidality in our defence and veteran communities. The Royal Commission and all of us have heard the harrowing stories of serving members, former serving members and the family members of those who have taken their own lives. The report is comprehensive. It is some 7 volumes long, containing over 3,100 pages and 122 recommendations. We're already putting the work in to properly understand and consider the recommendations and the detail behind them. It is incumbent on all of us, government, defence, the ADF, the Department of Veterans Affairs, to take the action necessary to identify and combat the drivers of suicide and suicidality in our defence and veteran community. We moved swiftly when we received the Royal Commission's interim report, taking action on all 13 of its recommendations. We recognise the urgency of the recommendations in this final report and will move swiftly to develop the government's response. I want to thank everyone who helped campaign for and who has contributed to the Royal Commission for their bravery in sharing their often harrowing stories about their own experience in service and those who have given a voice to loved ones no longer able to share their own story. I thank also the Commissioners for their important and sensitive work. One death is one too many. We must do what we can as quickly as we can to prevent suicide across our defence and veteran community. For those who require support, please reach out to Open Arms on 1800 011 046.
On indulgence, the member for New England.
Thank you very much, Mr Speaker. And on indulgence, I'd like to concur with the remarks of the Minister for Veterans Affairs and note the Coalition's willingness to expedite the process as quickly as we can. I don't think there's any person in this House who wants to see one other person harm themselves, and it is incumbent upon all of us. We all wear the responsibility of where this has come to, and we all wear the responsibility of finding as best we can some resolve, but not for 1 second holding up a panacea that what we will do will fix everything up, but we will do our utmost. Might I say in conclusion, it is an incredible thing that some people sign on the dotted line knowing full well that they may get the order that brings an end to their life. And a culture that asks of that is a culture that is sometimes a hard thing to rewind from. We understand that, and we acknowledge that the esprit de corps that is part of the Defence Force also relates to the huge loss that so many families have when they ask us for so much, but really we know deep in their hearts what they really want is their mother or their father or their brother or their sister or their son and their daughter back, and that is one thing our chamber can tragically not be able to provide to them.
Call to the member for
Just to the Prime Minister. Prime Minister, today thousands of farmers from around Australia have travelled to Canberra railing against Labor's decision to ban live sheep exports and other anti-farming policies. And after 2 years of bad regulation, ideological rhetoric and job-killing policies, it has been reported that the mining industry, representing 10% of GDP, took the Prime Minister's Mineral Week speech as a declaration of war. Can the Prime Minister explain why he is fixated on policies that hurt West Australia, risk jobs and make life harder for families and businesses in my state?
Order. Give the call to the Prime Minister.
Thanks, Mr Speaker. That's a very broad question from the member for O'Connor, whose electorate I was in just last week. There in Collie, the place where there is going to be a nuclear reactor sometime in the 2040s or 2050s, if those opposite are to be believed. We are yet to have any costings. We're yet to have a process, but that is what they say. And of course, Collie used to be for a long time a place where coal mining and through the coal-fired power station was a major generator of jobs and economic activity. But that is a region that is in transition. And what is happening is that government is working with the private sector, including the resources sector, on that transition. And there you can see on the site of right next to the power station there, 500 people at work building a big battery that will store enough energy for 860,000 homes.
Look, Prime Minister will pause. It's going to be very tough for you to take a point of order on relevance, so I'm giving you some... No, let me finish. Before I call them, you'll get the call if you choose to take it, but if you ask a broad question with all the topics in that question, and the Prime Minister is talking about energy, mining, directly about Western Australia, which you asked about, it'll have to be a different point of order relevance. So you'll get the call. Member for O'Connor.
Well, it is a point of order on relevance. The question was about live sheep exports and the mining industry, not about energy.
Order. I'll ensure that the Prime Minister remains directly relevant, which he is doing at the moment. Prime Minister has the call.
Mr Speaker, that is an area that is in transition, successfully. And just as some farming practices will change as well, successfully. And I have faith in our farmers and I have faith in our resources sector. Now, when it comes to farmers, what we have done is we have, firstly, restored trade relationships on cotton, timber, oat and hay, barley and wine. Pretty close between the resources sector and the farming sector, $20 billion of additional trade and exports that were gone prior to us being in government. We've delivered $1.1 billion for connectivity plan for regional and rural Australia. Australia's red meat exporters are hitting record highs, with emerging markets accounting for unprecedented demand for locally processed beef and lamb. And might I say that this includes the live cattle industry that has been very successful, that those opposite wanted to shut down. Those opposite called for the border to Indonesia to be shut down. That is what they called for. We've rescued biosecurity by pumping in $1 billion to protect industry from pests and disease while improving traceability. We are working to support our agriculture sector and our resources sector.
Order. Member for Bennelong has the call.
Thank you, Speaker. My question is to the Treasurer. How is the Albanese Labor government reforming and strengthening Australia's economic institutions, and are there any obstacles?
Give a call to the Treasurer.
Thanks, Mr Speaker, and to the member for Bennelong for the way that he engages in a considered way the big issues in our economy. Mr Speaker, the RBA legislation, the Reserve Bank legislation before the House, is all about modernising our central bank, strengthening its decision-making and making it more independent, not less independent. It seeks to implement the considered recommendations of the review, which reported about 1.5 years ago and which has been in the public domain for a long time now, the subject of a lot of welcome discussion and debate. Now, the Reserve Bank Governor herself is 100% behind the changes and has said she wants to see them legislated. And I want to thank her for her efforts working with the government to bed down the changes that have already been implemented. Now, Mr Speaker, as those opposites interject, I want to read to them a quote from a big supporter of the changes to the Reserve Bank, and I quote, "The recommendations of the review will clarify the Reserve Bank's monetary policy role, strengthen its governance arrangements, improve the transparency of its decision-making and deepen its economic expertise. It is essential the implementation of the review be as bipartisan as possible." Mr Speaker, that's what the Shadow Treasurer said about the recommendations of the review, and now he says he's going to vote against it. Now, I have tried to work with the Shadow Treasurer to implement the changes in a bipartisan way.
The Treasurer will pause. The member for Hume, just yelling non-stop, just continuously, all throughout question time. You're not helping. You're showing disrespect, so you leave the chamber under 94A. Treasurer has the call.
Thanks, Mr Speaker. I've tried to work with the Shadow Treasurer in a bipartisan way. I have accommodated every single one of the 6 issues that he raised with me. I have accommodated every single one of the concerns that he raised with me by making sensible changes to what had originally been proposed. I met with him, I arranged briefings for him, I engaged with him genuinely and respectfully, publicly and privately on this really important matter. And that's because my preference was and continues to be a bipartisan agreement between the major parties. I say respectfully I'd rather not deal with the crossbench in the Senate because I want these changes to endure any future changes in government. And that's why, Mr Speaker, I tried to take the Shadow Treasurer seriously, even if his colleagues don't. And unfortunately, all along in this process, we have been hostage to the Shadow Treasurer's ability to carry an argument internally in his show, Mr Speaker. He's been unable to do that. And so again, if the House listens closely, they will hear the familiar sound of the Shadow Treasurer getting rolled once again, Mr Speaker. And the decision that they've announced today is irresponsible, it creates uncertainty, it's disappointing, but it's not surprising, because this is what happens when the opposition leader's destructive negativity collides with the Shadow Treasurer's weakness. This is why they have no credibility on the economy, Mr Speaker. They're always looking for unnecessary conflict to distract from the fact that they have no credible or costed economic policies, and they won't tell us where $315 billion in cuts are going to come from.
Call to the Manager of Opposition Business.
My question is to the Treasurer. Last week's national accounts data reveals the economy has shuddered to a halt, productivity is going backwards, real disposable income has collapsed, and Australians are paying more tax and more for their mortgages. RMIT economics professor Sinclair Davidson has said, quotes, "All the economic indicators are going the wrong way, and what is the government doing? Fighting with the RBA. Having created a disaster for Australian families, why is the Albanese Labor government fighting the Reserve Bank while Australian families go backwards?"
Call to the Treasurer.
Well, I thank the honourable member for asking the question the Shadow Treasurer was supposed to be asking before he got turfed out a few moments ago. Mr. Speaker, the question goes to the pressures that people are feeling in our economy right now, and we acknowledge them, but more than acknowledge them, we are doing something about it. And it beggars belief in the context of an economy which is slowing considerably, and an economy where people are under considerable cost of living pressure. It beggars belief that those opposite oppose our cost of living relief for people who are doing it tough. They've said they want to roll back the tax cuts. They've said they don't support helping people with their energy bills. They've said they don't support cheaper medicines or cheaper early childhood education. They've said that they don't support rent assistance. They obviously don't support getting wages moving again, Mr. Speaker, because they deliberately presided over a decade of wage stagnation and wage suppression. And so we won't be taking lectures, Mr. Speaker, from those opposite on responsible economic management. When we came to office, inflation was much higher and rising. It had a 6 in front of it. It now has a 3 in front of it. When we came to office, those opposite had presided over the worst decade for productivity growth in the last 60 years. When we came to office, there were huge deficits, and we turned 2 of those deficits into substantial labour surpluses. When we came to office, real wages were falling 3.4%, and they're growing again. When we came to office, nominal wages were stagnant. They're now growing, on average, almost twice as fast as they were under those opposite. That's a deliberate design feature of our economic policy, to get wages moving again so that people can earn more and keep more of what they earn, Mr. Speaker. But I think the thing that really goes to the difference between the big parties in the parliament when it comes to the economy and the pressures that people are feeling right around our country is that when we had an opportunity to give a tax cut to every single Australian taxpayer, we grabbed that opportunity because we know people are doing it tough right up and down the income scale. If those opposite had their way, only some people would be getting a tax cut, people who are doing better than others. If those opposite had their way, there'd be lower wages. If those opposite had their way, there would be no cost of living help for people doing it tough. And if those opposite had their way, Australia would be in recession right now. We know that. We know that because they gave us a lot of free advice about cutting harder and harsher in the budget. We didn't take that advice, and that's because we're going for a soft landing in our economy, and those opposite want a crash landing in our economy because they think it suits their political purposes, Mr. Speaker. Now, their time would be much better spent coming clean on the $315 billion in cuts, secret cuts, telling the Australian people what those hundreds of billions of dollars in cuts will mean for Medicare and pensions and an economy which is already soft.
Call to the member for Adelaide.
Thank you, Mr. Speaker. Mr. Speaker, my question is to the Minister for Housing and Homelessness. How is the Albanese Labor government helping Australians with the housing pressures they face, and is there anything standing in the way of further support?
Call to the Minister for Housing and the Minister for Homelessness.
I thank the member for Adelaide for his question, and this is a problem that I know he cares about very deeply, as I do and as my colleagues behind me do. Speaker, Australia is in a housing crisis which has been a generation in the making, and this is a problem that is today affecting the lives of millions of people around our country. Why do we have a housing crisis? Because over a period of decades, Thank you, Speaker. Over a period of decades, Australia has not been building enough homes. This is partly a failure of markets, but it's partly, too, Speaker, a failure of governments. And what we've seen really since the post-war period is the Commonwealth Government work further and further back from this problem. Speaker, if I can just give you an example, in the preceding decade before Labor came to office, we saw the Abbott, Turnbull, Morrison governments. For the majority of the period of that period of coalition government, there was no Commonwealth Housing Minister. There was no person in the Australian government responsible for this problem. Now, Speaker, unsurprisingly, this has changed under our government. Today, our country is led by a Prime Minister whose entire life trajectory was changed by his access to affordable housing in his childhood. And we have a $32 billion plan which is targeted at helping Australians manage these issues. Speaker, part of that plan is to build, build, build. We want to build 1.2 million homes working with the states over a 5-year period. Speaker, we've got to do more to help renters in our country, and that's why you've seen our government make two very large increases.
Member for Fadden will cease interjecting.
Speaker, that's why you've seen our government make increases to Commonwealth rent assistance and work with the states to improve renters' rights. And that's why, Speaker, we are making such an effort to help more Australians get into home ownership. Now, Speaker, I'm asked about whether there are any challenges to progress, and unsurprisingly, there are really serious challenges to progress, Speaker. We don't just have a broken housing market in this country, we have broken housing politics. What we have seen in the time that our government has been in power, in our successive attempts to make legislative change to address this crisis, that the Greens on the crossbench and the Liberals that sit opposite me have teamed up in this incredibly dysfunctional alliance to try to stop us addressing this important issue for Australians. Now, Speaker, we have two bills that are sitting in the Senate at the moment, blocked by these two political parties, which will help us resolve this crisis for Australians. One of them will help us build more rentals. Why would anyone in this country be opposed to the building of more rentals? One of the pieces of the bill will help us encourage more low and middle income Australians into home ownership. This is a bill being opposed by political parties in this parliament. Now, Speaker, I'd say to those who are gathered in the chamber here, all of our constituents are affected by this problem. We need to come into this parliament and do our jobs, and that means coming into the parliament and working with our government to help Australians address this significant problem in their lives.
Before I call the member for Clark, I'm pleased to inform the House that present in the gallery today are recipients of the School Plus 2024 Commonwealth Bank Teaching Awards, awarded in recognition of great teaching and leadership in schools across Australia. On behalf of all members, I congratulate you and wish you a warm welcome. Give the call to the member for Clark.
Speaker, my question is to the Prime Minister. Prime Minister, in defending the census debacle, the Deputy PM said, "We've seen how divisive debates have played out across our country, and the last thing we want to do is inflict that debate on a sector of our community right now." So, Prime Minister, if your government is so concerned about divisive debates, will you enact comprehensive vilification protections and appoint an LGBTIQA+ Human Rights Commissioner and an Equality Minister?
Call to the Prime Minister.
I thank the member for Clark for his question and for his long-standing advocacy for members of the LGBTQIA+ community. We value every Australian, and every Australian should be valued regardless of their sexual orientation or their identity. That is really important. In the development of the 2026 census, the ABS came to the government with potential changes it planned to trial, including changes it had not itself recommended for the census. We paused the process to make sure that we get it right, so that there weren't the sort of implications that were contained in the question by the member for Clark. The truth is that for many people, if they're marginalised in parts of Australian society, we don't want to add to that and to add to the pressure which is there. We engaged with the community and additional discussions with the ABS to make sure that we got the direction right, and I believe that we have, and that we can move forward in a way that doesn't have the unintended consequences that the Deputy Prime Minister was precisely talking about. I would say it's the responsibility of everyone in this parliament to engage in debate respectfully and not to inflame community tensions. Sadly, there are examples of us failing, of that test being failed. The government will be introducing legislation this week to create new criminal offences and strengthen protections against hate crimes. These offences will protect the community, including the LGBT community and other targeted groups, from the threat of force or violence and from those who would urge violence against them, which we know is only too real. Our government does support the work of the Australian Human Rights Commission. We already have in place a commission which works to ensure that human rights of all Australians, including those from the LGBTIQ+ community, are protected. and that is really important, and my government will continue to be committed to that and continue to work with the community towards that objective.
The call to the honourable member for Swan.
Thank you, Mr Speaker. My question is to the Minister for Climate Change and Energy. How is the Albanese Labor government lowering energy bills by delivering cost of living relief as well as delivering renewable energy backed up by batteries? What energy policies has the government rejected?
There's far too many interjections while the minister was rising to his feet. The Minister for Climate Change and Energy has the call.
Well, thanks very much, Mr Speaker. I thank my honourable friend, the fantastic member for Swan, for her question. And, Mr Speaker, as the member knows, this government's providing energy bill relief in a couple of ways. There's direct relief that was in the last budget, Mr Speaker, which is already flowing to Australian households, anybody who has an energy bill. But, of course, Mr Speaker, that comes at a cost of around $5 billion, which was included in the $315 billion of spending that the Finance Minister said she was against yesterday, Mr Speaker. So that gives us a pretty good idea about what the opposition thinks about direct relief for Australian households. But in addition, we have a plan to see, Mr Speaker, the cheapest form of energy, renewables, backed up by transmission, backed up by gas peaking for reliability and backed up by batteries. And last week, Mr Speaker, when I was in Gippsland, I was able to announce a big step forward for batteries in Australia, Mr Speaker, when I announced the support through the capacity investment scheme of 6 big batteries across South Australia and Victoria, including in the Gippsland, which will support 4 hours of storage for 1 million homes, 1 million houses across Victoria and South Australia, Mr Speaker.
And members on my left.
And of course, we were also in Perth, where we could announce the Western Australian Capacity Investment Scheme has been massively oversubscribed, which shows a strong pipeline of batteries in Western Australia, which builds on what's already happening. And the Prime Minister and I saw this firsthand when we spent Father's Day together down in Collie, Mr Speaker, seeing the progress that's already made. 2 big batteries under construction, one of which is enough for 20% of the energy needs of Western Australia, Mr Speaker. Just one battery, Mr Speaker. But this is what's happening today, and these batteries, the ones that are supported under the Capacity Investment Scheme, will be open by 2027, and the 2 Collie batteries will be open by 2025, not 2035, not 2050, 2025. Now, there are alternative plans for Collie, which the Prime Minister and I also heard about. The Prime Minister, the first Prime Minister to visit Collie in 40 years, and the only candidate for Prime Minister in the upcoming election to visit Collie this term, Mr Speaker. But we heard about the opposition's alternative plan as well. Now, we don't know when that will happen. The member for Fairfax said, oh, that'll be one of the early ones. And the Western Australian Senator Cash said that'll be one of the late ones, around 2050, so no details from the opposition. But we also know the opposition has said they won't use any more water than the existing coal-fired power stations will already use, which means they'll only get about 1.5 gigawatts from anything in Collie, which shows that even their plans to get just 4% of energy needs from nuclear will be underdone. This is what you get when you get a scheme thought up on the run with no details, compared with the detailed plans of the Albanese government, backed by the experts, for renewables, supported by batteries, supported by gas and supported by transmission, which delivers the lower... the member for Fairfax should be more mindful and more demure, Mr Speaker.
The House comes to order. We'll hear from the member for Menzies.
Thank you, Speaker. My question is to the Treasurer. Last week's national accounts data shows that under Labor, real disposable income has fallen by 8.7% on a per capita basis. Independent economist Warren Hogan said, quote, "We are going backwards in terms of our living standards." Having created a disaster for Australian families, why is the Albanese Labor government fighting the Reserve Bank while Australian families go backwards?
Call to the Treasurer.
Well, Mr Speaker, they got a lot of nerve asking about incomes, having opposed all of our efforts to get incomes moving again in this country after they presided over a decade of deliberate wage stagnation and wage suppression. And we know this because former Minister Matthias Cormann said the quiet bit out loud, and he said that Stagnant wages were a deliberate design feature of their economic policy architecture, and we take a different view. We take a different view when it comes to incomes. And our view is that we needed to get wages moving again in our economy, and we are pleased to see that that's happening. Because this side of the House is all about Australians earning more and keeping more of what they earn. And that's what we're on about, Mr Speaker. And that side of the House is all about screwing people down. It's all about blaming working people and the most vulnerable for our inflation challenge in our economy. It's all about screwing people down and denying them the tax cuts that they need and deserve to get by at a difficult time. Their approach is all about denying people a bit of help with their electricity bills. Their approach is about denying people a bit of help with early childhood education fees. It's about denying people cheaper medicines, and it's about denying people the wages growth that has been missing for too long in our economy, Mr Speaker. Now, if they want to ask about the national accounts, they should be up front and say that if we had taken their advice, Australia's economy would be in recession right now and people would be doing it even tougher. And I invite those opposite, and I invite the public beyond, to think about the consequences of their $315 billion in secret cuts and what that will mean for incomes and what that would mean for living standards and what that would mean for an economy which is already barely growing, Mr Speaker. Now, their time would be better spent explaining to the Australian people what those $315 billion in cuts are, what they mean for Medicare, what they mean for pensions and payments, and what they mean for an economy that we know has growth which is soft and subdued, Mr Speaker. Now, what we have done in the little over 2 years that we've been in office, having inherited much higher and rising inflation, having inherited deficits as far as the eye can see, having inherited real wages falling substantially, is we have worked diligently and collectively to try and turn things around, because we know, and as the Prime Minister said, that what really matters in the economy is how people are faring, and they would be doing it much tougher if those opposite had their way when it came to wages and when it came to cost of living relief. So they do have a lot of nerve, Mr Speaker, asking about living standards when they spend most of their time trying to deny people the decent wages and the cost of living relief that they need and deserve at a time when they're under pressure and growth in the economy is soft and subdued.
Give a call to the member for Bean.
Speaker, my question is to the Minister for the National Disability Insurance Scheme. What changes has the Albanese Labor government made to deliver better outcomes for participants and improve integrity in the NDIS?
Call to the Minister for the National Disability Insurance Scheme and the Minister for Government Services.
I thank the member for being, and as people may be aware, he represents Norfolk Island as well as Canberra. And before there was an NDIS, there were no disability services on Norfolk Island, and now nearly 50 people there receive NDIS support. They're part of more than 661,000 people who are receiving support from this vital scheme. I'm pleased to tell Australians listening to Question Time that there's been a marked increase in participation rates in community and social activities for those on the scheme. There's been a 10% increase from those who have been on the scheme more than 6 years. I'm also pleased to report that young participants between 15 and 24, there's more of them now in paid employment. And it's great also that over half of all families and carers, 52% of people, are reporting an increase in paid employment. Also, where it once took up to 100 days in many parts of Australia for a person with a disability on the NDIS fit for discharge to actually be able to leave the hospital, we're getting it down in the first 6 months of this year to an average waiting time of 17 days. So these are all just genuinely good outcomes that we've accomplished in the last 2.5 years. I'm also pleased to advise that the process to register most service providers, long overdue, is now well underway. Pleased to advise that we're now strengthened the Safeguards Commission from 367 staff to nearly 1,000, dealing with a lot more complaints and issues. Half the board of the NDIS are now people with lived experience. We've got the first Aboriginal and Torres Strait Islander director of the scheme. And we're also doing a lot more co-design than's ever happened before. The range of activities, including engagements, workshops, surveys, discussions, research and partnership with disability organisations. Importantly, also, we're cracking down on fraud. The tip-off volumes, because we now properly resource the agency, have increased by 250%. When we came to office, there were less than 1,000 tip-offs a month, Now they're up to about 2,500 on average per month. $779 million of NDIS funding is being investigated, and over 11,000 NDIS participants who have been potentially impacted by fraud and non-compliance cases are now getting the justice they deserve. I'm able to say that at the end of June this year, there are 100 active operations across the agency, the Commission and Service Australia, 531 investigations underway. A lot's being done, and a lot is being done to straighten up the scheme. And I'm also pleased that we secured parliamentary support for the legislation. And I want to finish on a little note from Mr Robert Chataway and the electorate of Right. He says, "I commend the government on what we're doing to reduce rorting and poorly targeting spending to make the scheme more sustainable. My wife and I care for an intellectually disabled young man. He receives support from the NDIS, which is very helpful, but we've seen the misuse of funds and the potential for significant fraud." And he concludes on this: "I'm a former long-term supporter and member of the Australian Greens, and I'm incredibly disappointed their opportunistic conduct with NDIS reform."
Order. 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 Members on my left. And the House comes to order. Leave from the member for Griffith.
Thanks, Speaker. To the Prime Minister, over the next decade, property investors like the Prime Minister will benefit from $176 billion in tax handouts in the form of negative gearing and the capital gains tax discount. Published polling shows a large majority of the country supports the Greens' push to scrap negative gearing. Will Labor scrap these grossly unfair tax handouts to property investors that turbocharge house prices and hurt millions of ordinary people?
Just before the Prime Minister answers the question, the first part of the question was inappropriate. It's not appropriate to mention someone's personal circumstances. Prime Minister has the call.
Speaker, I bet he doesn't mention in their party room. I bet he doesn't do that, Mr Speaker. Exactly. Or maybe just the person next to him. Doesn't have to go to the party room, Mr Speaker.
Order.
But I bet also he doesn't talk about the housing problem when he's addressing a rally in Brisbane to defend corrupt conduct in the CFMEU. I bet he doesn't do that, Mr Speaker.
Order. Order. The Minister for Defence Industry. The Leader of the Australian Greens on a point of order.
Yes, on a point of order, Mr Speaker, if the first part of the member's question was ruled inappropriate, then surely that comment ought to be ruled inappropriate. And secondly, it is not relevant to the question.
Order. Order. We'll deal with it. Order. We'll deal with this matter. The Leader of the House on the point of order.
Mr Speaker, you didn't ask for the imputation of motives to be withdrawn in that question, and given that it wasn't withdrawn, it should be completely reasonable for the Prime Minister to point out the conflicts of interest, the poor motives for somebody who has stood up and railed against action the government's taken against organised crime. And if he's willing to stand up and make those sorts of statements and then wants to throw motives around here, you can't play with a glass jaw. You throw that around, it comes back at you.
Order. Order. Members on my left. Order. Members on my left are going to cease interjecting, including the member for Gippsland. Order. The member for Griffith on the point of order.
Surely that's a reflection on a member and they should be forced to withdraw. Surely.
Order. Order. The Minister for Defence Industry is warned. I'm just going to ask all members to be careful with their language, to show restraint. I didn't ask the member for Griffith to withdraw. I'm not going to ask the Prime Minister to withdraw. Here's the call.
Thanks very much, Mr Speaker. It is a fact that the member for Griffith attended a rally in which there were if you want to talk about offence, referring to members of this parliament as Nazis and the member for Griffith standing in front of those signs, there is precedent for that sort of thing. And the member for Warringah was rightly condemned then at the time for standing outside this chamber, inside, with those sorts of signs and that sort of behaviour, and you are rightly condemned too. You are rightly condemned too. And I will say this to the member for Griffith. Renee Coffey won't be found anywhere near one of those demos because she is concerned about it. And I'll say this as well, that Renee Coffey would vote for more houses in this House and in the Senate. She would vote for the build-to-rent scheme that the member for Griffith has voted against. She wouldn't have held up the Housing Australia Future Fund. Renee Coffey would have voted for it straight away, not held it up. And indeed, as well, Renee Coffey would support the policy and vote for the same policy that we have, that those opposite from time to time have said they have, and that's in the Greens party platform of a shared equity scheme. Renee Coffey won't be shy about that when she occupies this chamber after the next election, because the member for Griffith says he cares about housing but never takes an opportunity to actually vote for it. If you want more social homes, vote for them. If you want more rental properties, vote for them. If you want more private home ownership, vote for it. It's pretty simple. It's pretty simple. Renee Coffey understands that, and I was very honoured to launch her campaign in Griffith because Renee Coffey wants more homes because that will be more doors that she can knock on.
Order. When the House comes to order, we'll hear from the member for Paterson.
Thanks, Mr Speaker. My question is to the Minister for Infrastructure, Transport, Regional Development and Local Government. What steps is the Albanese Labor government taking to ensure that the Australian aviation sector delivers better outcomes for Australian travellers? Are there any risks to these better outcomes being delivered, Minister?
The call to the Minister for Infrastructure, Transport, Regional Development and Local Government.
Thanks very much, and can I thank the member for Paterson for the question and for her tireless advocacy for our investment in the Newcastle Airport. Our government is, of course, in the midst of an ambitious series of aviation reforms. The aviation white paper we've released includes 56 policies that will boost consumer rights, increase transparency and scrutiny of our airlines and our airports, and deliver better outcomes for travellers with a disability. Our reforms to Sydney Airport, the most significant undertaken since the 1990s and which are already being implemented, will boost access to new entrants, crack down on anti-competitive behaviour and grow competition in our most important airport. We're also building a new airport at Western Sydney that will massively grow access to the Sydney Basin and will significantly change the aviation landscape, particularly when it comes to freight. And we're closely working with the voluntary administrators at REX to maintain regional connectivity, including through our regional flights guarantee. We are taking a considered and consistent approach designed to put downward pressure on airfares which, despite some hyperinflated rhetoric, are already back down below pre-COVID levels. We're delivering a more responsive and more competitive aviation sector for all Australians. And it couldn't be a bigger contrast to what those opposite are doing. We are introducing slot reforms, which they did not do, increasing transparency, which they did not do. And the only consistency that they've had when it comes to their bumbling around in aviation policy is, frankly, their inconsistency. Yesterday morning, Senator Mackenzie threatened the coalition would force divestiture of Jetstar. An hour later, the Leader of the Nationals said it wasn't coalition policy because we haven't got the evidence. Then just before lunchtime, according to coalition sources, the Leader of the Opposition sent Senator Mackenzie out to clean up the growing mess. But yesterday afternoon, we thought that was the end of it, a bit of fun in question time, draw a line under it, but there she was again, Out there, a free thought bubble from the rogue National Party senator, killed off by lunchtime by the Liberals, but by the evening, Senator Mackenzie was at it again, contradicting her own midday press conference, doubling down. Yesterday we had Senator Mackenzie agreeing with herself in the morning, disagreeing with herself by the afternoon, and then agreeing with herself again by the evening as well. Well, frankly, what is going on over there? You know, who is running this show? Here's some advice. Senator Mackenzie gives plenty of advice to everybody else, including to those opposite. Here's some in return. When you're in a big hole, stop digging.
Call to the Prime Minister.
On that note, Mr Speaker, I ask that further questions be placed on the notice paper, and I ask for indulgence.
Yes,
please.
Prime Minister has
Thanks,
a call.
Mr Speaker. I've had discussions with the Leader of the Opposition, and it's agreed that on Wednesday, October 9, which is the next sitting week, in order to give people notice of meetings, question time will be held at 10 a.m. On the Wednesday till 10 past 11. The ASEAN conference is on that week. We hosted the ASEAN leaders here in Melbourne earlier this year. It's obviously a very important relationship of which I'll be representing Australia. The media will be travelling as well up with us, and I thank the Leader of the Opposition for his support for that. And the Leader of the House will, of course, put the requisite motion on the notice paper, but I wanted to make sure that people kept that part of their diary free, given that people make arrangements in advance. So at the earliest opportunity, I'm advising the House.
Member for Warringah has indicated she has a question for me.
Thank you, Mr Speaker. I'd like to raise concern about guests signed in by members of parliament to the gallery. In particular, during a question, the Leader of the Nationals asked the question to the Prime Minister and indicated that guests from supporting or objecting to the live sheet lobby were in the gallery and pointed to the gallery here. When they decided to leave, a gentleman in jeans, black T-shirt, overweight and bald, flipped the bird to...
Just remember, if the order, members on my left. I'll just allow the member for order. Members on my left. The member for Riverina. I'll take your point of. Well, the Deputy Leader of Opposition is asking for that comment to be withdrawn, but. Well, I'm just reading your mind. So just resume your seat. I'm just going to allow the member for Warringah, perhaps in not so many details, just to continue on with the question to me, to get to the question to me.
For the benefit of the Speaker, the description is so that that person may be identified from video content, because upon leaving the gallery, flipped the finger to the chamber, and in doing so, looked to the Leader of the National for support. Now that is, again...
Just...
Oh, are you threatening me? Leader of the Nationals, are you threatening me? Mr. Speaker, the Leader of the Nationals thinks it's appropriate to threaten me.
Order. The Leader of the Nationals, resume your seat. The Deputy Leader is... It's difficult to take a point of order in the middle of a question to me, just as you can't do during a question. Think of it like question time. So can you just allow the member to finish her question, and then I'll give you the call.
Thank you, Mr. Speaker. Now, I've identified the gentleman because clearly he has been signed in by a Member of Parliament to attend the gallery. That conduct is not becoming of a visitor to the chamber. It's a reflection.
Order.
It is a reflection on the Speaker and all of us here, and I do take offence at that behaviour. If we are here to improve standards, it has to come from all, including visitors. So I ask the Speaker, is that appropriate conduct of signed-in guests in the public gallery?
I understand.
And I can also point out, I do take offence to the threat that was made to me by the Leader of the Nationals that I should be careful. That is not appropriate conduct in this chamber.
Okay. You've asked the question. The Deputy Leader is now... Order. Members on my right. Members on my right. Any member is entitled to ask me a question after question time regarding conduct of the House and the operations of the House. So everyone just show respect. Now, the Deputy Leader has been waiting patiently for a point of order.
Thank you, Mr Speaker. And I did stand up earlier because I thought that that was disgraceful, that body-shaming remark by the member for Warringah, the pejorative description of a member of our public galleries, and it should be withdrawn immediately.
The member for Warringah on the point of order. Does the member wish to withdraw that descriptor?
No, because I would like the video footage to be identified.
So the identification is the issue there. Look, order. The member for Braddon. We're just going to deal with this issue because it is a serious issue that what the member has raised. I want to remind all visitors and people who are guests of members, there are established forms of behaviour. Members in the gallery are not here to participate, they are here to observe. So I'm asking all members, when they sign in guests or offer guests tickets to... The member for O'Connor, I'm answering a question. And a message to all members of the gallery not to interject, converse or signal. And I further remind all members, if you do invite guests to the gallery, I consider their conduct to be a reflection on you. I want to be clear that if this behaviour continues, the privilege may be revoked, just as it has been done in this term. Visitors of the public are welcome here to observe. Leader of the House with papers.
Speaker, this document is tabled in accordance with the list circulated to the honourable members earlier today. Full details of the documents will be recorded in the votes and proceedings.
I have received a letter from the Honourable the Leader of the Nationals proposing that a definite matter of public importance be submitted to the House for discussion, namely this government's anti-farming and anti-resources agenda. I call upon those honourable members who approve of the proposed discussion to rise in their places, and I give the call to the Leader of the Nationals.
Well, thank you, Mr Speaker. Today we saw out the front of the Australian Parliament farmers forced to travel from Western Australia, from right across this country, to protest against the government, something they have not done for 40 years. Such is the siege that they have been under since the Albanese government was elected 2.5 years ago. They feel as though their livelihoods and their future has been torn up because of the ideology of some that want to save the world but forget about their important place in producing the food and fibre of this country. Those Western Australian farmers that have come across the Nullarbor that have had their livelihoods taken away, the live sheep export industry without an explanation. If this government has the courage of its conviction and says that they want to shut this down because it's an inhumane industry, then go to Kittanning and face these people. Look them in the eye and explain the science. Let me explain the science for them, because I was the Agriculture Minister when there was a mistake. The Awassi boat and the horrific incident there was fixed, and we fixed it with reform. We are the only country in the world that measures our boats in success from animal welfare standards, not through mortality. We actually measure to the millimetre the length of wool on each sheep before we put them on a boat, to the kilogram, the weight of those sheep. And we independently score each boat for the airflow that goes through that boat to be able to give them the carrying capacity that they can have. We've also put independent observers that actually count the pants per minute of a sheep on those boats. And once they hit a certain number, then there are measures taken to ensure that that heat stress is taken away. That is science. That is leading the world. Instead, what the Albanese government has done has cut and run. And what that will do is see the perverse and horrific death of millions of sheep from other parts of the world, from those parts of the world that will take this market up, from Sudan, Ethiopia and South Africa. Let me tell you, they don't work on animal welfare. They don't work even on mortality numbers in measuring any success of a shipment. They simply put as many sheep as they possibly can on a boat, and they get paid for what's left over. Those that want to shut Australia out of this industry are morally bankrupt. Those that sit there and Australia cannot do this and Western Australians can't do this are morally bankrupt. We will see horrific animal welfare outcomes. We will see 3,000 livelihoods in Western Australia torn up, all because of ideology, all because animal activists did a deal with the Albanese government to get their preferences in the last federal election. Where is the courage of their conviction to stand up and face these people and explain that science? They won't, because they can't. And for the Prime Minister to quote numbers in here that the industry is in decline is actually in incline. And for those years that the Prime Minister talked about where there was a steep decline, what he might want to understand, there was this little thing called the drought. And on the eastern seaboard, we destocked. We had nothing left because we didn't have the water and we didn't have the feed. And if it wasn't for Western Australian sheep producers, we wouldn't have got the 2 million sheep that were brought across when it started raining. They got East Coast farmers up off their knees and gave them a livelihood. That's why they weren't put on a boat, because they were sent across the Nullarbor to save us. Western Australia saved the East Coast straight after the drought. But to sit there and arbitrarily say, bad luck, it's all over, without even the courage to turn up to Katanning, to have meetings at the back of the Parliament House here, didn't even have the courage to walk out here and explain the science. If you want to lead this country and you're going to take away someone's livelihood, you're going to change their lives, then have the courage to stand up there and look them in the eye and explain the science. But that's before you even get to the Murray-Darling Basin plan, a plan that these people put in place. The Labor Party put this plan in place in 2012. That plan they have now walked away from. And what they are saying to every Australian is they're going to take an extra 450 gigalitres, they're going to take it off farmers and they're going to shove it down a river that they can't even physically get it down, taking away the livelihoods and taking away your food security and driving up your food prices. This is the insanity of a plan that they implemented, and the member for Riverina, who's sitting here next to me, proudly stood against that and voted against that, and I acknowledge him for that. But we, when we were in government, made sure that we implemented a plan that didn't go towards buybacks, because they are a brutal instrument on the communities that are left behind, because the farmer takes the money and runs to the coast. It's the machinery dealer, it's the irrigation shop, it's the local CRT, and it's right down to the local hairdresser. They're the ones that are left behind with nothing. They're the ones that pick up the pieces without the jobs and without the income. They're the ones that have been destroyed by a change in their very own plan to take another 450 gigalitres with buybacks. Buybacks will destroy regional Australia, but they're going to destroy Australia's food security and push up your food prices. We stand committed to making sure the plan that was put through here is put back to common sense. We return water to the environment through infrastructure, the smarts of backing a country with technology and science and infrastructure to give it back to the environment, not take it out of communities. That's common sense, and that's what we intend to do. We're going to give back the ag visa that was ripped away by those opposite, an ag visa that the Vietnam government signed up to. And subsequent, have we learned in Senate estimates that Senator Wong, the foreign minister, has been offered other countries. I think he's gone.
Right, he'll be called back in to withdraw
Thank
that.
you.
That
Thank
is
you,
highly
Deputy
disorderly. You have the call member.
Thank you,
Leader of
Deputy.
the
And
Nationals.
Senator Wong has subsequently had requests from other ASEAN countries to take up the ag visa. And this government has turned its back when, even at their own job summit, which I actually went to be constructive and to say what regional Australia's issues were, told them that we needed workers out there, and the NFF and COSBOA said we needed another 172,000 workers to get food from a paddock to Australians' plates. And all we could have was the Pacific scheme. At best, 42,000 people. And all they did was actually change the Pacific scheme that was unworkable. But you take away the ag visa and farmers have nothing. And what they do is they make investment decisions. They don't plant. You don't plant a crop. You don't spend hundreds of thousands of dollars to plant a crop if you can't pick it. That's economics. And so what we have seen is farmers take away their confidence, which is driving up food prices because they don't have the tools. And now this government wants to take away the 88-day rule on backpackers. What happens is you come to Australia as a backpacker. If you go and work in the bush for 88 days, you get another 12 months to stay in Australia. And the unions want this taken out. They've got a paper out there at the moment wanting to rip this away from country towns, not only farmers but country pubs. But you won't have pubs going if you take that away. That's the common sense that we'll give back to, and the certainty to Australian farmers. It'll also be about making sure that the bill that was passed yesterday, the financial infrastructure bill, that not too many people have learned about. But what this means is the government is going to force the reporting of Scope 3 emissions. Now, some might say, what does that mean? What that means is if you've got a turnover of over $500 million, i.e. a bank, and you've got customers, what you've got to be able to do is report your Scope 3 emissions of all your customers. That means a little old cocky in Western Queensland, in my electorate, who runs 5,000 sheep and probably 5,000 acres of grain, he has to be able to give his emissions profile to his bank. That, even in the Treasury's own numbers, is going to cost the Australian taxpayer $2.3 billion, $2.3 billion in administrative costs. That has to be passed on to you. And now we see in Blaney last week shutting down a gold mine, and for the minister, the environment minister, to say, oh, they can still do it. She might want to walk out there and have a look at it, because if you stand on that mine site and see where you can actually place a dam, there's this thing called topography, and water runs certain ways. And you can't just whack a dam at any part of that, particularly a tailing dam. And for a company that spent $300 million, 5 years of investment in putting 800 jobs into Blaney, and to have it cut out after the local Indigenous representative group that is recognised by law said that while they didn't support it, they didn't oppose it, but then the New South Wales Environment Department, the New South Wales EPA approves it, and even Minister Plibersek's Environment Department approves it. For some reason, she has listened to some other Indigenous group. Yep. She will not release the statements of reasons. I would have thought that's owed to Regis. That's owed to the people of Central West New South Wales, that they have certainty about understanding why the minister has declined an 800-job mine, $1 billion of investment. Yep. That is what regional Australia are cranky about, and that is what has brought them to Canberra. Right. When the Prime Minister was elected, he made this grand statement: no one held back, no one left behind. Well, that's unless you live in regional Australia. That's what they're feeling, and that's why they're out there today.
I'm giving the call to the Minister for Agriculture, Fisheries and Forestry and Small Business.
Thanks, Deputy Speaker. What an interesting contribution that was from the Leader of the Nationals. I mean, seriously, I'm actually pleased to be given the opportunity to stand up here and talk about our record investments that will support our critical industries of agriculture and resources, which is what this MPI is actually supposed to be about. Because we do have record investments supporting both the resources and the agriculture sector. We've invested now over $3 billion in new investments in agriculture since we came to office, including fixing up the messes that they left behind. You talk about a world-renowned biosecurity system keeping out pests and diseases in this country. We've invested over $1 billion in extra funding to be able to secure that. Those opposite left it in deficit, left it in a mess, and we have been cleaning it up. What about the APVMA? We all remember what a mess that was, Deputy Speaker, an absolute mess. I mean, we have chemicals in this country that had not been checked for more than a decade. Can I say, Mr. Speaker, Deputy Speaker, we also have these two critical industries, resources and agriculture, we know are going to play a critical part on our road to net zero. And of course, we have legislation that's being debated in the Parliament. We just had some votes on it yesterday and it's on its way to the Senate, called the Future Made in Australia. And what does the Future Made in Australia do? It supports the critical minerals industry from Western Australia particularly. It also, of course, provides opportunities for our agriculture industry when it comes to low-carbon biofuels. It will provide a lot of support to both of those industries to be able to actually make more here in this country, and for some reason those opposite are opposed to it. It will create more regional jobs Deputy Speaker, and those opposite are opposed to it. A future made in Australia. I cannot believe that even the Nationals, I can see a grin over there. This is a serious bill about making sure that we make more here in Australia of the opportunities in our great raw products. Both the agriculture and the resources sector provide great raw products in this country, and we want to do everything we can do to support them. When it comes to agriculture, this financial year, the agriculture sector will contribute $84 billion to Australia, the majority of which, over $70 billion, is in exports. So what have we been doing as a government? We've been trying to open up trade markets and repair our international relations, but those opposite decimated when they were in government. We all know that that has actually been one of the things that our government has been recognised and praised for around the world, restoring those trade relations, particularly when it comes to places like China. Deputy Speaker, indeed, currently we have $17.2 billion in agriculture, fisheries and forest products going into China in the last financial year, $17.2 billion. But we know, of course, that when those opposite were in government, there were some serious issues. The Prime Minister today talked about our red meat going into China. He talked about, of course, our bottled wine going back into China. He talked about our barley going back in China. He talked about oat and hay going back into China. We have worked diligently, not just with China, but of course we also want to diversify our trade markets. So of course we've also maintained access to canola for the EU. We've got new access for live eastern rock lobsters to Vietnam. We've improved access for wine in Thailand. We've got new access for Has avocados to Thailand. Just yesterday, the Trade Minister and I announced access of plums to Vietnam. We've maintained access for queen bees exported to Canada. We've improved dairy access for products to Chile. We've got new market access for Australian honey and edible aquaculture products to be exported to Vietnam. If you want to add it all up, we've actually got, just in the last financial year, 88 technical market access achievements, of which 10 are new markets, 44 are improvements to existing markets, and 29 actions to maintain existing and restore existing markets. These are worth $4.6 billion just when you talk about restoring the existing markets we had and maintaining them. This is a very significant support for our agriculture sector because we know how important it is. It's important to the country. We know what happened during COVID. Our producers, of course, produced and kept this country going to make sure that we could keep our supply chains going and Australians were fed. We know how critical it is. What we need to do is continue to support them. Our National Reconstruction Fund will have specific money set aside for agriculture, forestry and fisheries, and indeed they're eligible to apply for that now. That, together with a future made in Australia, will provide enormous opportunities for the sector in this country to be able to continue to grow. And of course, we're working on the agriculture and land sector plan with the industry so that they can get the benefits from our road to net zero. There are huge opportunities here for diversifying income on farm. There are huge opportunities for increasing productivity, as we're going to need to invest in lots of research and development when it comes to on-farm reducing emissions. And we heard from the member opposite, about Scope 3 emissions. And of course, what we have said is very clearly is that these only need to be collected where there's not a huge cost and they are available. And that is the truth of the matter. And the member over there, the Leader of the Nationals, has been running a bit of a scare campaign on this. We've also heard all sorts of rumours about we're going to change the diesel fuel rate. Again, untrue. He was up here talking about the 88-day working visa. They are the ones that removed that requirement when they did the trade deal with the UK. It was actually their government that removed it. Seriously, he talked about the ag visa. Nobody came to Australia under 9 years under their ag visa. It actually didn't do anything. We're serious about the workforce. We have changed palm, but importantly also with our fee-free TAFE, we have actually got over 14,000 people doing agricultural studies that wouldn't have otherwise been doing it. So we actually have been working when it comes to workforce. We've been working when it comes to improving our biosecurity system. We've improved the AMA. We've opened up trade markets. We are working incredibly hard to make sure that our agriculture sector continues to thrive. We, of course, and I know my colleague Madeline King has also been working hard when it comes to our resources sector. Indeed, modelling shows our critical minerals industry, by processing more onshore, could generate close to an extra $70 billion in GDP. And again, as I said, that would increase jobs in regional Australia. We've invested $3.4 billion for Resourcing Australia's Prosperity Program for Geoscience Australia to identify the likely locations of the critical mineral deposits to make sure that we can access them and we can get the benefits. We know that other countries are trying to get onto the critical minerals because we all know that they're going to be vital for the road to net zero, but we want our country to take those opportunities. We do not want to be left behind as a country, which is why we're making these investments. Our value of our resources projects is over $13 billion in investments that we are making to support the resources sector in Australia. The Prime Minister and the Cabinet have been over to Western Australia several times, including myself been over to Western Australia. I'll be travelling to Western Australia again in coming weeks to work with the state government on the transition in terms of the phase-out of the live sheep exports. We are very serious about engaging with the Western Australian community, working with the Western Australian government and making sure that we get the best for West Australians. I have been out to Launceston, actually on a sheep farm, can I say, talking to them. I thought you said Launceston over there. I've actually been out talking to farmers right across the country. I have been talking to farmers right across the country from Cairns all the way down to the south of my electorate since I've had the agricultural portfolio for just over a month. I am very keen to engage with the sector. I want to make sure that our farmers get the very best representation, as they did under former Minister Murray Watt, and I want to continue that important and vital work. The other thing that I want to make sure is that farmers' voices are heard in this place, and making sure that those opposite don't get away with telling furphies about what's going on in our regions and for our farmers. Because, as I said before, we heard a lot of stuff from the Leader of the Nationals over here that just simply isn't true. Yep. And interestingly, at the rally today, I was really surprised to see the Deputy Leader of the Liberal Party standing up behind their leader, Peter Dutton, particularly given she was in here moving private members' bills to do the exact same thing that she is now saying that she doesn't support. I mean, seriously. We had the Leader of the Nationals also out there, and surprisingly he came in here in his speech and talked about the Murray-Darling Basin. And I understand that he actually had farmers attack him and ridicule what they did in government when it comes to water in the Murray-Darling Basin. They're not very happy with him. So perhaps he should be honest with farmers about what's going on. Our government is providing record investments when it comes to resources, when it comes to agriculture. Right? When it comes to agriculture, we want to make sure that both of these industries get the support they need in terms of road to net zero, but importantly, that we support them because we know that their critical support and the things that they will be required to do as we go down to road to net zero will mean that they are continuing to receive a high yield for our great products around the world, because if we don't do that, they're not going to continue to get the market access that they deserve, and we'll continue supporting them and Western Australians.
Is the member for Solomon seeking the call?
Yeah, I think I'm in here to withdraw, Deputy Speaker.
Thank you. I'm going to just remind all members in the chamber and anyone listening in, interjections, even from your own seat, are disorderly behaviour. But as you leave the chamber, it is highly disorderly. So let's conduct this debate without offending standing orders. And I give the call to the member for Page.
Thank you, Deputy Speaker. Deputy Speaker, there is unfortunately in this country right now a huge divide between inner-city elite MPs and the country and as farmers. And that's not me saying that. I hear interjections from opposite, Deputy Speaker. That's not me saying that. You know who's saying that? The thousands of farmers who are out there today, who I'm sure, Deputy Speaker, the member for Lyons wouldn't have gone anywhere near. It's not me saying that, Deputy Speaker. It's the thousands of farmers who are out there today saying there is a big divide between inner-city elite MPs. The sanctimony in this place you can feel dripping at times, Deputy Speaker. The sanctimony no heavier than what it is over there with the Teals and the Green inner-city MPs, but certainly there's a fair share of inner-city Labor MPs, Deputy Speaker, too, where sanctimony drips heavy. And that's not me saying that. That is farmers
today at the front of this building who's saying inner city elite MPs do not understand what they do. Do not come and talk to them about what they do, and do not and have again hypocrisy over what they. Deputy Speaker, you'll remember just a couple of weeks ago we were talking about another inner city elite MP and country divide over the transmission system, about solar panels and wind turbines, and we saw that inner city MPs, like the Teals, like the Greens, like the Labor ones, they didn't want anything on North Head with solar panels or wind turbines, but gee, let it rip out in the country. And here again today is the same theme, because there are a couple of themes out there. Well, actually, there are about 4 or 5 themes out there today, Deputy Speaker, but the driving one of this was the inner city MPs' ideological hatred of live export. And that's what drove today's rally. Now, I'd be interested, and I'm happy to sound corrected if any of these entitled inner-city elite MPs want to come in and tell me that they've been to Kentani, and I have. I've been over there to speak to the sheep producers over there, have been speaking and been onto a live export sheep to see, as the Leader of the Nationals just articulated, Deputy Speaker, a lot of work has happened. No industry's perfect, mistakes have been made, but gee, there's been a lot of good work happen in the live export industry over the last 5 or 6 years. Animal welfare, we lead animal welfare, Deputy Speaker, on this around the world with animal welfare. But again, this ideological obsession of entitled elite inner-city MPs who think they know best, say, we'll tell you what you can do, we'll tell you what you can't do. We know best from our inner-city leafy suburbs what you should be doing out on the farms that you have. And, again, that was one of the really heavy themes out there, Deputy Speaker. But I also want to make the point to those opposite that when you say to someone the market that you're in, so what we're saying to countries like Kuwait, Israel, Jordan, Oman, Qatar and Saudi Arabia, Deputy Speaker, what we're saying, because they want to import live sheep. So when you say to them the live export of sheep industry is not okay, you're saying to those countries what you want and the fact that you want it is not okay. That's what you're saying. That's damaging to trade relationships. That is again is the entitled attitude that these inner-city MPs have, Deputy Speaker. They think they know best. So they're saying to those countries, they're saying to Kuwait, Israel, Jordan, Oman, Qatar and Saudi Arabia, the fact that you want to import live exported sheep is bad. You shouldn't do that. And that's what they are saying, Deputy Speaker. Again, you shouldn't be surprised. I'm not surprised that our inner-city elite MPs think like that, but it is disappointing for the industries and the people who are trying to make money out of that industry, Deputy Speaker. But again, as we said to the farmers out there today, on the election of a Dutton Little Proud government, we will reverse that decision, Deputy Speaker, and let the live exporters of sheep continue. There are a number of other themes. The other one certainly was water, because again, the other thing that the entitled inner-city MPs don't want, the Minister for Environment, being an inner-city MP herself, she doesn't want farmers in the Murray-Darling Basin to have all the water they have now. She's taken water away from them. So what does that mean, Deputy Speaker? That means our farmers don't have the water that they otherwise would have to grow food and fibre in this country. So I was going to go into the resources dinner. The resources dinner last night, they're not happy with the government. The Prime Minister said no one held back, no one left behind. Well, you're doing a lot of that, Prime Minister.
Member for Bendigo.
Thank you, Deputy Speaker. Well, I rise today to make a contribution towards this debate, and I do feel like I need to sort of give the National Party and the members of the National Party a bit of 101 on how to organise a rally, Deputy Speaker. I've organised a few in my time, not just here as the federal member. I do confess I've helped organise a few, but in my life before. And 101 in organising a rally is do not overinflate the number of people who come, because you will get called out. There weren't thousands of people out on the lawns, lucky to have 100 farmers. Then with all the staffers stacked it out, it's probably about 400 people. So 101, do not overinflate the number of people at a rally, because you will get called out, and usually by your own. Number two, and this relates to the rallies that happened in my electorate over the break. We had the Bush Summit in my electorate. We had, so I'm a Bush electorate. We had the Rural Press Club have an event, and the National Party in Victoria bussed in some farmers to protest against the Premier of Victoria. And just to show you how ridiculous this MPI is, because it tries to link farming and resources, some of the signs that the farmers had at the rally at Bendigo. Save our farms, no mines. Farming, not mining. These are what National Party stacked out rallies had in my electorate. Farmers say no to mineral sands on the Wimmera, but possibly my favourite, grains of wheat, not uranium, at a National Party rally. Now, I have to say, I said to those farmers, I'm with you. Grains of wheat, not uranium. Our party is opposed to nuclear energy. So another 101 of organising rallies, make sure you get the message right to the constituents who are turning up, if you want to get a clear message out about what you're rallying about. So if you're going to try and organise a political protest, be organised. 101 of organising a rally. Because at the moment, you're trying to please two constituencies, big energy, big mining, and big farming, and it's not working. In my part of the world, Central Victoria, we do have the balance of mining and farming. We have gold mining that is growing and going gangbusters. We've rediscovered gold in Bendigo, and I'm the first to stand here and say that I'm really proud of what our local mining industry is doing and the way in which they are working, not just with our local farmers and agricultural community, but our First Nations community. Fosterville Gold Mine has got about 1,000 workers there, including contractors, and Mandalay Resources over in Costerville also mining gold. So we have a significant mining work that is going on, and it's a demonstration of what can be done well when you bring people together in a collaborative way, where you don't try and blow the relationships up like we are seeing to the north of my electorate and to the west of my electorate. I just don't know how the member for Mallee, who I notice isn't speaking on this, can actually reconcile those two issues between grains of wheat, not uranium, farming, no mining of mineral sands. They're at this stage where the farmers in the Mallee are starting to call for a moratorium on farming landing because they don't want mining going on. So the Nationals are heading for a collision within their caucus room between their original constituency, the farming community, and then the big mining mates. And just to give you an example of a few of the mining mates that have moved into the north, Dina Reinhardt does have an interest to the north. This is the kind of interests that are coming back into Victoria, and it's a problem that they've created because of the way in which they've fuelled misinformation and disinformation in communities. In the government, in our side, we believe on bringing people together, to finding that common ground to work through smart policy. We want to make sure when we have resources, new resource projects, they have to stack up economically and environmentally. We want to make sure that people who are investing in these, that the local constituencies, the local people who might be concerned, they have their day, they can raise their concerns, but then decisions are made based against the law, that we've applied the law to all projects. And I can see that rolling out in my state of Victoria as well as in other parts of the country. We also want to make sure that when we are farming, that we are doing it in a way that is collaborative and supporting and embracing new farming technologies and new farming methods.
Time has expired. Member for Capricornia.
Thank you, Deputy Speaker. Australian farmers are the backbone of our nation, and their contribution extends far beyond putting food on our tables. Right. In my electorate of Capricornia, over 73,900 people are directly employed in the agriculture sector. The dominant form of farming here is cattle production, with 768 dedicated cattle graziers working the land to sustain our thriving beef industry. Farmers across Capricornia contributed an astounding $1.88 billion in gross value product for the 23-24 financial year, but that's just the beginning. This industry alone employs 270,000 Australians, and nearly 37% of those workers are outside our major cities. These just aren't numbers. They represent how agriculture is the lifeblood of rural communities. It sustains families, businesses and entire regions. Our farmers ensure Australia's food security, and without them, we would be far more vulnerable to global shocks and supply chain disruptions. The hard work of our farmers doesn't end in the paddock. It continues when they come together to share knowledge and advance their industry. Beef 2024, held every 3 years, is one such event that attracts graziers not only from across Australia but across the globe. This year, the impact of Beef 2024 on the Rockhampton region was nothing short of remarkable, injecting an astounding $102 million into the local economy. This event showcases the critical role agriculture plays in supporting local businesses, creating jobs and driving economic growth in our community. However, the importance of the agriculture industry is lost on a government who bows to the loud voices in the inner city. Since taking office, the Albanese Labor government has consistently targeted regional Australia with policies that have hit our farmers hard. As the backbone of our agriculture sector, they are now facing increased challenges due to Labor's misguided approach. Rather than offering the support needed to sustain the industry that feeds both Australia and the world, Labor's decisions have led to greater uncertainty, instability and mounting pressure on our farmers. One of the most detrimental actions taken by the Albanese Labor government was scrapping the agriculture visa. Industry leaders have made it clear that Australian agriculture is in desperate need of more workers, with an estimated shortfall of 172,000 people. Despite these warnings, Labor's decision has left farmers without the necessary workforce to keep operations running smoothly. The government's heavy reliance on the Pacific Australia Labor Mobility Scheme has only worsened the situation. Additionally, Labor proposed a fresh food tax which would force farmers to bear the financial responsibility for biosecurity risks introduced by international competitors. Labor's assault on farmers extends beyond workforce challenges, more red tape and taxes. They are also undermining the critical infrastructure that supports water security and boosts agriculture productivity. By stripping billions of dollars from vital water infrastructure projects, Labor is putting the future of Australian agriculture at risk. In their first budget, Labor stripped $483 million of funding from the Urana Dam, a project which would deliver water security for Central Queensland farmers. Yet the blatant hypocrisy of the Labor Party is to rush to Rookwood Weir only weeks ago to officially open the coalition-funded project. It's ironic that Labor pretends to support water projects one week, then the next day acts 970 gigalitres at Urana Dam, killing off water security for 20,000 hectares of prime agriculture land. Those opposite are quick to cut the ribbon on coalition-funded projects, but refuse to invest in the very initiatives that could drive growth in our regions. These cuts are not just an attack on our farmers, but an attack on the entire agriculture supply chain. Every dollar invested in water projects brings exponential returns, ensuring that our farmers can continue to thrive even during challenging weather conditions. By pulling funding from these essential initiatives, Labor is not only jeopardising the livelihoods of farmers, but also threatening the stability of rural communities and the broader Australian economy. Australian farmers are staring down the barrel of a government who doesn't care for the work they do to create jobs and growth, while also driving up the cost of every Australian's grocery bill. Labor's agriculture policies are nothing short of shameful, reckless and blatantly ideological. As I did today at the National Farmers Rally and have done every day of my 4 terms as member for Capricornia, I will stand with farmers and fight to keep farmers farming.
I call the member for Paterson.
Thanks, Deputy Speaker. And I want to firstly say how proud I am to be the chair of the House of Representatives Standing Committee on Agriculture. We work collectively and in a bipartisan way with both members of the opposition and the crossbench. And earlier this year, we were asked to conduct an inquiry into the phasing out of live sheep exports. And I'm pleased that the member for Lyons and the member for Hasluck are both in the House with me today talking about this matter of public importance. And I want to say firstly to the 3,500 people that came along to our inquiry, many more that were here today, but I understand that distance can be a tyranny. They came to the Muresk Institute to hear the inquiry, and I understand that it is a concern for the farming community. I want to acknowledge that sheep farmers in the West are concerned about this. I acknowledge that, and I thank them for their efforts and input that they had into our inquiry. It is now the law that the trade will cease from the 1st of July 2028, and it won't be revisited. But what our government wants to do is provide certainty. We're not vacillating on this as those opposite have done with so many policies over the last decade. We have made a decision. We are not afraid to make that decision, but we recognise that there are going to be challenges for the people involved in that industry, particularly in Western Australia. And with this in mind, that's why we have offered up the $107 million transition support package to help individuals and families who are going to make some business decisions and do some planning around what will replace that live sheep export trade revenue for their businesses and families. It's 4 years away, and we did make a recommendation that in concert with the Western Australian State Government, we look at potentially extending that package. So I do want to say that it is important we get it, and we do thank and recognise those farmers who work so hard for not only the Western Australian farming economy, but also our Australian farming economy. I also want to share an interesting statistic. We spoke with Roger Fletcher, who gave evidence for us at that inquiry. He, of course, on the eastern seaboard will be well known to the people of Dubbo because he has a very big abattoir out there, and he has also abattoirs in the west. And I was interested to know that when we asked him about export of sheep meat, how much sheep meat that's many sheep that are currently being exported live would it take to process if they weren't being exported, if they were being slaughtered in Australia, processed here and boxed up to be exported. So the amount of sheep that are currently going out on boats in Australia could be processed in 4 days. That gives you an understanding of the size of the industry these days. So we know that this industry is in decline, no matter what those opposites say. These are the facts. We know that we can earn more. We know that we can support our farmers with better, more vibrant export markets, which the Trade Minister, Don Farrell from South Australia, has just been working night and day on, doing a brilliant job, restoring our relationships with Asia, particularly China, opening up those markets for our farmers. But look, I just want to close. I received an email from a vet about this, and today the Leader of the Nationals, David Littleproud, asked the Prime Minister about sheep from Sudan. And in this email, the vet said to me, the move away from sheep exports from Australia should actually see a net global animal welfare gain, as our sheep will no longer be travelling for up to 3+ weeks by sea from opposite seasons. Instead, locally grown and heat acclimatised sheep and goats will be sourced from much closer destinations to the Middle East, some with voyages as short as 10 hours from Sudan and Saudi Arabia, animals that were never going to be afforded the relative luxury of a pre-stun slaughter. Also, with our less crappy ships more freely available, they will most likely displace some of the very old ships in the Middle Eastern region and lead to safer shipping. Thanks again for your work. I value that I can put away all the memories I have of sheep suffering on these unnecessary voyages. Sincerely, Dr Lynn Simpson, live export vet. So, with that, we want to support Australian farming and Australian farmers, and we also want to play our role across the globe in better farming practices, and I think that we're achieving it.
I call the member for Barker.
Thank you, Madam Deputy Speaker. Well, Madam Deputy Speaker, can I just reflect on the contribution the member for Paterson has made? It must be a frustration for her to sit on the backbench. She quite frankly should be on the front bench, but of course her attitudes to many of those things don't accord with those of the Prime Minister. She's more Fitzroy River than she is Fitzroy, and that's the problem here on this debate. I do want to address the member for Bendigo, if I could, though she I think, kind of was critical of the number of people who'd come all the way from to Canberra to protest this issue. I mean, I've got some constituents up there. They've driven for 2 days. And unlike the rallies that the member for Bendigo used to organise, the people up there aren't being paid to come here to represent the interests of their community. When the member for Bendigo was an organiser for United Voice, every single one of those people who turned up to protest was on the pay. So, look, I don't think those opposites should be critical of people coming here and expressing their objection to the policies of those opposite, particularly when they're led by a man so weak, so gutless, that he wouldn't even walk, Madam Deputy Speaker, out the front of the building and confront these constituents. Now, talk about someone who's more focused on Fitzroy than he is Fitzroy River. Those opposite are led by exactly that person. Now, the reality here is this. The Australian live sheep export industry provides the best animal welfare standards anywhere in the world. We not only export sheep, but we export animal welfare standards. What those opposites don't understand is West Australian producers cannot produce an animal that has the characteristics that processors want and that consumers want. You're effectively saying to these producers they don't have a future. But the bigger issue, the member for Hasluck's happy to contribute, but the bigger issue is this. This industry, to those opposite, and the member for Paterson knows this industry has done every single thing the government has asked it to do. Every single thing the government has asked it to do, and yet it's being banned. So the question my producers have, Mark Poyker up there all the way from Mount Gambier, he's a beef producer. He's thinking, am I next? Am I next?
The member for Hasluck,
I've done everything I can.
The member for Hasluck will cease interjecting. Call the member for Barker.
Thank you, Madam Deputy Speaker. He's thinking, am I next? And he's living in an electorate where he's watched a government make life very difficult. No, those opposite want to talk about scare tactics. They gave us Mediscare. Oh, please, this isn't scare tactics. This is real. Go to Western Australia, talk to a Western Australian sheep producer and ask him if it's a scare campaign. It's not, mate. It's a bill that's become law, which means their business doesn't exist anymore.
You've scared them.
Well, the reality here is that those opposite, I don't know why you hate farmers so much. You've ruled out an industry, you've rubbed it out. And while I'm talking about rubbing out food production, let's talk about the Murray-Darling Basin. Those opposite want to take water from the basin, from farmers, intergenerational farmers, and take their water rights away.
Shame.
Now, the Riverland in my electorate, highly productive horticultural zone. But without water, it's a desert. Without water, it's a desert. And those opposite are going to take all of South Australia, the equivalent of all of South Australia's water entitlement, away.
Wow.
In the South Australian context, many people think, well, South Australia won't have to make a contribution. That's not true. South Australia will have to make a contribution. It's best estimated at 32 gigs. That's the size of the Renmark Irrigation District.
Wow.
That would be like saying to every horticultural producer, every almond producer, every viticulturalist, every person growing an orange, a mandy, an apricot in the Renmark Irrigation District, we're going to rub you out. Just like we rubbed out West Australian sheep producers. And those opposite can call it a scare campaign all they want. The people of Western Australia call it something else. Real.
I call the member for Lyons.
Thank you, Deputy Speaker. Well, the Leader of the Opposition stood outside this place today and told farmers he has their backs. Well, if that was true, he would come clean on his nuclear plan. How much water will his nuclear reactors use, and how much more will water cost as a result? How much more will farmers be paying for energy under the Liberal National Nuclear Plan? The CSIRO and others say it'll be at least twice as expensive, and perhaps up to 6 times as much as it would cost under renewables. If the Leader of the Opposition had farmers' backs, he would acknowledge that the National Farmers Federation is one of 18 major business and farming groups that last month issued a statement saying Australia requires more renewable energy at all scales. The Leader of the Opposition would acknowledge that 12,000 farms are located within 80 kilometres of his 7 reactor sites in regions that are major contributors to Australia's food supply, with cattle, milk, lamb, grain and vegetable production. Under international standards, that radius is classified as an ingestion exposure pathway, and farmers must take preventative measures to protect food supply in the event of a nuclear accident. Farmers would be required to inform customers of the risk of nuclear contamination. They would have to stump up for the cost of decontamination and livestock destruction. Will the Leader of the Opposition tell farmers how much that is going to cost them and what the implications are for their farms? No, because this is a Leader of the Opposition interested in only one thing, his own relentless political ambition, and he will tear down and rip up anyone and anything who gets in his way. He will say anything for a headline: wedge, divide, dog whistle, drive Australians apart. That is the stock in trade of this Leader of the Opposition. He won't support renewables, even though they are already delivering results for farmers and regional communities. Cheaper power and more jobs for the regions, and it's the Liberals and Nationals standing against it. Now, outside this place today, we have a couple of hundred sheep farmers from WA who don't agree with our government's decision to phase out the live sheep export trade. They have the right to express their view. Our decision directly affects them, and we accept that, which is why we have put a $107 million transition package on the table. The fact is, our decision is consistent with the position we took to the 2022 election. We have been upfront and fair dinkum. It's worth noting that the live sheep export trade is valued at $77 million, which is 1/3 the value of Australia's total mandarin exports. By way of comparison, it also contrasts to the $4.5 billion sheep meat export trade and $3.5 billion domestic sheep meat industry. And it's also important to say, Deputy Speaker, that that $77 million doesn't disappear. Those sheep, once destined for live export, go instead to domestic processing. Now, our Labor government is not alone in supporting the transition away from live sheep exports. The Deputy Liberal Leader, the member for the regional New South Wales seat of Farrer, has referred to the live sheep export trade as, quote, an awful trade, unquote. The member for Farrer said the trade, quote, fails on both economic and animal welfare grounds, unquote. So when the Leader of the Opposition falsely seeks to paint this issue as Labor versus the Bush, just remember we have a regional senior Liberal MP, his own deputy, who is on the record in sharing our position. I acknowledge she's since changed. Of course she's changed her mind. Now she's a Deputy Liberal Leader with the Opposition Leader breathing down her neck. Of course she has. But we know what's in her heart. We know what she really thinks. Now, Deputy Speaker, one of the more tiresome tropes of this place is those opposite claiming this government doesn't get the regions. We have a number of regional MPs, Ministers Collins, King, McBain, McCarthy, Miles, Conroy and Jones, as well as the members for Gilmore, Bendigo, Cunningham, Debelle, Lingiari, Hunter, Newcastle, Patterson and myself, to name a few. The fact is our Labor government is committed to a robust, sustainable agriculture industry, which currently stands at $84 billion a year and is expected to get to $86 billion. We stand by that and we're going to grow it. Thank you.
I call the member for Grey.
I have severe doubts about that last statement, Madam Speaker, I must say. I do defend the Labor Party. in my electorate when people say to me, why do they hate us so much? And I say, I don't think the Labor Party hates miners or farmers, but they think they can bear any amount of pain that they inflict upon them. That they'll be all right. Those farmers have got big utes and things and they always whinge about everything and they don't vote for us anyhow. They'll be able to soak it up, don't worry, and we'll be able to grab a few Green votes in the city, and don't think that this isn't about that. We'll be able to grab a few Green votes in the city and they'll get over it. They say the same to the miners. Well, I attended the Keep the Sheep rally out the front this morning. I know that I don't think any members opposite did. And from my estimation, there wasn't 200 farmers there. There was somewhere between 2,000 and 3,000. Now, I didn't put them all down the sheep race and count them personally, and I can count by about 5 at a time, but that's about what I reckon was there. And they'd come farmers from my own electorate, and I recognised them, and they came up to me and said g'day to me. And now the banning of live exports, no wonder it has galvanised farmers because there's no science behind it. There was precious little consultation and no courage. And in fact, the industry has jumped through every hoop. Millions have been spent upgrading on-ship ventilation, decreasing onboard stocking rates, better handling, feed and water systems, mandatory onboard vets resulting in close to negligible stock losses. Additionally, the ECAS system ensures Australian animals are tracked beyond demarcation and slaughtered in approved facilities. We're setting the standards for the world. And so I led the Coalition Ag Policy Committee through the sheep country of Western Australia in March this year. I had one meeting in Adelaide. There was 100 people rolled up there, and we staged another 7 meetings across WA, culminating at the Wagen Woolarama. And I'd have to say we went there because the government members would not. We went and talked to the farmers there because government members would not. One of the things we told them was, we will fight for you here in Canberra, but we can't win the battle unless you're prepared to fight for yourself. Well, they showed today that they are more than prepared to fight for themselves. But it's not just sheep that where farmers are being attacked. We have the recommencement of the indiscriminate water buybacks, and others have mentioned that. The closing of the fully sustainable Gulf of Carpentaria gillnet fishing to protect the reef thousands and thousands of kilometres away. Someone should look at a map. Building transmission lines and renewable energy parks all over farming country, and that is even starting to bark in my electorate, I'd have to say. The abolition of the Ag Visa program, reducing the instant tax write-offs, imposing a biosecurity levy on farmers to inspect imports brought into Australia by non-agricultural businesses. I mean, really, abolishing the Native Title Respondents Fund, a commitment to expand Australia's parks and reserve from 20 to 30%, the new vehicle emission standards which punish people who live in regional and remote Australia, in particular farmers. We've got the Scope 3 emissions coming down the pipeline, and some big emitters are buying agricultural land up to offset their emissions. And now we're hearing, I heard the APVMA mentioned by the Minister earlier, and now they are planning, looking like they're going to ban paraquat for all intents and purposes. This is an incredible assault on farmers. But it's not just farmers. They're after the miners as well. And last night I attended the Mineral Council dinner and I heard their CEO, Tanya Constable, laid it down quite clearly what the minerals industry think about what the government is doing to them, and she said that that Labor risks to return in the mining tax wars between the big resources companies and the Gillard government. We want cooperation, not conflict, Ms Constable said. The sector was under siege and being punished by the Albanese government for its success through a stream of reckless, restrictive policies, industrial relations changes, raids on mining royalties, new regulation and a looming threat of onerous and arbitrary environmental approvals. And of course we've just seen in this last week the Blaney gold mine disapproved, if you like, Madam Deputy Speaker. It's something that had already been through all the process and with the local Indigenous owners, and then some fringe group claims to have an interest, and the Minister folded like a deck of cards. No wonder Australian farmers and miners are upset with this government.
I call the member for Spence.
Thank you, Speaker.
Once again, we are confronted in this place with an opposition focused only on believing its own hype. This coalition is totally convinced that nobody knows about agriculture except for them, totally convinced that being on this side of the House removes you from the lived experience of Australian agriculture. In fact, the member for Barker made that point himself before question time today. That sentiment is offensively wrong, and those opposite should dispel that notion. Rather than use it to score political points, let me demonstrate why. Like the member for Barker, referring to his comments earlier, I was also born in a regional community. I also grew up on a farm in Sunraysia. I also know, to quote the member for Barker, what blood, sweat and tears goes into the work of farming families. I watched my parents pour their very heart and soul into our family farm while raising myself and my two sisters. It's work, it's physically and emotionally draining. I lived that experience that the member for Barker spoke of, and I'm proud of it too. I remember clearly when we had our last farm, our vineyard, and I'd have to go off to school in the morning, come home. My father would come in and look after my two sisters, and I'd have to go out on the tractor and work the property just to make sure that we could keep on top of our day-to-day requirements. During the middle of harvest, you get up early in the morning, unwrap all of the dried fruit, rake it out before heading off to school, rinse and repeat every single day during harvest, just to make sure that we made ends meet. I know what hard work is. I've lived those experiences all too often, and I'm proud of it too, extremely proud. I was on the phone just hours ago, just before question time, speaking to growers in my electorate, discussing the concerns that they're experiencing in my electorate. And for those that don't know the electorate of Spence, it's a peri-urban seat, and we have the largest undercover cropping in the Southern Hemisphere. We produce around 1/3 of the state's fresh produce. I'm extremely proud of what we grow in my area. So it's hugely offensive that he would insinuate that I am working against farmers in this country and that I don't know what they're going through. It is absolutely disgusting that the member for Barker would even attempt to make that point, not just because it's completely separate from reality, but because I share the same lived experience as him. And it's even worse that his colleagues would try to back it in with a statement like this. This kind of born-to-rule rhetoric from the coalition when it comes to agriculture, it's become all too familiar in Australian political discourse. And it's incredibly disappointing, because all that talk does nothing to actually improve livelihoods on farms in this country. Instead, that perception tries to weaponise Australian agriculture as a tool to fill a Liberal national ballot box. That agriculture sector deserves so much more respect than that from those opposite. And a Labor government will always show that respect, to take farmers seriously and work with them to produce positive outcomes. That's why we're investing more than $1 billion in new biosecurity funding, to help ensure that our farmers can remain free of disruption and continue to operate effectively as our nation leads the world in biosecurity. Those opposite would have instead persisted with the $100 million drain they placed on that funding while in power, which this government fixed, despite knowing agriculture better than everyone else. Our respect to farmers is why we've opened the doors to a multitude of export markets in cotton, barley, oat and hay, and especially wine, given the foreign policy failure of those opposite which brought winemakers to their knees in 2020. This government has corrected that failure, getting rid of the tariffs in China. $142 million of wine was exported to China in just May alone as a result. We're making farmers more resistant to climate in the years to come to ensure their sustainability. The coalition would rather weaponise our future for their own nuclear ends. We're also scrutinising Australia's food security, taking the necessary steps to ensure supply to the most precious of resources to the Australian people. Of course, those opposite know all of this already, because just by virtue of being themselves, they know everything. Perhaps they aren't quite sure on the resources sector. I'm yet to hear a member state they were born in a copper mine and then use that to justify their point of view. I'm happy to help those opposite on this front too. Our last budget was the most significant investment in resources in a generation, including the $17.6 billion production tax incentive to help secure a future made in Australia. Thank you.
The discussion has concluded. I call the clerk.
Government business. Order of the day number 8. Paid parental leave amendment. Adding superannuation for a more secure retirement bill 2024. Resumption of debate on the second reading.
The question is that this bill be now read a second time, and I call the member for Deakin.
Well, thanks very much, Madam Deputy Speaker. It's an important bill that we will now look at, and I will be moving an amendment, which I'll outline in a moment, in relation to paid parental leave. And I want to state at the outset that whilst the Coalition will be supporting the bill, I will be moving a second reading amendment calling on the government to provide choice to recipients of paid parental leave. Paid parental leave, from the government's perspective, has been quite a tortuous path in that we see on a daily basis the government in here talking about their support for paid parental leave, and those of us with any history or background whatsoever wonder how they can say that with a straight face, particularly those of us who faced the trenchant criticism of the then Labor opposition in relation to the former coalition government's generous paid parental leave scheme, a scheme that the Australian people voted on and the Labor Party opposed vehemently, essentially a wage replacement paid parental leave as it then was. Well, time has moved on, and notwithstanding the very unprincipled position that Labor has adopted in relation to paid parental leave in the past, we have, in opposition, sought to be much more constructive, and where the government has put forward ideas that we have no objection to, we have supported them, and indeed we've supported a range of measures in this House and in the other place in relation to paid parental changes, some that were amendments and changes that were in a sense waiting to be legislated when the government took power after the election in May of 22, and other changes that have been of the volition of the government. This is in that second category, an amendment essentially seeking to extend superannuation contributions onto paid parental leave. Well, the amendments that I'll be circulating, and I move the following amendment, that all words after that be omitted with a view to substituting the following words. Whilst not declining to give the bill a second reading, the House 1 notes the Coalition's strong record supporting government-funded paid parental leave in Australia. 1B. At the 2010 and 2013 federal elections, the Coalition's paid parental leave policy at that time sought to deliver 26 weeks paid parental leave based on actual wage and included superannuation, a policy that was then opposed. C. Both Labor and the Greens opposed the Coalition's paid parental leave policy, and 2. Calls on the government to amend the Paid Parental Leave Act to provide choice to Australian families by giving eligible PPL recipients the option of A. Receiving superannuation on the government-funded paid parental leave payment outlined in this bill, or B. Receiving 26 weeks of paid parental leave from the 1st of July 2025, increasing to 28 weeks from the 1st of July 2026, or C. Receiving a one-off payment equal to the value of the superannuation amount to help with costs associated with the arrival of a newborn or adopted child. So, Madam Deputy Speaker, the amendments that I have moved seek to do two things: to provide parents of a newborn or adopted child with an additional 2 options. They can choose to take the additional superannuation contributions on the PPL payments as outlined in this bill, or they can choose one of 2 additional options. The first being they can elect to take an additional 2 weeks of PPL. So at each stage over the next 2 years, an additional 2 weeks than they would otherwise be entitled to, which is broadly equivalent in financial terms, almost identically equivalent in financial terms to taking the superannuation on those payments, or secondly, adopting to take a one-off payment. We think families, parents are in the best possible position to determine in their own circumstances what it is they need. And for many people, for many Australians, one of the primary purposes for paid parental leave is to provide them with the financial flexibility that they need at a really special and beautiful time in people's lives, the arrival of a newborn or an adopted child. And providing them through this amendment with the optionality of taking those extra 2 weeks, we think is something that the government should absolutely support. And finally, we know how difficult it is. We know how difficult it is for families, just generally, with this cost of living crisis. So providing them with an additional option of being able to take an equivalent amount to the PPL superannuation as a lump sum through existing payment mechanisms, we think is another very worthwhile amendment, which is why I've moved it. And we implore the government to accept these amendments to provide families, if they so choose, with an additional 2 weeks of leave, or with the additional amount, lump sum amount of PPL, because, as I said, families and parents are in the best possible position to determine what is in their best interest at any given time. And we know anyone in this House and anyone watching this who's had a child, many of whom who never had the benefit of PPL, I suspect, know that it is an extraordinarily difficult time financially. And so providing these additional options to parents is treating them with the respect that they deserve. And on that, we hope that the government will see a good idea and will seek to support it. The key measures in the bill, which we don't object to in any way, is obviously to provide the entitlement as part of the scheme, provide the calculation mechanism, and create mechanisms for the Commissioner of Taxation to deal with any under or over payments. Those are all rudimentary mechanical provisions of the bill which we have no concerns with. Obviously, it provides an avenue for recipients to seek review of decisions made by the Commissioner as well, and give the Commissioner of Taxation compliance and enforcement powers as well. Those measures are all contained in Schedule 1. In Schedule 2, there's an additional minor technical amendment to the unpaid parental leave provisions of the Fair Work Australia Act to clarify the entitlement of the defined term keeping in touch days, and amendments to the Income Tax Assessment Act that are consequential to the paid parental leave super contribution related aspects to Schedule 1. It's estimated that 180,000 families will benefit from the changes in the bill when the scheme reaches 26 weeks in 2026. Well, under my amendments that I have just put forward, that will be 28 weeks if that parent and that family chooses to take the extra 2 weeks as opposed to the additional entitlement. The maximum family would receive in super contributions is around $3,000 based on a super guarantee rate of 12%. And for children born or adopted from the 1st of July, parents eligible for the PPL scheme will receive an additional 12%, of course, paid into their complying superannuation fund. So these are all mechanical aspects to the bill that affect the intent. As I said to the government, as I said earlier, we think giving people the optionality of an additional 2 weeks, and for some people that will mean something much more than a financial benefit. For a person who adopts to take an additional 2 weeks as opposed to the additional super on their PPL, for many of them will mean an extra 2 weeks with their child, an extra 2 weeks potentially as the primary carer for their newborn baby or adopted baby that they wouldn't otherwise be able to afford. We think giving people that precious time, or the option of having that additional precious time, is worthy of this amendment. And I'm not sure how the government will be able to argue against providing people with that option of taking that additional precious time with their baby without any additional cost to the Commonwealth. This is all done within the same envelope of costs that the current bill puts in place, and that would equally apply to a family or a parent who adopted to take a lump sum. Taking that lump sum in lieu of taking the additional PPL contributions into superannuation may mean for that individual and for that family that they can spend more time with that very newborn baby. And we think providing families with that option is extraordinarily important. So again, just to summarise without being too repetitive, the amendment that I have moved will seek to provide optionality to families so they will be able to choose one of 3 options under our amendments: take the additional superannuation contributions on the PPL payments, take an additional 2 weeks of PPL leave, which is almost an identical amount to what they would be receiving as additional contributions, or take that exact amount as an additional lump sum at the time when you're bearing all of those costs, all of the costs associated with a new baby, and I could rattle off the long list, and providing those options, we think, treats Australians and treats mothers, treats families with respect that, in the end, they know what's in their best interests. They know what is going to work best for them, and you get the best of all worlds in that they can choose themselves which option they take. So I commend the government to examine the amendment, and I hope that where the government sees a good idea that they are willing to adopt it in the best interests of families and, importantly, in the best interests of children in Australia.
Is the amendment seconded? The member for Bass.
It is seconded.
And you reserve your right to speak?
And I reserve my right to speak.
The original question was that the bill be now read a second time. To this, the honourable member for Deakin has moved that an amendment, that all words after that be omitted, with the view of substituting other words. The question is that the amendment be agreed to. And I call the Minister.
Speaker, I move that the debate on this bill be adjourned to a later hour today.
The question is that the debate be adjourned and the resumption of the debate be made an order of the day at a later hour of the day. All of the opinions say aye. All those contrary no. I think the ayes have it. Clerk.
Government business. Order of the day number 9. Parliamentary Workplace Support Service Amendment, Independent Parliamentary Standards Commission Bill 2024, resumption of debate on the second reading.
The question is that the bill be now read a second time, and I call the member for Deakin.
Well, thanks very much, Madam Deputy Speaker. In relation to the Parliamentary Workplace Support Service Amendment, Independent Parliamentary Standards Bill, I want to reiterate the Coalition has said many times since the delivery of the Set the Standard report into Commonwealth parliamentary workplaces, everyone in this place deserves to have a safe and respectful workplace. All parties have a role in improving and maintaining the good culture of Parliament. This bill represents the culmination of work in both the passage of other legislation and consultation across this building to ensure the process for change in this place hears the perspective of all sides. The Coalition would like to thank the many people across the Parliament who have worked to develop the legislation to bring it into place. In particular, the Coalition would like to thank the independent chair of the Parliamentary Leadership Task Force, Dr Tom, and her staff for their endless patience and commitment. There have been challenges in our workplace, as most Australians would know, and the Coalition has been working with all other parties and parliamentarians to address them. This includes through the Parliamentary Leadership Task Force, its staff consultative group and the work of the Department of Prime Minister and Cabinet. Since the beginning of this process, the Coalition has worked for practical and implementable changes that importantly respect the institution of our Parliament. It's why we accepted and implemented the recommendations of the Foster Review, including an independent complaints mechanism, workplace training and improved independent support services. It's also why the former government accepted the Jenkins Review and committed to working towards all of the 28 recommendations at that time. There have been concrete changes that we have no doubt will make our workplaces more safe and respectful. We now have in place an independent and confidential complaints mechanism for current and former parliamentarians and staff, which this bill will further formalise and enhance by placing it in the statutory Parliamentary Workplace Support Service. We have a confidential 24-hour support service for current and former parliamentarians and staff. We have new training and education programs for all of our staff and parliamentarians to keep our workplaces as safe and respectful as they can be. It was the Coalition that first established the Parliamentary Independent Complaints Mechanism under the first iteration of the Parliamentary Workplace Support Service. That mechanism introduced a complaints process that for the first time was independent from the Department of Finance and its predecessors. This was an important step and completed before the Set the Standard report had been provided to the Parliament. This new independent complaints mechanism had the power to hold parliamentarians as employers accountable for their actions and introduced the concept of referring parliamentarians to the relevant Privileges Committee if they failed to implement recommendations of relevant workplace reviews. It brought new practices to improve the culture of our workplaces, which used the current institution's functions to apply accountability that importantly respects the role of the Parliament in that process. The purpose of the Parliamentary Workplace Support Service Amendment Independent Parliamentary Standards Commission Bill is to establish the final piece in a legislative framework outlined by the Set the Standard report. The bill will create a commission within the statutory PWSS and allow for the commission to investigate breaches of conduct by parliamentarians, their staff and other occupants within the Commonwealth parliamentary workplaces. The commission will comprise 9 commissioners, with one being the chair. The Commission will enforce behaviour codes within the Commonwealth parliamentary workplaces and investigate breaches of these codes when they occur. These investigations will be conducted to establish, on the balance of probabilities, whether the code was breached or whether some other matter relating to work, health and safety in our workplaces needs to be addressed. The process established by this legislation for investigating a matter will ensure confidentiality, appropriate process to deliver natural justice and the necessary fairness to allow for reviews of outcomes. Most importantly, for the first time, this body will be able to place sanctions on those individuals who breach the codes. This is a new element that does not exist in the current regime of the independent complaints mechanism. The sanctions placed on staff and other Commonwealth parliamentary workplace occupants can be recommended directly by the Commissioner to the relevant employer. However, when it comes to sanctions on parliamentarians, this legislation recognises and respects the importance of the Parliament and parliamentarians within our Constitution. It's worth touching on the importance here of the work undertaken by parliamentarians, why we have been afforded parliamentary privilege and are covered by protections under the Constitution. It's a fundamental right of this place to govern itself and its proceedings. The absence from interference from either the judiciary or from the executive is a fundamental protection for the independence of all of us as legislators. But this does not mean that there can be no change or progress, or that we should be unaccountable as employers. This legislation is the result of a careful process in which the last Parliament and the current Parliament have engaged in how to manage the change. All parliamentarians have had to grapple with how best to approach a unique work environment where the employer is constitutionally protected. The opposition wants to acknowledge the government for prioritising this institution and its integrity over rushed expediency. It is right that only the Parliament can ensure that its privileges are appropriate and fit for purpose. It's also worth noting that the first person to commence a process whereby Australia saw updates to the privileges in this place was the father of the member for Wentworth, the former Liberal member for North Sydney, John Spender. But until that point, the privileges of the chamber had not been altered since they were established at Federation. The late Mr Spender acknowledged the fact that there needed to be modernisation, but importantly with respect to the past. Speaking on the Parliamentary Privileges Bill in 1987, he said, and I quote, "I believe that it's necessary for us to come into the 1980s. As Australians, we should state what our main privileges should be and say that there are some privileges which we inherited in 1901 which have nothing to do with the way in which Parliament should run in the 1980s. Today's bill will acknowledge the need to modernise our parliamentary workplaces, but importantly, respecting the important role of the protections that exist for this place. To do so, it's recognised that sanctions on parliamentarians on how they conduct themselves in their work can only be determined by the relevant chamber of Parliament. It will be the respective Privileges Committee that will ensure that parliamentarians adhere to the standards expected and sanction members appropriately. To oversee this new commission and the process of enforcing the behaviour codes, a new joint committee will be established. This committee will be charged with overseeing the operation of the Commission, approve the appointment of commissioners and undertake necessary reviews, including the behaviour codes. While the measures in these bills have the in-principle support of the opposition, at this time the opposition will be reserving its position, noting that the Minister for Finance has committed to our Shadow Minister to consider some minor technical changes to this legislation to improve the operation and to provide clarity. The coalition in government and now in opposition has consistently taken the approach that these matters should remain non-partisan, and we've sought to deal with these by consensus, and we acknowledge that the Labor Party and the government has worked to do the same, particularly when reasonable and sensible compromises can and have been achieved. This is important and appreciated by the opposition, as we have consulted widely since this legislation was made public 1 month ago at its time of introduction. Staff and parliamentarians have provided views to the opposition that there remain, as I said, some minor and technical issues, as well as other concerns that the government will be aware of regarding the Oversight Committee and ensuring, importantly, that the codes of conduct are fit for purpose. The opposition takes these views seriously. In particular, the views of staff which have raised concerns that the codes of conduct were not provided to the relevant employment groups before they were finalised. We appreciate the Minister has recognised the need for bipartisanship in these matters and is therefore taking time to work through these concerns of the staff and concerns of a number of opposition parliamentarians. We note the need for this legislation to pass soon to ensure it can achieve a start date of the 1st of October 2024, and note the government has indicated that it will preference consensus over the timeline. Noting this goodwill, the opposition will assist with passage while the discussions between the Minister and the Shadow Minister continue. I understand that there's been significant good work even in the last few days, for which the opposition is appreciative. We support the improvements that this bill will implement in our workplaces and look forward to the continued discussions with the government as this bill moves to the other place. Thank you, Madam Deputy.
The question is that the bill be now read a second time, and I call the member for Moreton.
Thank you, Deputy Speaker. Throughout my working life, I've been a farm worker. I've worked at Hungry Jack's. I've been a teacher. I've been a lawyer. I've been a union organiser. I've been a policy advisor, and for the last 17 years, a member of Parliament. So I have some understanding of what a safe and respectful workplace looks like. The best workplaces have a fair treatment of all who work there. They respect each other's differences, whether they be in values, religion, culture, sexuality, sporting teams, and so on. Those workplaces have open and civil communication, and they're always acting with integrity. And I would add another: good workplaces have an accountability for employees' actions or employers' actions. In February 2023, both the House of Representatives and the Senate endorsed, on an interim basis, the Parliamentarian Behaviour Codes and the Behaviour Standards for Commonwealth Parliamentary Workplaces. These were developed by the Joint Select Committee on Parliamentary Standards and apply to parliamentarians, to staff and the wider parliamentary workplace. The passage of this bill means that the behaviour codes will be formally adopted. It is worth highlighting the behaviour codes, Deputy Speaker. The headline standards are to act respectfully, professionally and with integrity, to encourage and value diverse perspectives and recognise the importance of a free exchange of ideas, to recognise your power, your influence or authority and to not abuse them, to uphold the laws that support safe and respectful workplaces, including anti-discrimination, employment, work health and safety and criminal laws, and bullying, harassment, sexual harassment or assault or discrimination in any form, including on the grounds of race, age, sex, sexuality, gender identity, disability or religion will not be tolerated, condoned or ignored. The Behaviour Code for Australian parliamentarians states that we have, and I quote, a shared responsibility as employers and leaders in the community to ensure that Commonwealth parliamentary workplaces meet the highest standards of integrity. I say that again, the highest standards of integrity, that they have dignity, safety and mutual respect. And it's a good thing to remind every MP and senator, but also in the lead up to the election next year, every candidate, that it's the highest standards of integrity in this workplace. Unlike every other workplace in Australia, here we expect the highest standards. With the possible exception of early morning sporting events, where some people have unfairly indicated that I occasionally suffer from white line fever, I agree with this statement, that this parliament should have the highest standards. We do not hold these positions lightly or take them for granted. We need to reflect these standards in our daily activity, whether that's here in Parliament or in our electorate offices or when travelling for work. That's why I'm pleased to support the Parliamentary Workplace Support Service Amendment, Independent Parliamentary Standards Commission Bill. This bill directly addresses recommendation number 22 of the Set the Standard report on the independent review into Commonwealth parliamentary workplaces from November 21, probably more commonly known as the Jenkins report. The recommendation 22 states that the Houses of the Parliament establish an independent Parliamentary Standards Commission, or the IPSC, to handle complaints and make findings about misconduct and to make recommendations on sanctions for parliamentarian staff and others who breach codes of conduct. Labor has been committed to implementing all 28 recommendations in the Jenkins report to ensure that this workplace and all of the electorate offices and ministerial offices throughout the country and anywhere else where parliamentary work occurs, because committees do a lot of travelling, that anywhere where there is parliamentary work occurring, that they operate in a safe and respectful manner, as I previously described. This is the standard we should have, and one that proves worthy of the community we serve. This place should be, as the Jenkins report describes, a model workplace. It is fair to say that the lack of clear standards of conduct and the lack of accountability for misconduct has put the Australian Parliament behind most other workplaces. I remember, as I'm sure most people know, Deputy Speaker, you particularly, that when this building opened in 1988, it had 4 bars. Now it has none. One of those bars is a childcare centre that I know my children have been and your children have been. It reflects the modern parliament. That this bill ensures that this will no longer be the case, that we're different to other workplaces in a bad one. Labor intends that the IPSC will start on the 1st of October this year. This body will investigate complaints about breaches of the behaviour codes. It will be an independent body with fair, impartial and confidential processes, and it won't be toothless. If the IPSC decides that there's been a breach of the behaviour codes, it will be able to directly impose sanctions on MPs. The sanctions may include training, behaviour agreements or reprimands. Serious findings will be referred to the relevant Privileges Committee to recommend appropriate sanctions. I'm sure all of us in this place agree with these measures and with the concept of holding each other to account for respectful behaviour at work. Any sanctions implemented by Privileges Committee will become public. The Jenkins report states that taking steps to prevent and respond to misconduct effectively has several benefits. Not least of these is improved conditions for employees. And I quote, establishing Parliament as a model, safe and respectful workplace, it will help to attract and retain the best staff in a competitive labour environment, support high performance in a complex operating environments and support diversity and better democratic representation and decision making. This bill builds on Labor's leadership in bringing reforms to the parliamentary workplace. In 2023, the Albanese Labor government worked closely with the cross-party Parliamentary Leadership Task Force and its staff consultation group to establish the Parliamentary Workplace Support Service. I would like to extend my thanks to those who participated in this process that will benefit us here in this chamber, our colleagues and our staff. And I especially want to thank one of my indefatigable comrades, the member for Newcastle, who made a great contribution in steering that process, the Deputy Speaker, in a more respectful way, obviously. The remit of the PWSS is to provide independent and confidential human resource advice to create and maintain safe, respectful and inclusive workplaces. This encompasses workplace health and safety support, well-being, workplace reviews, conflict resolution and early intervention to all who work or volunteer in Commonwealth parliamentary workplaces. The PWSS is driving cultural change in response to the Jenkins report, and the IPSC will continue the charge. It is important to us that the reforms hit the mark, which is why there has been careful consultation with the Parliamentary Leadership Task Force. The IPSC will be established as part of the PWSS while retaining a functional separate between its investigatory function and the daily operations of the PWSS. Currently, the PWSS has the power to undertake workplace investigations. This function will sunset, hopefully, all going well, on the 1st of October in order for the IPSC to operate. Going forward, we anticipate that the PWSS will still be the initial recipient of any complaints or reports, and that the IPSC will not investigate any issues that are better off addressed through the complaint resolution function of the PWSS. If the complaint is determined to need an IPSC workplace investigation, PWSS could assist the complainant in their initial dealings with the IPSC. Employees in Commonwealth parliamentary workplaces have existing obligations under workplace health and safety legislation. It's important to note that the IPSC complements these existing laws. It does not require additional reporting, but it does provide an additional pathway if appropriate. Again, the PWSS can assist in determining if a complaint is best suited to existing work health and safety laws or via the IPSC. It will operate as the set the standard report recommended. The structure of an investigation acknowledges that parliamentarians are elected members, so 3 commissioners will make the final deliberation for a parliamentary respondent. In the case of a staff respondent or other worker, a single commissioner would make the decision. There are pathways for internal review of decisions, and in these circumstances, 3 commissioners would do the review. It's intended that the behaviour codes be adopted into the standing orders for both the House of Reps and the Senate. That's in line with recommendation 2 of the Joint Select Committee on Parliamentary Standards report. and the behaviour code for staffers will be formalised under the Members of Parliament Staff Act. Going forward, the PWSS will provide training on the behaviour code so parliamentarians, their staff and others who work in Commonwealth parliamentary workplaces will understand their obligations, and the standards will be reviewed within 1 year of the first session of each new parliament, keeping them front of mind for all. The Albanese Labor government has committed $3.8 million to establish the Independent Parliamentary Standards Commission. This is an important reform which must be taken seriously. Obviously, Deputy Speaker, I believe that this is the best country in the world and we have the best parliament in the world. But it can still be better and can still be improved. As the song goes, rust never sleeps. We must keep trying to improve this building and all who dwell in it. The behaviour codes and the IPSC will work together to set expectations for safe and respectful workplaces and add accountability for actions. Deputy Speaker, we all have a part to play now and ongoing, and that's why I'm happy to commend the bill to the House.
The question is that the bill be now read a second time, and I call the member for Indi.
Thank you, Madam Deputy Speaker. I'm very pleased to rise to speak on this bill. After years of advocacy from many corners of this country, we are finally seeing laws that establish a robust, independent Parliamentary Standards Commissioner. It's been a long time coming. When I was first elected to Parliament in 2019, I, like others, was shocked to learn there was no code of conduct for members of Parliament and a complete lack of accountability for parliamentarians and parliamentary staff who breached the most basic workplace behaviour standards. Across the hospitals and universities that marked many years of my career, the high professional standards expected of me and my colleagues had always been clear. As a nurse and an academic, I could see how codes of conduct and independent complaints procedures offset the risk of power imbalances and harmful workplace environments from forming. These exist for judicial officers, journalists, barristers, medical professionals. Codes of conduct for parliamentarians also exist in many other democracies, Canada, New Zealand and the United Kingdom. This workplace, the Australian Parliament, should be no exception. But like many Australians, I was appalled by the behaviour of some elected representatives that would not be tolerated in other workplaces. Behaviour that, in the absence of clear standards and, importantly, enforcement mechanisms, has been allowed to fester. Of excessive alcohol consumption within parliamentary offices, of unashamedly hosting political fundraisers with major donors inside this building, of the use of taxpayer-funded flights used for holidays, sports events or to host private fundraisers, and of course, the terrible, traumatic, unacceptable rates of bullying, sexual harassment and even sexual assault. These are all examples of unethical, toxic behaviour that should not be accepted in any workplace, let alone in the workplace of representatives who must uphold the highest standards expected of public life and of elected office. These are behaviours that have gone on without any consequences for too long or become another rolling news headline. But these aren't unsubstantiated rumours within the Canberra bubble or media reports that haven't gone anywhere. The Australian Human Rights Commission set the standards report into Commonwealth parliamentary workplaces in 2021, led by Kate Jenkins, clearly found an unacceptably high number of people, in particular women, experiencing bullying, sexual harassment or actual or attempted sexual assault in Commonwealth parliamentary workplace settings. We all know the grave impacts of this. Even before the Jenkins review, I sat with brilliant people who came to me to tell their stories of their experiences in this place. People full of potential who came here to contribute to their country, who were then dealing with the consequences of a culture which enabled harm, then disbelieved and sidelined them when they tried to speak up about that abuse or about unethical behaviour that they witnessed. I thank those people and the many people who came forward subsequently for their bravery. It's their actions that sparked us to progress reforms like this one. As an MP with staff that I'm responsible for, I do not want them to feel threatened or experience harm in their workplace. As an MP who hosts volunteers from my electorate in Parliament every single sitting week and interns from universities, I want their time here to be a catalysing moment that shapes their lives, not one that casts a long shadow. Those who have come forward with their experiences undoubtedly set the wheels in motion for reform, and I want to acknowledge the many people who then listened to them and championed their cause. I want to acknowledge the work of my predecessor, the first independent member for Indi, Cathy McGowan, who in 2018 brought a parliamentary standards bill to the Parliament. I have then followed this work with my own parliamentary standards private members bill in 2020 that was introduced alongside my bill for a Federal Integrity Commission. Once again, we are seeing a bill before Parliament that has reached consensus support, just like the National Anti-Corruption Commission, after the hard work and relentless advocacy of many, especially the independents on the crossbench. I want to particularly acknowledge the work of Kate Jenkins and the Australian Human Rights Commission. This independent Parliamentary Standards Commission implements one of their final outstanding recommendations. When they were writing their report back in 2020, I was pleased to share detailed information about my own private member's bill with them, and I thank them for listening to me and for their vital work in reforming this Parliament's workplace culture. I want to thank the Parliamentary Leadership Task Force, which includes representation from across the political spectrum. They worked hard to reach agreement on this bill despite political differences. I thank the work of the Staff Consultative Group, which includes a member of my own staff. It's important that everyone who works in Commonwealth parliamentary workplaces has had a say in this bill. I also acknowledge the work of the Joint Select Committee on Parliamentary Standards, led by the Deputy Speaker, the member for Newcastle. Thank her for her leadership and outstanding contribution. The committee has been particularly instrumental in formulating the behaviour standards in the Code, and I thank them all for their work. Even though this bill directly impacts those who work in Commonwealth parliamentary workplaces, it is vitally important to those who exist outside the Canberra bubble. It is, of course, voters, everyday Australians, who expect their representatives in Parliament to uphold their values, to behave to the highest standards, even if those standards might seem like basic professional conduct. Unfortunately, this expectation of the Australian public has not been met for some time. It is these scandals and more that are chipping away at the trust Australians have in government, in democracy, in all of us here in this place. According to Transparency International's 2023 Corruption Perceptions Index, Australia's ratings has dropped 10 points since 2012. And there are many factors that we can attribute to the worsening perception of corruption in Australia's public sector: pork barrelling, jobs for mates, lack of accountability for serious corruption. But the poor behaviour, the unethical behaviour, seemingly without consequence of elected representatives is, without doubt, a key contributor to Australia's failing trust. If we, as parliamentarians, want the trust of the Australian people, if we want them to trust in government and in democracy, we have to show that bad behaviour won't be swept under the rug, that there are consequences, that we are holding ourselves accountable. There's many reasons why the Jenkins report is called Set the Standard, because we must set the standards in this workplace and demonstrate that to the nation. This bill is a significant step towards achieving that. The bill will establish an independent Parliamentary Standards Commission to enforce behaviour codes and apply sanctions for parliamentarians, parliamentary staff and others working in the parliamentary setting. These behaviour codes set clear standards for behaviour and consequences when MPs and staff do not meet those standards. They are endorsed by both Houses of Parliament in 2023. They include basic yet fundamentally important standards that parliamentarians and their staff must comply with. And these include to act respectfully, professionally and with integrity, to recognise your power, influence or authority and do not abuse them, to have a shared responsibility as employers and leaders in the community to ensure parliamentary workplaces meet the highest standards of integrity, dignity, safety and mutual respect. A prohibition on bullying and harassment, sexual harassment and assault and discrimination, and the requirement to cultivate respectful and inclusive workplaces. The Joint Committee on Parliamentary Standards heard from many witnesses who made it clear that these codes would not be able to drive the long-term cultural change that is needed unless there is a confidential, independent and serious investigative body with an effective sanctions regime. And this is what the bill before us ultimately attempts to achieve. Under the bill, the Independent Parliamentary Standards Commission has powers to receive and investigate complaints against parliamentarians and staff. There are important safeguards, including that the Commissioner can decide not to investigate a complaint if it is frivolous, vexatious, or may be dealt with by another appropriate body. For parliamentarians, a panel of 3 commissioners make decisions about whether that parliamentarian has engaged in misconduct. They could impose a less serious sanction, such as a reprimand, training requirement, or behaviour agreement. If they believe a more serious sanction is warranted, such as a fine, discharge from a committee, or suspension from Parliament, they must refer the matter to the Privileges Committee, and I will address this more in a moment. For staff, a single commissioner would make the decision whether they've engaged in misconduct and make a recommendation to the relevant employing parliamentarian about an appropriate sanction. If a respondent or complainant wants to review any of the Commission's decisions, this review is conducted by a panel of 3 commissioners. The bill reflects key elements of my own private member's bill to ensure the Independent Commissioner conducts investigations with appropriate safeguards to protect rights to procedural fairness, rights to privacy and the protection of personal reputation. The bill also sets up appropriate oversight mechanisms in the creation of a Parliamentary Joint Committee on Parliamentary Standards. Now, this committee has important functions to protect the independence of the Commission, such as the appointment of commissioners. They will also be responsible for undertaking a review of the behaviour codes. I also note that the Parliamentary Leadership Task Force agreed to a review of the Independent Parliamentary Standards Commission itself after 18 months after the commencement of the Parliamentary Workplace Support Services, and the government have budgeted for such a review. And this is important to make sure these new bodies are operating as they should and to make any necessary adjustments. Now, I want to briefly address any concerns that by upholding parliamentarians accountable for bad behaviour, this bill may hamper robust debate in Parliament. Robust debate, a contest of ideas that serves the public interest, is a core function of Parliament. I absolutely agree with this. But debate must still occur with respect. At the end of the day, parliamentarians are models of behaviour for their staff, for other MPs and for the public. The establishment of a Parliamentary Standards Commissioner recognises and upholds this. I support this bill, but I want to acknowledge that it is not perfect. As I mentioned earlier, if the Commission makes a finding against a parliamentarian that would attract a serious sanction, fines, suspension, discharge from a committee, they must refer this to the Privileges Committee. The Commission does not make a recommendation of which sanction would be appropriate, and the report they provide to the Privileges Committee would not be published nor tabled in Parliament. It's then up to the Privileges Committee to make a finding against that MP and recommend a sanction for the Parliament to vote on. It's also up to the Privileges Committee to name that MP in any reports it makes to Parliament. And I share the concerns of many with the aspects of the bill that refer to this. According to Fair Agenda, who have undertaken significant work on these reforms, I share this concern. Because this means serious findings could not be made, or could be made about an MP, but they could face no sanction and the public might never, or will never know. And that's a problem. Bad behaviour of parliamentarians should not be swept under the rug because of the nature of the office that they hold. We are legislating not just for now but for the future. We frankly don't know how future Privileges Committees will operate, even if the one that exists now is robust and non-partisan. We must ensure the Commission and the Privileges Committee operate with transparency if we want the public to trust in the new frameworks established through this bill. That's why I support any amendments moved that would allow the Commission to make recommendations to the Privileges Committee of serious sanctions against parliamentarians, and that requires the Privileges Committee to table reasons where its findings differ from recommendations of the Commission. I urge the Government and the Opposition to listen to these concerns and support these amendments. Finally, I want to acknowledge that this bill has achieved the broad support of all major parties and from many independent members in this place. Consensus decision-making is a significant achievement at any time in this Parliament. We should not underestimate. With one voice, we recognise that we must do better, that we must meet the standards the public holds us to and that we hold ourselves to. And it's up to us now to make this a safe and respectful workplace, and a workplace that attracts the highest calibre of people in our society to come and work in this place. I commend this bill to the House.
The question is that the bill be now read a second time, and I call the member for Chisholm.
Thank you so much, Deputy Speaker. I remember very well in 2022, during the election campaign, knocking on doors in my electorate of Chisholm, and the issue of trust in institutions, in Parliament, in the government, and integrity were a really big deal. And at the heart of some of these conversations every single day was the issue around gender equality and the experience of women in this place. And indeed, it was a frequent question I had on the doors with my now constituents asking me, how will you go in that place? This is a really important issue in my community and in communities right across the country. People expect to see consequences for bad behaviour here. And this institution really does matter. It must be a place that does set the standard, where integrity, respect, accountability and inclusion are at the centre of everything we do here. And this must be a safe workplace. I want to acknowledge everybody who did so much work to bring this bill to the House today, including the member for Newcastle, Minister Gallagher, Kate Jenkins, and the hundreds of people who participated and contributed to the Set the Standard inquiry. And here I want to say that I contributed to the Set the Standard inquiry before I was a candidate to run in this place, not knowing that I would end up here. And the reason I want to be a bit personal here, Deputy Speaker, is for a number of reasons, including that yesterday we had a celebration of affirmative action in the Labor Party, marking 30 years of rules changes in the Australian Labor Party. And I think what I have been reflecting on has been that we bring our whole selves to this place, and that there is a reason that we have fought to have more female representation on this side of the House. It's to make the kinds of changes that need to be made in this country. And so I will say that I participated in interviews and completed surveys during the Set the Standard inquiry process, because about 10 years ago I worked here, and I do not believe I worked in a safe environment. And I do not intend to detail discrete experiences here in the chamber today. But I want to do everything that I can, now that I'm a member in the House of Representatives, to make sure that this place is a safe and respectful environment. I take my responsibility as an employer very seriously, and I take my responsibility as a woman in this place very seriously. And I want to make sure that there are real and meaningful consequences for bad behaviour. I'm also really sad to reflect on the fact that people I know, people that I care for and are my friends, have had their careers cut short due to the environments that they've worked in here. Whilst others, who very well may have misbehaved, have thrived. This isn't fair. This isn't fair at all. And so the bill before us today will make a real difference in the culture in this place and the experiences of workers in this place. And it is an incredibly important achievement from everybody who worked on it. Since the Set the Standard report was first handed down, the Labor Party has been committed to implementing all 28 of its recommendations. Of course, parliamentary workplaces, like every other workplace in this country, should be safe and respectful for everyone. Last year, the government, working with the Parliamentary Leadership Task Force and its staff consultation group, established the Statutory Parliamentary Workplace Support Service. The PWSS, The Parliamentary Workplace Support Service commenced its enhanced operations in October last year, providing centralised human resources support to parliamentarians and their staff. The PWSS also provides services to a broader cohort of people who work in the Parliament to support a safe and respectful workplace. This bill will establish the Independent Parliamentary Standards Commission. And this entity will be able to investigate complaints about breaches of behaviour codes that will apply in the parliamentary workplace. Its commencement will mean those codes can finally commence. It will have fair and confidential processes, it will be independent, and it will be impartial. Our government has worked really closely with parliamentarians through the PLT staff and others across Parliament to get these important reforms right, so that when serious workplace issues arise, people have recourse through an independent investigation and real accountability for those doing the wrong thing. We've also sought to align as much as possible with the approach and recommendations of the Set the Standard report, whilst balancing the need for the legislation to carefully interact with the role of the Parliament, which is, of course, a unique workplace. We've sought really carefully to strike this balance. The IPSC would be established as part of the PWSS. There's going to be a functional separation between the IPSC's investigation function and the PWSS's functions. Nevertheless, they will work together in complementary ways, and it is intended that the PWSS will continue to be the front door for complainants, although a complaint could be made directly to the IPSC. The IPSC would not commence investigations that would be better addressed through the PWSS's complaint resolution function. As an independent and impartial body, the IPSC is well placed to undertake investigations and determine whether misconduct has occurred. Their process is very important in all of this. The IPSC will be able to directly impose sanctions on MPs, including training, behaviour agreements and reprimands, and will refer serious findings to the relevant Privileges Committee to recommend appropriate sanctions to the Parliament. This is really important in restoring faith in institutions that we know globally are in decline, and including in Australia. People do expect parliamentarians to behave in a way that demonstrates integrity and accountability, and this body, I think, will enhance that part of the role of an MP. The relevant House Privileges Committee will then be responsible for considering the appropriate sanction and would be required to report to the Parliament with their recommendation. This would require a public report and ensures they are accountable for their recommendation to the Parliament. And this is consistent with the long-standing convention of the Parliament appropriately holding members to account. Passage of this legislation will help finalise the implementation of government recommendations from the Set the Standard report. This was a historic report, and as I noted earlier, the government accepted the recommendations, and so this really means that we are being good faith operators in relation to what we believe are our obligations from those recommendations in the report, and honouring the evidence that so many people generously and courageously gave to the inquiry. As I mentioned earlier, there were hundreds of people that were involved in that process. This legislation will help ensure this workplace is able to lead by example and is safer for everyone, for parliamentarians, for staff, for everyone who works in this building and in other parliamentary workplaces. Parliament House is a unique workplace. We do want to attract the best here, and we want everyone who works here to have an enriching and fulfilling experience. Nobody's career should be cut short because they were subjected to inappropriate conduct with no recourse to any kind of action against any alleged perpetrator. We all here have a shared responsibility to make sure people who work in this building and in other political offices are able to do their job in a safe way, and where they're confident that the systems and supports are there for them when they need them. I think set the standard as a title for the report is incredibly important, and I also reflect on the perhaps cliched maxim, the standard we walk past is the standard that we accept. But I think it is really important that all of us here recognise the responsibility we collectively have to make sure that we are all paying attention and making sure that standards do not slip, and that everyone here is included, respected and safe in this workplace and other parliamentary workplaces. We've taken time to get this right. I'm really pleased that we are here today speaking about the Independent Parliamentary Standards Commission, and I hope that this will mean that in the future, if things go wrong, and we absolutely hope they do not, and that the culture in this place improves, that there will be meaningful consequences that will be able to be delivered. And I'm very pleased to commend this bill to the House. Thank you very much, Deputy Speaker.
The question is that the bill be now read a second time, and I call the member for North Sydney.
Thank you, Deputy Speaker. It's been 3 years since the Australian Human Rights Commission set the standard report into the independent review into Commonwealth parliamentary workplaces, and 2.5 years since the North Sydney community sent me here to fight for the reform that report recommended. It's frustrating it's taken so long to see legislation that establishes the Independent Parliamentary Standards Commission, or the IPSC. Yet, having now seen this place from the inside out, I'm not surprised. And the continued pushback says everything that needs to be said about the resistance of the old guard in this place to change. In 2022, Australians, particularly Australian women and their allies, sent a clear message to our federal parliament that enough was enough. For while this bubble, as it's often described, sees itself as existing outside normal community expectations, everyday Australians disagree. The people we serve expect more from us. And while we have made some progress, there are many in this place determined to do everything they can to block reform because they're quite simply threatened by it. This legislation represents tentative steps in the drive to reform by establishing the IPSC, and I thank the Parliamentary Leadership Task Force for producing it. The independent review into Commonwealth parliamentary workplaces was established following numerous reports about the toxic workplace culture in this system. Run by the then Sex Discrimination Commissioner, Kate Jenkins, the review followed allegations of rape, bullying and abuse of power by former and current ministerial staffers, and came in the wake of growing public anger about the treatment of women. That anger came to a head during the March 4th Justice rallies, attended by over 100,000 women and their supporters, including 10,000 outside this very building, and was further evidenced by the emergence of people like me, who stood as community independent candidates in the 2022 election. As a consequence, we now have the largest crossbench ever in the history of our parliament, one dominated by people who were committed to fighting for integrity in this place. This bill is designed to make this place a safer and more inclusive work environment. With over 4,000 people working in Parliament House every day and thousands more in electoral offices or visiting parliamentary spaces, it's an important piece of reform because it finally provides an independent avenue for people, from parliamentarians to staff, parliamentary and service employees, and all who work in this environment, with a way to raise a complaint when they experience behaviour that they feel breaches a common understanding of what is acceptable. As a member of the Joint Parliamentary Select Committee that developed the Codes of Conduct and the behaviour standards in late 2022, the importance of this legislation as a next step is not lost on me. The expectation has always been that the codes would set behavioural standards that would be binding, and if breached, there would be consequences. The absence of clear standards of conduct have left the Australian Parliament out of step, not only with other jurisdictions and other workplaces, but importantly with our community. Reflecting on the response to this bill then, the very fact that there are those in this place who argue enforceable standards are not necessary concerns me greatly, and is, I think, the strongest indication yet that the old guard in this place are fundamentally out of step with our wider community. Some from the opposition have even gone as far as to suggest establishing a mechanism for enforcing standards of behaviour would deter people from politics. And I've got to say, that's just rubbish. If someone is deterred by behaviour standards, they probably have no place being here in the first instance. And indeed, I'm pretty sure they'll struggle to find work anywhere, because behaviour standards are common in every work environment. And reform like this is more likely to encourage people to consider careers in this space, because it will make politics more attractive for a diverse range of people, from women to younger people to people from migrant backgrounds, LGBTQIA+ people and Indigenous Australians, because the establishment of this body will help build trust. While the bill is welcome, it ultimately falls short of the vision laid out in the Set the Standard report and recommended by the Joint Parliamentary Committee, and this is disappointing. As it stands, there is no guarantee findings of parliamentary misconduct will be made public, and the ability to make independent sanctions in cases of serious misconduct has been left to the discretion of the Privileges Committee rather than the IPSC. The scope of the behaviour standards is also disappointingly limited to parliamentarians' conduct in the course of their role and pursuant to parliamentary privilege. Each of these weaknesses represents a significant dilution of this reform. The lack of transparency and true independence in the process means that while the IPSC will be tasked with investigating referrals, their capacity to move and recommend sanctions will be limited to the scale of the breach. If the breach is considered minor, the IPSC will be empowered to act. If the breach is more significant, the IPSC will be required to refer the matter to the Privileges Committee, which in effect means consequential steps will be shrouded, and it's akin to empowering arsonists to put out their own fires. This weakening of accountability flies in the face of the Set the Standard report. Whether the established system likes it or not, Australians want to see parliamentarians in this place held to the same standards that apply in other work environments. And I can confidently predict most people will see this exclusion as politicians yet again looking out for themselves. Turning the light on poor behaviour is the quickest way to effect change, and for this reason I believe greater transparency and independence in this process is imperative. By placing the IPSC in a position where it must refer cases of serious misconduct to the Privileges Committee, this legislation significantly weakens the body. To be clear, I believe the process of investigation proposed in this legislation is reasonable, with a panel of 3 independent commissioners looking into any case that involves a parliamentarian. If the Commission finds misconduct, they will consider the appropriate sanction. In less serious cases, the IPSC can impose non-parliamentary sanctions, including a reprimand, requiring the member to undertake training or to enter a behaviour agreement with the IPSC. If the Commission determines the breach is serious, however, the matter will be referred to the Privileges Committee of the relevant chamber, and that committee will then decide whether to recommend a sanction. These sanctions may include fines, a discharge from a parliamentary committee, or a suspension from Parliament, among other things. However, this approach is a departure from the recommendations of the Set the Standard report that specifically stated it was critical the IPSC be able to make independent recommendations. Quoting the report, "An independent mechanism and structural independence from parliamentarians and political parties is imperative to ensure a standards and accountability system is able to fulfil its accountability, deterrence and public confidence objectives." The ability for the IPSC to recommend serious sanctions was endorsed by the Joint Committee into Parliamentary Standards, and it is already a feature of the Parliamentary Standards legislation recently introduced in Victoria. Indeed, a joint investigation conducted by IBAC and the Victorian Ombudsman not only recommended a process for independent recommendations for serious sanctions, but also recommended that the Privileges Committee of each House be reformed to dilute the capacity of the majority in each House to determine the Privileges Committee's priorities and decisions-making. In addition to this, as it currently stands, there is no requirement that the findings of the IPSC investigation will be made public. This is unlike in the UK, where the findings of the independent body are published along with their recommended sanctions when a Member of Parliament has been found to be in breach of a code of conduct. While I understand there may be circumstances where someone who has made a referral may wish to remain anonymous, I think the expectation that those who have been found to be in breach of the code are protected by secrecy is a serious flaw in this legislation. I also believe the IPSC should be given the scope to address any conduct that brings the Parliament into disrepute, including conduct that is currently protected by parliamentary privilege or happens outside the normal scope of our roles. As drafted, the IPSC will not be able to investigate allegations of poor behaviour that happen in this chamber or during the proceedings of Parliament, nor will it be able to investigate allegations of bad behaviour that occur outside the normal course of work. This is again a departure from the Set the Standards report, which recommended an approach which was more consistent with that which already exists in the United Kingdom House of Commons and the Scottish Parliament. Parliamentary privilege has long been an obstacle to behavioural reform here, with it often seemingly interpreted as an entitlement for parliamentarians to behave however they want. But I believe that interpretation is flawed and that parliamentary privilege should not elevate us above the people who elect us. The impunity it provides should come with responsibility and should not be exploited or used to resist regulatory changes to govern conduct. The evidence received during the inquiry into parliamentary standards was largely supportive of behaviour codes applying to all parliamentary proceedings, with even the President of the Senate, the Honourable Sue Lyons, giving evidence that the presence of a clear set of standards would be helpful in managing behaviour in the chambers. At the same time, multiple submissions pointed to the experiences of other parliaments that have implemented codes of conduct, including the United Kingdom, where misconduct is placed outside the protection of parliamentary privilege. The Set the Standard report asserted that while parliamentary supremacy needed to be recognised, the powers of the IPSC should be delegated from the House of Parliament. By doing so, the IPSC's investigations would not conflict with parliamentary privilege because the scheme remains within the Parliament. Ultimately, if we can't agree behavioural expectations should apply to us in all circumstances, we will have not only missed the opportunity to set a meaningful standard of behaviour in this place, but we will have failed to meet our community's expectations. There is much more to do to ensure the behaviour in our federal parliamentary system meets the standards our public currently rightly expects. And while people like me can come here to deliver that message to the major parties, ultimately it's on them to get with the program and show they can change to meet modern expectations. The distinction between legitimate, robust debate and harassment, sexism and bullying continues to be something many in this place struggle to understand. Many of these same people continue to mistakenly think Australians want to see a performative contest and that Australians like the aggressive and combative behaviour that they see, while those same people hide behind an argument that the Westminster system is traditionally adversarial. But they are missing the fact that everyday Australians want to see us challenge that highly gendered institutional legacy. After all, they did it in the UK. Why can't we? Each time poor behaviour in this place is called out, I am inundated with messages from the community. People call my offices, they send emails, and they call in en masse during radio interviews, as was the case when I recently spoke with Richard Glover on the ABC and he opened the phone lines. And the resounding message is consistent. This must stop. People are fed up with their elected representatives behaving like overindulged children. And as someone who has worked her entire life in often male-dominated environments where debate was part of unlocking great ideas, I can guarantee the behaviour we see in this place every day would not be tolerated in any other workplace. Yet while parliaments, including in Wales and Northern Ireland, have banned parliamentarians from subjecting others to unreasonable and excessive personal attacks and have prohibitive language that is sexist, racist, homophobic or otherwise exclusionary or discriminatory, in a bid to improve everyday respect in their chambers, it would seem the major parties in this parliament are paralysed by the idea of ambitious reform and accountability beyond a 3-year election cycle. Improving everyday respect in this place would not only benefit those who work here, but also those who watch, because the norms exhibited here influence our society more broadly. If we cannot agree that it's not okay to yell at or harass each other when we disagree, how can we expect a man prone to dominance in the real world to allow his partner to express a divergent opinion at home? This very issue was noted in the Set the Standard report when one participant shared that, and I quote, "You're constantly in that adversarial environment with people just constantly arguing, yelling and screaming across the chamber. So if it's acceptable there when the public is watching, it must be acceptable in my office when the doors are closed." Clearly, not only embracing but enforcing behaviour standards here would have positive outcomes across both our work environment and, more broadly, our community. But for it to work, all of us in this place must accept that this workplace should reflect the nation's values and meet our community's expectations. While this bill is welcome then, it is weaker than many had hoped. And for this reason, I move the amendments circulated in my name. We must continue to advocate for greater ambition to not only ensure any parliamentary workplace is respectful and inclusive, but ultimately to ensure it reflects everything our community wants us to be. Thank you.
I thank the honourable member for North Sydney. Is the amendment seconded? I call the honourable member for Goldstein. Order. The original question was that this bill be now read a second time. To this, the honourable member for North Sydney has moved as an amendment that all words after that be omitted with a view to substituting other words. The question now is that the amendment be agreed to, and I call the honourable member for Newcastle.
Thank you, Deputy Speaker, and I rise today to support the original content of this bill to establish an Independent Parliamentary Standards Commission, or an IPSC. The bill represents a critical step towards enhancing the integrity and accountability of our Parliament. In 2021, reports of bullying, sexual harassment and sexual assault in our Parliament justly shocked the nation. It highlighted the need for urgent reform to ensure that all Commonwealth parliamentary workplaces are safe and respectful places to work. And it resonated with the community as well. Indeed, tens of thousands of people took part in marches for justice, as they were known, rallies right across Australia calling for an end to gender-based violence and workplace harassment. The public were demanding change, as were voices from all parts of the parliamentary ecosystem. And these demands culminated in the Australian Human Rights Commission being engaged to conduct an independent review into Commonwealth parliamentary workplaces, or CPWs. Led by the Sex Discrimination Commissioner, Kate Jenkins, this review lifted a lid on parliamentary misconduct and found 1 in 3 people surveyed across the federal parliament reported being sexually harassed on the job. The review uncovered some shocking discoveries. For example, 51% of those surveyed for the review had experienced at least one incident of bullying, harassment or actual or attempted sexual assault in a Commonwealth parliamentary workplace. 1,723 individuals added their voice to the review, as well as 33 organisations and collectives. This included 935 survey responses, 490 interviews, 302 written submissions and 11 focus groups. I won't read the testimonies from that report because I have gone to some of that in previous speeches, but it is very sobering reading, and all members in this parliament should take the time to read that report again. I think suffices to say much of that testimony was genuinely heartbreaking, some of it infuriating, and some of it just downright disgusting. And we should never lose sight of that. The 2021 report of the review, entitled Set the Standard, was a thorough and broad-reaching review. It made 28 recommendations for improving safety and culture in our workplaces, including an expansion of the Parliamentary Workplace Support Service, the establishment of a Joint Select Committee on Parliamentary Standards to inquire into and report on matters relating to the development of codes and conduct, and the establishment of an Independent Parliamentary Standards Commission with responsibility for enforcing the codes of conduct. And that's this bill before us today. As part of Labor's statement of acknowledgement to the Parliament back in 2022, The government committed to implementing all recommendations of the report. And I've got to say, as somebody who's been in this parliament for 11 years now, where we are today, I'll come back to it whilst everybody, you know, there are some people who want to see more and there are some people who don't want this to see the light of day, right? But 11 years ago, it was unimaginable that this bill would even be before the House. Yeah. Unimaginable. So I just think it is, you know, I'll come back to that a little bit later, but it is as infuriating and as slow as change can be at times. We have to recognise that these are all very important steps we make towards a journey that we all have to collectively sign up to. In February 2022, I was very privileged to be appointed the chair of the Joint Select Committee on Parliamentary Standards. It was tasked with bringing together a group of 11 parliamentarians from diverse, right across the political spectrum, people from the Senate, people from the House. I want to acknowledge the work and contribution of the member for North Sydney and indeed her speech just earlier, and I want to acknowledge the members from this House, the members for Ryan, Bean, Caldwell, member for Forrest, and the senators that joined us, because this was a committee that was quite exceptional, really, in its work. Seldom is a parliamentary committee asked to draft legislation or codes of conduct, as the case might be, for the work that was before us. We were asked to draft 3 codes of conduct. One that was specifically for parliamentarians, one for parliamentarian staff, and one for all other occupants and people who come in and out of Commonwealth parliamentary workplaces. The need and indeed the public expectation for codes of conduct was not new. You know, this House has in fact debated this for more than 50 years now. And we've been considering these codes. It has come before the Parliament on 4 separate occasions, and spectacularly unsuccessful were these previous parliaments embedding down some codes of conduct. So to have them introduced was an incredible achievement for this 47th Parliament. And I acknowledge the hard work of all members of that committee. It had been, as I said, a long-standing failure of successive parliaments where codes focused on conflicts of interest and broader ethical concerns rather than ensuring safe and respectful workplaces. All those other codes of conduct did not see the light of day. We wanted these codes to be part of a suite of reforms that created long-lasting cultural change in Commonwealth workplaces. The draft codes underwent extensive consultation with parliamentarians and staff, parliamentary department employees, public servants, the press gallery, lobbyists, the other people that work in or visit our workplaces. And the committee conducted staff surveys, considered submissions, consulted with expert stakeholders, held public and private hearings, considered codes of conduct in similar comparable jurisdictions, such as the British Parliament. We chose to collectively call them behaviour codes instead of codes of conduct because we wanted them to reflect the standards of behaviours that we expect in our workplace. The committee eventually had a consensus report made of 16 recommendations and included 3 draft behaviour codes. As I said, one for the parliamentarians, one for our staff, and one for all other people entering and working in Commonwealth workplaces. Included in the recommendations were the development of guidance materials for those codes as well, the frameworks for continued review and monitoring, support for a body to apply sanctions for breaches of the codes, and for both houses of Parliament to adopt interim codes ahead of the development of this sanctioning body. The draft behaviour codes have since been endorsed by all political parties and the independents, both in the House and the Senate. I acknowledge the power and strength that comes from that collective action should not be underestimated. This is an Australian first. I look forward to them being adopted by both Houses of Parliament following the passage of this bill. There will be nobody happier in this House than myself, other than perhaps the member for North Sydney and everybody else who toiled on these behaviour codes. But the committee were constantly cognisant that the codes would be worth nothing without the independent enforcement regime. Witnesses to the committee's inquiry were most vocal in declaring that the codes of conduct were not worth the paper they were written on if there wasn't a strong independent enforcement regime to accompany them. And this bill will establish that enforcement regime, which is the next piece of the parliamentary cultural reform work. This is serious, hard work. But this IPSC will act as a fair and independent workplace investigatory body to handle complaints, make findings about misconduct, and make recommendations on sanctions for parliamentarian staff and others who breach codes of conduct. It will have the power to investigate genuine complaints, to impose sanctions and recommend reforms. It will not replace parliamentary privilege. It will work with the Privileges Committee where necessary, nor will the IPSC be an avenue for vexatious or malicious complaints or political point scoring. The IPSC independence from political pressure will be crucial. Decisions will be made based on principles of fairness and justice, not partisanship. The bill outlines a clear and transparent process for handling grievances and disciplinary actions by establishing rigorous procedures and open channels for reporting and addressing misconduct. The Commission will foster a culture of responsibility and ethical conduct within our system. And the expanded Parliamentary Workplace Support Service, whose building occupants now know and trust, will remain the front door for people who have a workplace complaint. The IPSC will be located within the PWSS, sharing some resourcing, but will otherwise operate independently, and that is important. That means that if you have a complaint, you can go to the PWSS like you currently can, and they will give advice on how it can be resolved, including whether it would be appropriate to be handled and investigated by the IPSC. If it was determined that an investigation was needed by the IPSC, the process would be rigorous, conducted by the independent expert commissioners, and in accordance with the legislation before this House today. Importantly, this legislation also allows for oversight and review. And I say that to all those that have reservations, whether they're people who are very anxious about having any form of independent oversight, or those that would wish to see even further requirements for greater independence. This is a process that we embark on now, I hope and I expect, with the full support of everybody in this House, notwithstanding some reservations that have been articulated. I believe there will be support for this bill from every single 151 members of this House, and that's an important signal to send to us all. And this is a body that has a review mechanism in place, and it will be important to ensure that this is in fact delivering everything we want and need an independent body to be able to do. This legislation, as I said, it will allow for that oversight and review, and I expect that that will be conducted in a very rigorous manner. It'll also establish a joint committee on parliamentary standards to reform a whole range of important functions. It's the recommendations about the appointment of commissioners, the review of the behaviour codes, monitoring and reviewing the performance of commissioners, and reporting on any matters connected with the performance and function of the IPSC and its commissioners. Just like the way we drafted those codes of conduct, those behaviour codes, where we sought to reach consensus on that, I don't for one moment suggest that they should be set in stone, that they are perfect. They will be subject to a review. And this is important work. What we do in 2024 might not necessarily hold in 2034. I expect to see change in these. I expect to see a process of continuous improvement and best practice always applied to this House. This is much needed legislation. It is long awaited legislation. and it offers so many benefits to our Parliament. There'll be the enhanced accountability. There will be consistency in standards. There will be protection against political influence through independence to ensure that the investigations and decisions are made are based on evidence rather than political interest. It brings us improved public confidence by demonstrating a commitment to high ethical standards and transparency in the nation's Parliament. It brings effective oversight through the ability to investigate complaints, enforce rules and recommend sanctions or reforms. It promotes ethical behaviour by acting as a deterrent against unethical behaviour and encouraging a culture of integrity. And it brings objective decision-making based on objective assessments and established criteria rather than influenced by external pressures or internal biases. The Jenkins report gifted us, through very difficult circumstances, an opportunity to transform Commonwealth parliamentary workplaces to become what they already should be, workplaces where expected standards of behaviour are modelled, championed and enforced, where respectful behaviour is rewarded and in which any Australian, no matter their race, gender, sexual orientation, disability status or age, feels safe and welcome to contribute. I also just want to acknowledge at the end the work of Senator Katie Gallagher, our Minister in the other. It requires tireless leadership to make this happen. I want to acknowledge that. We need to set the standard. I urge all members to support this bill.
Order. I thank the honourable member for Newcastle. The question now is that the amendment be agreed to. And I call the honourable Leader of the Greens.
Thank you, Deputy Speaker. I rise today to just make a few short remarks about this bill. Further and more detailed contributions are going to be made by Senator Larissa Waters and our other members in the Senate, but I do just want to place a few matters on record. Establishing this independent Parliamentary Standards Commission to enforce the codes of conduct that should regulate parliamentarians' behaviour has been a long time coming. Recommendation 22 of the Set the Standard report was that the Houses of Parliament should establish this body within 12 months. The IPSC was initially expected in October 2023, but that time frame has since been delayed until October 2024. But both Houses of Parliament have now endorsed codes of conduct for behaviour, but one of the things that we strongly believe and why we are pleased to see legislation coming here is that without an independent body to investigate breaches, those codes have been unenforceable. And it's for that reason that the Greens support the establishment of an IPSC to hold MPs accountable for bad behaviour. We do have some concerns about some of the provisions in this bill and that we don't think they go far enough and as far as had been mooted and had been recommended. We think there should be higher fines for MPs and more consequences for ministers where there is an adverse finding, and that it shouldn't be up to the Prime Minister to determine what happens to ministers who misbehave. We are disappointed to see that the bill doesn't allow the IPSC to suggest appropriate parliamentary sanctions to be imposed on MPs by the Privileges Committee, because this is something that Recommendation 22 of the Set the Standard report actually specified and actually proposed, but we are disappointed that that hasn't been picked up. We're also disappointed that there's no requirement for Privileges to report its reasons, the Privileges Committee to report its reasons, if it departs from IPSC recommendations. Now, this is important. There's a key, the I in the IPSC stands for independent, and part of the reason that the public will have faith in this, or ought to have faith in this, is that it may well be the IPSC that recommends action be taken. Now, When that comes here, if it comes here for constitutional reasons and is only able to be dealt with by the Privileges Committee, then if the Privileges Committee doesn't do what the independent body has recommended, I think people are entitled to know why. People are entitled to know why, if we've set up this independent body and then someone does something wrong and a sanction is recommended, but the Privileges Committee, i.e. the Parliament itself, decides to depart from that, or a committee of the Parliament decides to depart from that, then at a minimum we say there should be reporting of reasons, because the public must have confidence that politicians will be held to account. And a strong and transparent process is needed for that confidence. And so on those issues that are flagged, and potentially others as we work our way through the bill, but certainly on those, our leader in the Senate, Senator Waters, will move amendments in the Senate to address those omissions. And I want to pay tribute to the work of Senator Waters and indeed all the other members across the Parliament of the Leadership Task Force, as well as Senator Green's Deputy Leader, Senator Marian Faruqi, and all of the other members of Parliament for their work on the codes of conduct. We think, as the Greens, that having an IPSC to enforce these codes of conduct is a very important step in making parliamentary workplaces safer. I think finally, to just conclude my brief remarks, Deputy Speaker, it is worth noting that as well as the work of people within the Parliament, this progress would not have happened without all of the brave staff that spoke out. And many of those staff spoke out with great fear and trepidation, but they were brave and they brought their stories forward, and they forced us to act. They forced us to act. And the request that they had is indeed a request I think that pretty much everyone else in this country would have, namely that it is about time that this place set the standard rather than be a national shame.
Order. I thank the Honourable Leader of the Greens, and I call the Assistant Minister.
Thank you, Deputy Speaker. Well, I have spoken in this place many times about the need for us to hold ourselves accountable and to indeed set the standard. And so I do want to once again take the opportunity to acknowledge the critical work of the former Sex Discrimination Commissioner Kate Jenkins and her team at the Australian Human Rights Commission in helping to set us on this course. I also want to acknowledge all the staff in this place, the current and former staff who contributed their experiences to that report. I know that was not easy for many of those staff, but we are a better parliament because of your efforts, so thank you. I want to acknowledge the people in this place who have helped steer us to this point, because again, let's be honest, this isn't a workplace that embraces change easily. It is not a workplace that has done this really difficult work in the past. It has taken us far too long to get to this point, and I want to acknowledge the people who, in the just 2 years of our government being in power, have now got us to the point where we are introducing something that probably should have happened a very long time ago. So in particular, I pay tribute to my friend and colleague, the member for Newcastle, for her leadership, and of course to the Minister for Women, Katie Gallagher. Deputy Speaker, Labor, both in opposition and now in government, have been steadfast in our commitment to making this a safer workplace for all people. This is something that we need to see action on. For too long, this Parliament hasn't met the standards the Australian people expect of us. And in fact, we're the place that sets the standards and rules for other workplaces, and yet we haven't managed to meet the standards that we have expected of those in the Australian community. And that is shameful for all of us, and it is something that collectively we must continue to set right. In particular, it is very concerning that this Parliament has, in too many cases, not been a safe workplace for women. It is positive that that is changing, but we would be kidding ourselves if we thought it was job done. This is a really important part of the puzzle, but it is still on all of us in this place, particularly those of us elected to this place, particularly those of us who employ staff in this place to make sure that we are doing everything we can, everything that we have a responsibility for, to make this a safer workplace for all and particularly for women. The Set the Standard report found that the experience of so many staffers and others who work in Parliament or other parliamentary workplaces, their experiences were of a workplace that was often toxic and harmful. So it's been absolutely clear for some time that Parliament needed to improve, that we do need that long-term cultural piece of change in how our Parliament workplace operates. The recommendations that were put forward in the Setting the Standard report have helped us to ensure that we are on the pathway to make sure that this workplace, our electorate offices and related workplaces are safe and respectful. They do put us in the area where we are now following best practice in preventing and responding to bullying, sexual harassment and sexual assault. The delivery of all of that work, as I said, is on all of us. Government members, opposition members, crossbench members, we all have a responsibility to deliver on making this a safe workplace. To ensure this building, Commonwealth parliamentary workplaces here and around the country are safe and respectful. And in particular, I think what is important about the architecture of the IPFC that we set up through this bill is that it ensures that there are consequences for actions, that we know that if we are not behaving in a way where staff feel safe, where they are respected, where we are doing the work to make this a workplace where that is the norm, that we will be held accountable for our actions. For too long, there has been impunity in this place. There has been a sense that being an elected member of Parliament in some way, put you above consequences or rules that apply to people who worked in other workplaces. That is no longer the case. With the Independent Parliamentary Standards Commission, we do have in this place a mechanism to see the outcomes that will hold people accountable for their actions. Since the Set the Standard report was first handed down, our government has been committed to implementing all 28 of its recommendations. We are very clear that parliamentary workplaces should be safe and respectful for everyone. And it's work that we have done and tried to do by bringing the whole Parliament together. So last year, the government, working with the Parliamentary Leadership Task Force and its staff consultation group, established the Statutory Parliamentary Workplace Support Service. The PWSS has since enhanced its operations, providing centralised human resources support to parliamentarians and their staff. And I think, again, if you talk to people in many other professional workplaces around Australia, they would be astounded to hear that it took us until 2023 to really have in place a centralised professional HR service for this building, but that is in fact the case. And I know, certainly from my experience, from the experience of my staff and from the experiences of others I've spoken to, that having the PWSS in place has made a difference to their experience in this building. The PWSS does provide services to a broader cohort of people who work in the Parliament to support a safe and respectful workplace. And so that is a really important part of that architecture that we needed to set up to make this a safer workplace. What we are doing now with this bill is the next part, the establishment of the Independent Parliamentary Standards Commission. So the IPSC will be able to investigate complaints about breaches of behaviour codes that will apply in the parliamentary workplace. And in fact, having the IPSC in place means that having those codes, those behaviour codes that we have all signed up to, can finally commence. Importantly, the IPSC will have fair and confidential processes. And again, that is important. I acknowledge all of the staff, again, who as part of this process have brought forward their stories and their experiences. It is vital that as part of these mechanisms we are putting in place now, staff feel like they have avenues to take complaints and to take issues to that they feel are safe and respectful, and that is how the IPSC is being set up. It will be independent and it will be impartial. And the government has really worked very closely with parliamentarians through the Parliamentary Leadership Task Force, with staff in the building and other people right across the Parliament to get these important reforms right. We do have to make sure that when serious workplace issues arise in this place, people have recourse through an independent investigation. and that there is real accountability for people doing the wrong thing, that accountability that has been lacking in the past, and that I think has been a factor in making people both feel unsafe and also feel like they do not have genuine avenues to take complaints or concerns through. In doing all of this work, we've sought as much as possible to align with the approach and the recommendations of the Set the Standard report, while also really balancing that against the need for this legislation to carefully interact with the role of the Parliament. And so in striking this balance, we've worked out that the IPSC would be established as part of the PWSS, and there will be functional separation between the IPSC's investigation function and the PWSS's functions. So they'll work together in complementary ways. The PWSS will continue to be a front door for complainants, although a complaint could be made directly to the IPSC. And the IPSC will not commence investigations that would be better addressed through the PWSS's complaint resolution function. So again, we have tried to be very thoughtful about how both of these bodies are providing people who in this workplace with avenues to have issues addressed, and then at the end point, where necessary, there are also consequences for findings against people. And as I said, those consequences will be an important part of the architecture that we're setting up. Deputy Speaker, as an independent and impartial body, the IPSC will be well placed to undertake investigations and to determine whether misconduct has occurred. The IPSC would be able to directly impose sanctions on MPs, including training, behaviour agreements and reprimands, and will refer serious findings to the relevant Privileges Committee to recommend appropriate sanctions to the Parliament. The relevant Privileges Committee would then be responsible for considering the appropriate sanction and would be required to report to the Parliament with their recommendation. Importantly, this would require a public report, ensuring that the committee is accountable for their recommendation to the Parliament. And accountability, again, is part of what has been missing. And again, in talking with many people over the years that this process has been active in this Parliament, I know from many conversations with broader members of the public, but particularly when talking to young women about how they view this place as a workplace, that they have really seen it as a consequence-free environment. And obviously the concern for all of us in here is not just the concern that we should all hold that the Australian public aren't very impressed sometimes with how we conduct ourselves and how we treat this place as a workplace, but also that the message we are sending to young women is one that they're receiving of this not being a safe place for them to either want to work in or to enter as an MP. And that is something that it is on all of us to actively work to change. Passage of this legislation will help finalise the implementation of the recommendations from the Set the Standard report, helping to ensure that this workplace leads by example and is safer for all, for parliamentarians, for staff, all of those in the building. I absolutely acknowledge that Parliament House is a unique workplace. And in that uniqueness, we want to attract the best and the brightest here. We don't want to be exclusive about it. We don't want to be saying you can only come if you can hack it. You can only come if you can work out our unique workplace to your advantage. We want to say this is a safe and respectful workplace for all people. And this is an important part of sending that message both to the Australian people and also to all of those who work in this building. We have a shared responsibility to make sure that people who work in this building and in other political offices are able to do their job in a safe way, and that they are confident that the systems and supports that should be in place to support them are there when and if they need them. We have taken the time to get this legislation right and as I said, to consult across the Parliament, and I do thank all the people, not just in the government but in the other parties and the opposition who have been involved in that consultation. I am sure that as a result of this legislation, we will get a better Parliament. We will get a Parliament that is more respectful. We will get a Parliament that is safer for staff and people who work in this environment. We will place this parliament in line with the standards that we request of other workplaces right around the country. Change like this doesn't happen overnight. I'm not kidding myself that we have done all the work we need to do, and I say again that the responsibility is on all of us, particularly those of us who are elected members of this place, to make sure that we live up to setting the standard, to make sure that we don't think this is a set and forget and work is done, but that we continue to work together to set the standard, to make sure that people are safe and respected in this workplace.
I thank the Honourable Assistant Minister. The question is that the amendment be agreed to, and I call the Honourable Member for Wentworth.
Speaker, I move the second reading amendment as circulated in my name.
I give you the call.
Thank you, Deputy Speaker. I rise to speak in support of the creation of an independent Parliamentary Standards Commission Bill 2024. The legislation represents an essential step towards addressing the deep-rooted issues that have plagued our parliamentary workplace for too long, and I commend the work of the Parliamentary Leadership Task Force, including the member for Warringah, in getting us to this point. Deputy Speaker, like many Australians, I've been appalled by the reports and revelations about conduct in Parliament over the last few years. Kate Jenkins' Set the Standard report shone a stark light on the toxic culture that had been allowed to fester within these very walls, revealing a workplace where inappropriate behaviour, including sexual harassment, bullying and assault, was allowed to proceed unchecked. Her report found that Parliament had become a breeding ground for misconduct, particularly against women, who were underrepresented in senior roles and often subject to gendered discrimination in the workplace. As one woman interviewed for the inquiry lamented, "It's a man's world and you are reminded of it every day, thanks to the looks up and down that you get, to the representation in the parliamentary chambers, to the preferential treatment politicians give senior male journalists." This male-dominated culture, described by Jenkins as testosterone-fuelled, allowed a dangerous sense of entitlement to flourish. The report recounts the harrowing experience of one individual who recalled, "The MP sitting beside me leaned over. Also thinking he wanted to tell me something, I leaned in. He grabbed me and stuck his tongue down my throat. The others all laughed. It was revolting and humiliating." Such behaviour is not only unacceptable, but is an indication of how far removed this workplace had become from the values of respect and equality that we, as representatives of the Australian people, are meant to uphold. The Set the Standard report also highlighted the extensive culture of bullying that existed within parliamentary workplaces, with 37% of employees reporting that they had experienced some kind of bullying at work. One individual shared the disheartening advice they'd received. Frequently, like at least every week, the advice was to go and cry in the toilet so nobody can see you because that's what it's like up here. Even more alarmingly, over half the people in the Commonwealth parliamentary workplaces reported experiencing at least one incident of either bullying, sexual harassment or sexual assault. And a staggering 77% said they'd witnessed, experienced or heard about such behaviour. These statistics paint a grim picture of our parliamentary workplace. They reveal a culture that not only fails to protect its workers, but also perpetuates harm. As one individual described, aspiring male politicians who thought nothing of, in one case, picking you up, kissing you on the lips, lifting you up, touching you, pats on the bottom, comments about appearance, the usual. The culture allowed it. Such casual references to such deeply inappropriate behaviour highlight a deeply troubling normalisation of this kind of misconduct. But, Deputy Speaker, one of the most damning findings of the Set the Standard report was that parliamentarians who engaged in misconduct were often not held to account. As one participant put it, "There are no ramifications for bad behaviour because there are no risk of MPs getting fired or otherwise being held accountable for their actions. This glaring lack of accountability is unacceptable. It undermines public trust in our institution and tarnishes the reputation of our democracy." Deputy Speaker, the findings of the Set the Standard report sent shockwaves through my community, and they demand immediate and comprehensive action. it is clear that the status quo cannot continue. We need to create a parliamentary workplace that is safe, respectful and inclusive, where misconduct is not tolerated and where those who perpetuate it are held to account. This is not only about justice for those who have suffered in the past, but a necessary step towards restoring the public's faith in our political system. Deputy Speaker, whilst many of the recommendations from the Set the Standard report have been now addressed, this bill seeks to address several issues that remain outstanding by establishing an independent Parliamentary Standards Commission. The IPSC will have the authority to investigate allegations of breaches of codes of conduct for parliamentarians and staff, as well as breaches of conduct standards which apply to all Commonwealth parliamentarian workplaces. Importantly, it will address bullying and sexual harassment. Complaints to the IPSC can be made through various channels, including referrals from a parliamentarian, party leader, or the PWSS CEO. A single investigating commissioner will determine whether an investigation should commence, with protections in place to deal with frivolous complaints or those which should be addressed under other laws. After an investigation, IPSC will make findings on whether a person has engaged in misconduct and impose or recommend sanctions. Deputy Speaker, this bill is a critical step forward in addressing misconduct in parliamentary workplaces. It sends a clear message that inappropriate behaviour will no longer be tolerated and those who can engage in misconduct will be held accountable. However, I have two key concerns with the legislation. First, when it comes to the most serious instances of misconduct, this bill only partially implements recommendation 22 of the Set the Standard report. The Set the Standard report recommended the IPSC should have the power to recommend specific sanctions in relation to parliamentarians that had engaged in misconduct. But this is not fully provided for under this legislation. Where there is a less serious breach of the code, the IPSC will have the power to determine and impose sanctions on parliamentarians, such as a reprimand or requirement to undertake training. But where the IPSC determines that a breach justifies serious sanctions, it will have to refer the matter to the Privileges Committee, who will then determine the relevant sanction and in turn recommend it to Parliament. As a result, there will be no mechanism for the IPSC to recommend sanctions against parliamentarians for the most serious breaches of the Code of Conduct. This is concerning and creates the risk that the most serious offences could go unpunished or indeed be covered up for political expediency. Now, I have the utmost respect for the Privileges Committee and I believe it will do its job well. But we are operating on trust here without a legislative backstop. And trust is not well, and the community doesn't have high trust in many of the institutions we hold dear at this stage. I therefore urge the government to look again at this issue and to ensure that there is appropriate transparency in the case of the most serious breaches of the code. Without this, the IPSC will not meet public expectations of reform. Deputy Speaker, the second limitation of this bill is that it does not address conduct within the parliamentary chamber. And my second reading amendment goes to this point. The current Code of Conduct requires parliamentarians to treat people with dignity, courtesy, fairness and respect. But the conduct of parliamentarians in this House of Representatives chamber, especially during question time, frequently falls well short of these standards. There is no other workplace where shouting, mocking and hurling insults is not only tolerated but celebrated. At times, this House is more like a sporting event than a place of serious discussion of the laws and the most important issues facing this country. I recall an instance during question time where a parliamentary colleague shouted, "Rip him another one," in the middle of a debate. On another occasion, I left the chamber after question time and two members of the public came up and asked me, "Is it always like that?" They were so stunned by the behaviour they witnessed. And today, we had members of the public who were leaving the gallery and making obscene hand gestures towards the Parliament. But the behaviour in this place, I think, encourages this sort of behaviour. It says, hey, that's okay. This is the sort of behaviour that is expected in this place, that made them think that was okay. There are so many other examples that I could cite. And indeed, since May 2022, politicians have been thrown out of the chamber over 200 times. You know, I've heard of politicians boasting, particularly on the coalition side, boasting of how many times that they have been thrown out. Like this is some sort of, badge of honour. This is disgusting. We have young people in this chamber almost every single day looking down at this chamber as an example of how to have conversations about the most important issues of the day, and they're competing with each other to be thrown out. It does nothing to support constructive discussion and social cohesion at a time when we are struggling so hard to disagree well as a country. And I have heard many sermons on all sides of the House about how important it is that, social cohesion, this is so important. We can't stand for bad behaviour, we need to lead. Well, we need to start by leading in this place. As the Director General of ASIO, Mike Burgess, has said, words matter. ASIO has seen direct connections between inflamed language and inflamed community tensions. These are sobering words. But I fear that many in this place have not listened. My community at this point in time is feeling these inflamed tensions more than most, but at a time where we desperately need to bring people together, where we desperately need to be listening respectfully to each other, to holding deep emotions and deep conviction, but still be able to listen and learn from each other. Our tone and our language in this Parliament is frequently seeking to divide. We should be setting an example for this nation, having difficult debates, but doing so in a way that does not undermine social cohesion and does not foment fear and anger, engaging in constructive discussions, not trading insults. The Governor-General, in her first speech as Governor-General, spoke about going around the country and listening to what was important to the members of our community. And she noted that many people expressed their concern that we might lose our capacity to conduct robust and passionate argument and debate with civility and respect, without resorting to rancour or violence. Question time frequently shows politics at its worst. It undermines the institution, it undermines support for politicians, it undermines our democracy. And the problem with this bill is the IPSC and the codes of conduct do not apply in this place, which is the most visible place of debate in the country. And I think that there are some people who have been in this Parliament for so long, either as staffers or as members, that they have become completely out of touch with the Australian public and what they expect. So while I think this bill is a positive step forward, I am disappointed that the most important part of parliamentary conduct are not included. The IPSC is supposed to enforce a code of conduct for parliamentarians, but its remit will not extend to conduct in this chamber. And so I call on the government, through my second reader amendment, to embed the new code of conduct in the House of Representatives standing orders and to take real steps to improve behaviour in this chamber. Thank you.
Is the amendment seconded?
Amendment and reserve my right to speak.
Seconded by the member for Curtin. The original question was that this bill be now read a second time. To this, the honourable member for North Sydney moved as an amendment that all words after that be omitted with a view to substituting other words. The honourable member for Wentworth has now moved as an amendment to that amendment that all words after reading be omitted with a view to substituting other words. The question now is that the amendment moved by the honourable member for Wentworth to the amendment moved by the honourable member for North Sydney be agreed to. And I call the honourable member for Warringah.
Thank you, Mr Deputy Speaker. Well, it is an important day that we finally see this legislation here and that we have the opportunity to debate it. The Australian Federal Parliament has failed to be a safe, supportive workplace in recent years. Indeed, we see all too often conduct that is incredibly inappropriate. But we know from the Set the Standards report that for too often staff had a very unsatisfactory experience. with the rates when it came to sexual harassment, bullying, intimidation, and even so far as assault, just incredibly high. And the Set the Standard report shocked the nation, that the idea that our Commonwealth workplace, which should be the gold standard, leading the way for the private sector and other areas, was in fact miles and years behind the private sector. But is it really surprising when we see the conduct in this place during the course of debate and often during question time? Because ultimately we have the government investing in a campaign which is around respect to address domestic violence, and we look at a campaign that is, respect started at the start. And as I've said, I think, and the member for McKellar has said, is we need to start it at the top. And ultimately, behaviour and culture changes comes down to leadership. And it's how leadership behaves that really makes a difference. And what we see too often, especially during question time, is behaviour that has vitriol, bad behaviour, and in particular, we have often in particular tried to discuss those experiences. And they are experiences that are, behaviour that is condescending, aggressive, misogynistic, and just the events of today just reinforce that perception and the very real reality that as soon as there is a viewpoint that is not the one that some members in this place, in particular members of the coalition, don't want to hear, they think it is their right to yell over the top of someone, to try and bully them out of the opportunity to speak. I would remind the coalition, this is the House of Representatives, and all communities under our Constitution have a right of representation and a right to speak. And so that's what this place is for. Just today, I had the Leader of the Nationals yelling at me that I should be careful. Now, what exactly does that mean? Is that a threat? Is that a threat that in raising my concern about conduct in the public gallery, that I should then feel threatened or intimidated from raising that point? That goes to the heart of what is wrong with this place and the culture that needs to change. And as today's events show all too well, that change has to come from the top. Leadership matters, and those in position of leaderships for parties need to do better. Or those below them in the parties need to seek for better leadership that will show the kind of example and integrity and the kind of behaviour that is becoming this place, and that we can set a standard for other workplaces. I know, and Set the Standard identified, many female MPs and staff have been subject to a lot of condescending, aggressive, misogynistic behaviour. If we are going to be a gold standard workplace here, and set the ethics, we set the laws that direct so many other workplaces, they look at the behaviour in this place and shake their head. The arrogance of members in this place to try and then dictate on other workplaces the standards they should comply to, when this very workplace does not comply or set any kind of standards of a similar examples. So is it any wonder that most Australians don't believe we are good role models, yet we are elected to be leaders of our community? The Guardian Essential poll reported in July that showed the public is extremely dissatisfied with members as democratic leaders. Only 29% are satisfied with the federal parliament. An overwhelming 75% think most politicians enter politics to serve their own interests. So is it any wonder that the public has so little faith in what we do here as parliamentarians when our own behaviour and standards are falling well below what the community expects of us? And it is just incredible the justification that we hear all too often. So in trying to raise the standard, people have said, oh, look, if you're not up for robust debate, you should do something else. I've been an Olympic athlete. I've been to Olympic Games and stared down incredible pressure and other aspects. I've been a barrister for 10 years. I've been in courts with incredibly robust debate and arguments. Never have I seen the disrespect we see in this place, in any other professional environment. And members in this place are kidding themselves if they think that in any way this is a question of robust debate. Robust debate is not disrespectful debate. And that's what all too often we see evolve in this place. And when I think of the children in years 5 and 6 of our schools coming to see that this is the place of debate, I really am concerned. And they all invariably raise concern and are surprised at the conduct they witness. And I often think it's nearly like a white line syndrome, that MPs come into this place and they think no one's, that it's going to be held to a different standard. It's part of the game of Parliament or of question time, without thinking about the impact, the role modelling this has. At a time where we have got a crisis of respect, we have a crisis when it comes to domestic violence, it really matters what kind of behaviour we say is acceptable behaviour, and it needs to start in this place. So, whilst I welcome the legislation we have before us today, it's incredibly disappointing that ultimately it does not apply to the conduct in this place. It does not apply to the conduct in the Senate or the conduct during Senate inquiries. Now, I appreciate it is because of the question of parliamentary privilege, but what I strongly support the amendment, and I do call on the leaders of political parties, go that extra step of leadership and endorse, and you take it to your party room and make sure that we endorse the code of conduct in this place as well. That is within every leader's power of political parties. Now, what's difficult is I have been a member of the Parliamentary Leadership Task Force, and I know how difficult it has been to even bring this legislation to this point. And obviously a lot of the deliberations of the committee has been confidential, and I do thank the government and the Minister and Senator Gallagher in her leadership in bringing it forward. And I very much want to thank the Secretariat and the Task Force Chair, Dr Vivian Tom, for all the work they've done to help us undertake implementing the recommendations of Set the Standards and bringing this legislation to the front. Establishing the IPSC is a key recommendation of the Set the Standard report completed by Kate Jenkins in 2021. And work on fully implementing the recommendations of this report has not been as quick as it should have been and many wanted, and it has taken too long. But look, we have to look at the glass half full, that progress is being made. Change to the culture of the federal parliament is happening, but events of today would say very, very slowly in this room at least. But I hope that at least for staff that this provides some level of security, or a feeling that they are now going to have a body to properly investigate complaints. So the legislation before us formally establishes the IPSC. In Set the Standards, the IPSC was recommended to ensure independent and consistent responses to reports and complaints of bullying, sexual harassment and sexual assault in Commonwealth parliamentary workplaces. Again, noting this is part of our workplace, yet it is exempt from the application. So the bill aims, at least outside of this chamber, to apply those principles and that process. It will lift the standard, keep people safe, staff safe and MPs safe, ensuring there is the right support for everyone, MPs, senators and staff members alike. It's important to have a clear body that can investigate where these standards are not met. The draft behaviour standards of codes of conduct will now be enforceable by the IPSC, and that's important. And I thank my colleague, the member for North Sydney, and all those on the Joint Select Committee on Parliamentary Standards who did the work to prepare the draft codes. The IPSC will have the power to enforce these codes and investigate instances of where these codes have been breached for those who work in this place. It will also have the power to enforce sanctions on those found to have breached expected standards. Sanctions for staff will include fines or even dismissal. For parliamentarians, it's more complicated. Fines can also be imposed along with more severe sanction, but there obviously are issues when it comes to sanctions for parliamentarians. The bill formalises the Parliament's first ever workplace investigation framework to cover everyone, and that is real progress and well overdue. The Parliamentary Workplace Support Service, or PWSS, remains the place to provide advice and guidance for any in this place who need it. The IPSC is the accountability and enforcement mechanism for when the behaviour codes are breached. It will be independent, impartial, it will ascertain the facts, and it will conduct investigations. Commissioners will be appointed who have the relevant experience and training to ensure they can undertake their investigative function as fully and properly as possible. Investigations would be undertaken where a commissioner judges sufficient information to do so with a complainant's consent. A commissioner has discretion not to investigate on several grounds, including if the conduct would be more appropriately dealt with under any other law or by PWSS Complaint Resolution Service, or if it is a vexatious or lacking in substance. And that is important because obviously complaints can have huge reputational damage if it is vexatious or without proper merit. So it's important to note that if another authority at the federal, state or territory level has jurisdiction, it would be considered the appropriate place to take a particular issue or grievance, then that will occur. But the PWSS will remain an avenue to support people involved in an investigation, whether a complainant, a respondent or a witness at all times. So it is really important to emphasise the continued role of the PWSS that it will play in ensuring Parliament and electorate officers remain potential complainants are encouraged to seek advice from PWSS, who can talk through options to facilitate resolution of workplace issues. PWSS can provide advice about making a complaint to the IPSC if an investigation would be appropriate. However, there might be those who will be more comfortable reporting directly to the IPSC, and that is of course possible. In relation to the more serious misconduct, in relation in particular to parliamentarians, the Parliamentary Leadership Task Force has landed on a model which requires serious misconduct to be essentially referred to the Privileges Committee, and there will be a range of sanctions that can be imposed. I should say that is not my preferred pathway. I feel that is parliamentarian, because ultimately Privileges Committee, without detracting from their professionalism and authenticity and integrity, are ultimately also parliamentarians and are also party members. And so you ultimately have a situation where we are regulating ourselves. And to date, that has not been a sufficient deterrent to improve behaviour. So I do have questions about the effectiveness of the referral to the Privileges Committee and leaving it to the Privileges Committee to determine the sanctions, that the Commission will not make recommendations, and there is no requirement for the Privileges Committee to consider particular recommendations as to sanctions and, in fact, explain why they may depart from recommendations. Now, I understand the constitutional and, I guess, the ethical dilemma around that the parliamentarians are elected. It is not a traditional employment situation, and the Privileges Committee is the committee that has oversight over the conduct of parliamentarians in other circumstances. But it's clear there is an expectation from the public that we, as members of Parliament, need to actually be held more accountable than what we currently are. And so there is a question whether or not the Privileges Committee will be capable of doing that, especially since it is ultimately still government-led. And so the question around, is that going to provide increased scrutiny and conduct? Well, the jury's out. Ultimately, I support the legislation because it's overdue and we need it, but I think we need to be open to whether or not further amendments are going to be needed to ensure there is greater direction to the Privileges Committee and accountability of the Privileges Committee in how it gets there. But ultimately, I am appreciative of the steps the government has taken to engage in genuine consultation and seeking to get as broad an agreement as possible. That is the difficulty of the nature of this place. It's so adversarial that even the question of should we be all held to a better standard becomes adversarial in itself. And unless everyone genuinely is at the table wanting these changes to happen, it is difficult. Ultimately, of course, the public will judge us on how well we improve standards in this place, but the key is to make sure there is visibility on those processes, and I am absolutely committed as a parliamentarian to pull the curtain back on this place and keep the public informed.
The question is that the amendments be agreed to, and I call the honourable member for Goldstein.
Thank you, Deputy Speaker. If there's one thing that gets under the skin of the members of the Goldstein community who approach me, it is parliamentary behaviour inside and outside this chamber. Indeed, if there was one thing that helped motivate me into standing for Parliament as a community independent, it was the accounts of sexual assault, harassment and bullying of parliamentary staff in the months and years before the 2022 election. What the Parliamentary Workplace Support Service Amendment does is give effect to one of the most important recommendations of Set the Standard, the landmark report of former Sex Discrimination Commissioner Kate Jenkins into workplace culture in and around Parliament House. That is the establishment of an independent Parliamentary Standards Commission, the next step in bringing workplace culture in parliamentary offices into line with those that apply or should apply in every other workplace in the country, and also in line with community expectations as voters made clear at the 2022 election. Based on contributions from 1,700 people, Set the Standard condemned the workplace culture here in Parliament House. It found that 51% of all people currently working in Commonwealth parliamentary workplaces had experienced at least one incident of bullying, sexual harassment or actual or attempted sexual assault. What a disgrace. It revealed that 1 in 3 workers had experienced sexual harassment, with young women and people who identified as LGBTQIA+, the most vulnerable. It was laid bare for all to see. The nation's parliament was an unsafe place to work. Kate Jenkins noted that while men and women spoke of their experiences, the harassment and bullying was disproportionately aimed at female staff and MPs, and it was largely driven by power imbalances, gender inequality and exclusion, and a lack of accountability. The contributions from those interviewed in the report are harrowing. For example, quote, "I'm now in the privileged position to have a good job, a home and a family of my own, but the scars from this period of my life run deep. I left the office after basically having a nervous breakdown," one person said. "I'll never work in a political office again. It's not worth it," another said. Another, "I did not want to stay in an environment where I was going to be subject to that level of abuse." And another, "From the get-go, there's no incentive to actually report because it's not going to change it and it's probably actually going to make it worse." Again, disgraceful. In the past, it's been too easy to say that Parliament is a unique workplace, that no other workplace is like it. This narrative has to stop. By speaking about Parliament this way, either intentionally or unintentionally, we excuse antisocial behaviour. Yes, it's the national Parliament. It's the imposing house on the hill. But the people who work here have every right to feel safe and respected. The people who work here should have the systems they need to go about their work in a safe and respectful environment. No exceptions. Society has a problem with the way it treats women. And if we cannot lead by example right here in Parliament House, how can we expect respect at work in other workplaces across the nation? Excusing poor behaviour perpetuates myths and misconceptions about sexual assault. The facts are that sexual assault is an underreported and under-prosecuted crime. According to the national statistics, in 2023, 92% of women who experienced sexual assault did not report the incident to the police. Changing the culture here in Parliament has been a lengthy and tortuous process. The Parliamentary Workplace Support Service is up and running. Parliament has accepted draft behaviour codes for MPs, senators and their staff. Establishment of the Independent Parliamentary Standards Commission means that those codes can be formally adopted and that there will be a mechanism to ensure that they are enforced. As Kate Jenkins put it in her report, quote, "The Commission heard that current reporting processes were opaque and ineffective and that participants consider that the risks of reporting outweigh the benefits. Establishing an independent complaints mechanism will ensure that people working across Commonwealth parliamentary workplaces feel confident to report misconduct and that standards will be enforced." As the Minister stated in his second reading speech, the absence of clear standards of conduct and the absence of consequences for misconduct make the Australian Parliament not only out of step with developments in other parliamentary contexts, but also with the most basic standards in other Australian workplaces. You can say that again. The question is whether the consequences for misconduct enshrined in the legislation are sufficient to be a deterrent, and whether they provide adequate penalties for transgression. Fair Agenda, which campaigns for gender equality and safety, thinks not, arguing that the legislation does not go far enough to deliver strong transparency around misconduct by MPs and senators. It says serious sanctions like suspensions, fines or removal from a committee can only be imposed by the Parliament itself, so will have to be voted on in the House or the Senate. And indeed, this approach is at odds with recommendation 22 of the Set the Standard report, which says that an independent Parliamentary Standards Commission would, quote, make recommendations on sanctions in relation to parliamentarians, staff and others. It further adds, an independent mechanism is needed to provide an effective reporting, investigations and sanctions authority in the context of Commonwealth parliamentary workplaces. In particular, a level of structural independence from parliamentarians and political parties is imperative to ensure that a standards and accountability system is able to fulfil its accountability, deterrence and public confidence objectives. Instead, what this legislation would require is that where serious sanctions are recommended, the IPSC's report, including its findings and the recommended sanctions, would be directed to the relevant chamber's Privileges Committee. The Privileges Committee would then conduct its own inquiry, decide whether the alleged behaviour is substantiated, and if so, what penalty, if any, should be applied. It would be open to the committee to dismiss the complaint and to determine its own sanction rather than that recommended by the IPSC. I agree with Fair Agenda, and indeed with the implications of the Jenkins report, that if the Privileges Committee does not accept the recommendations of the IPSC, it should say so publicly and give its reasons in a timely fashion. This is a requirement of recently enacted Victorian legislation, and there is no reason it should not apply in this Parliament as well. The members for North Sydney and Clark are both moving amendments along those lines, and they will have my support. And I urge members of the major parties to support them too. Because the accounts of bullying and harassment reported to Set the Standard show just how poorly this Parliament has rated as a workplace. The accounts of bullying and harassment are quite frankly appalling and demand drastic remedies rather than halfway measures. It's time for the major parties to step up and support these amendments. Amendments which would give the public confidence that we mean what we say when we declare that this must be a workplace that is safe and indeed attractive. Confidence in the quality of our democracy is low enough as it is. It will not be enhanced if we cannot attract the best young people to come and work for us. On the matter of whether this legislation should have addressed behaviour within the chamber, I'm inclined to believe that's a matter that is within our own hands, in the absence of those particular clauses within the bill. That it's up to us to show the voters that we can behave with civility and decency that would be regarded as the norm in any other workplace. That it's up to us to change the standing orders in such a way as to encourage robust but respectful debate, if that is what the majority wish. To date, governments of either stripe have shown no signs of wanting to reduce the advantage, as they see it, that being in majority provides. Indeed, the only significant steps forward in recent times were the improvements to question time initiated by the crossbench when it had the balance of power between 2010 and 2013. It looks like we'll have to wait until that happens again if there's to be any substantial improvement. Unless that is that the government is hearing similar complaints from constituents to those that I get on an almost daily basis and decides to actually listen and act on making the standing orders in this House fit for purpose. I commend this bill to the House. Thank you, Deputy Speaker.
The question is that the amendments be agreed to, and I call the honourable member for Curtin.
Thank you, Deputy Speaker. I'm pleased to speak on this piece of legislation, particularly after the last fortnight in Parliament when the question of parliamentary standards are up to scratch was on display for all to see. It's also an important discussion to have when trust in politicians and indeed in our democracy is at a bit of a low. As a first-time crossbencher, I feel that I've brought fresh eyes to the Parliament. And while this legislation does not directly address behaviour in the chamber, that's the behaviour that is the most confronting as a newcomer and sets the tone for the rest of the work environment. The jeering, heckling and disrespect shown in the chamber is unlike any other work environment in the country. Now, this chamber should be a place for robust debate, but the culture demonstrated here is a relic of the past, as is the lack of accountability and standards in this place more broadly. The standards in this House should not be so markedly different from the rest of the workplaces all across Australia. If anything, we should be setting an example. And if we want our constituents to respect our Parliament, we need to demonstrate that we are worthy of respect. And if we want our constituents to trust us, well, we need to earn their trust. Part of this means being transparent and open about misconduct in the parliamentary workplace and holding to account those who betray the trust and respect afforded to them. We also need to provide a safe and respectful workplace for our staff, just like any other workplace. And the sad reality is that this place does not have a good reputation. I interviewed a young woman about a job on my team, and she was hesitating about taking the job, and I asked her why. And she said she was quite worried because she had heard that Parliament House was a bit rapey. Now, it's absolutely horrific that this could be the reputation of the centre of our lawmaking, and we must do better. Now, this bill is the final piece of reform coming out of the independent review into Commonwealth parliamentary workplaces in response to public outcry over toxic culture and poor behaviour in the Commonwealth Parliament. The response to the review, the Set the Standard report, was tabled in November 2021 and it contained 28 recommendations to ensure Commonwealth parliamentary workplaces are safe and respectful. Recommendation 21 was to establish clear and consistent codes of conduct. Recommendation 22 was to establish the Independent Parliamentary Standards Commission, which I'll call the IPSC, which would enforce those codes of conduct. And in November 2021, it was recommended that the codes and the IPSC should be implemented within 12 months. Well, the parliamentary behaviour codes were developed by the Joint Select Committee on Parliamentary Standards and endorsed by both Houses of Parliament in February 2023, sometime later. An independent parliamentary workplace support service was established and commenced in October 23. And today, sometime later, we're debating this bill that establishes the IPSC and determining whether this is an appropriate response to the recommendations in Set the Standard. So what did the report say? Well, the Set the Standard report says that the IPSC should make findings about misconduct, make recommendations on sanctions, and apply sanctions for a breach of the Code of Conduct for parliamentarians. It also says the IPSC should operate a fair, independent, confidential and transparent system to receive disclosures, complaints and appeals about misconduct. So I want to look at how this has been translated into legislation. Firstly, on the functions and powers of the IPSC. Well, the IPSC has been set up to provide an enforcement mechanism for the behaviour codes. It's set up as an impartial fact-finding body that investigates conduct issues that have been submitted to the Commission in writing, if it's satisfied on reasonable grounds that there's sufficient evidence or information to justify doing so. Now, after investigation, the decision-maker provides a draft report which includes preliminary findings, a summary of evidence and, where relevant, proposed recommendations and sanctions. The person who's subject to critical preliminary findings or proposed sanction then has an opportunity to respond before final sanctions are recommended. In the case of a serious breach finding, the IPSC will refer its findings to the Privileges Committee, which then considers the appropriate sanction and reports to the relevant House of Parliament with its recommendation. And a recommendation by the Privileges Committee will become public. Now, all of this seems a reasonably appropriate response to the Set the Standard report and the committee report. And I agree that it's important there's a division between the IPSC's role of investigations and proposing sanctions and the functions of policy setting and providing advice and support on behaviour standards. I support the structure of the IPSC that requires MOPS employees to have one allocated investigating commissioner and parliamentarians to require a panel of commissioners. And I think it's correct to have recommended sanctions communicated to the employer of a MOPS employee found to have breached a behaviour code, while less serious sanctions can be imposed by the IPSC on parliamentarians. I also believe that serious sanctions against parliamentarians should be applied through the House by the Privileges Committee. But as I said at the outset, so much of the rebuilding of trust in this place requires the public to believe parliamentarians and their staff are acting within the highest standards. Secondly, is it fair, independent, confidential and transparent? Well, I want to address these requirements in reverse. Firstly, is it transparent? Transparency is essential to build trust. Now, this bill does not require full transparency. In fact, there's no need for the IPSC to ever share its fact-finding assessment nor its recommendations. In the case of serious misconduct, the IPSC assessment and recommendations are given to the Privileges Committee to determine a sanction, and the report of the committee is tabled. So there is some transparency in the determination of sanctions for serious misconduct that goes through the Privileges Committee. There's no transparency for lesser breaches and limited transparency on serious misconduct based on the discretion of the committee. Now, a number of advocates are concerned about this lack of transparency. Fair Agenda thinks that as long as the complainant has given their consent, information about serious misconduct by parliamentarians should be made public as a matter of course, so the public have visibility on whether those recommendations have been implemented in full. Australian Democracy Network says that it's crucial that there's transparency to the public if a Member of Parliament violates the standards in the Code of Conduct. But there is definitely a conflict with the requirement of increased transparency balanced with the next requirement, that of confidentiality. Now, as far as employment law and HR are concerned, it makes complete sense that the processes of the IPSC, while they investigate and assess, need to be confidential. Particularly for MOPS employees or for less serious allegations, the investigation and the outcome or sanction should be treated like an HR issue is treated in the commercial sector. This bill keeps non-serious allegations confidential, but includes limited provision for a commissioner or commissioners to make public statements regarding conduct issues. And a public statement may also be made by the responsible commissioner where a parliamentarian decision panel imposes a sanction on a parliamentarian in limited circumstances. So we're finding that balance between maintaining MOPS employee non-serious breaches as confidential employee management procedures and allowing the public to bear witness to serious or endemic conduct issues. Now, my preference is probably for a bit more transparency, but I can see that this is a difficult balance to find, and I think that we can achieve the desired purpose in its current form. Next, is it independent? Well, some have argued that the IPSC, as an independent body, should have final say on all sanctions, and the Privileges Committee should not be permitted to impose sanctions on MPs. But there is a problem with this line of argument. MPs are, by nature of their election, in a different employment arrangement than others employed under the MOPS Act. MPs have in effect been employed by their electorate, and the sanctioning by an administrative body is imposing restrictions on a representative that doesn't report to that body. So I'm actually happy with the balance found on this. The Procedure Committee is probably the appropriate body to do the ultimate sanctioning, but the proof will be in the pudding. And lastly, is it fair? Well, the final requirement from Set the Standard is to make sure the process is fair, which is probably the crux of the argument. And the premise is clear. MPs and employees must abide by the Code of Conduct. MPs and employees must have a standard of behaviour that's appropriate for their position, and we cannot accept lower standards of behaviour in Parliament than we would expect anywhere else. So is it fair that investigations and recommendations are confidential and that MPs are sanctioned only by their peers? Well, the public demands more from politicians than it has in the past. We definitely need to do better, And we have the opportunity to use this to make sure that we can reform the way this place operates. So while I think there are likely to be future discussions about fairness, this is huge progress, and I'm really pleased to see this bill. I do support the amendment put by the member for Wentworth that would make this standard apply in this House as well. It's the behaviour in this House that people see. It's that behaviour that we are judged by not only the public, also by the school children that come in and observe us. And I think it's really important that there is a high standard of behaviour in this House as well as in the building more broadly. So this piece of legislation could have gone further, but it is a huge and necessary step up, and I will support it. It's arguably fair, independent, and finds a balance between being confidential and transparent, even if it's not exactly the balance that I might have preferred. So I commend this bill to the House.
The question is that the amendments be agreed to, and I call the Honourable Minister.
To sum up. Okay. Right. Thank you, Deputy Speaker. It now comes to me to sum up this debate and to thank members for their contribution across the Parliament. The purpose of the Parliamentary Workplace Support Service Amendment, Independent Parliamentary Standards Commission Bill 2024, is to establish the Independent Parliamentary Standards Commission. This would implement Recommendation 22 of the Australian Human Rights Commission's Set the Standard report. The Independent Parliamentary Standards Commission would function as an accountability mechanism to ensure safe and respectful parliamentary workplaces. We have in this place a shared responsibility to meet that objective. That's been widely acknowledged by members in their contributions today. A range of actions have already been taken to ensure we have a professional and respectful working environment. This bill would build on those actions already taken by this House and by the Senate. Importantly, it will mean that shortly after the IPSC's commencement, the behaviour codes can finally be adopted. The government thanks members of the Parliamentary Leadership Task Force for their assistance with developing this bill. This bill will have application across the Parliament and it affects us all. We also thank members of the Parliamentary Leadership Task Force Staff Consultation Group for their time and their constructive feedback on the draft bill. That input was very welcome, and I want to thank again every staff member in this building, both current and former, who has helped get us to this place. Equally, I just want to highlight a few of the many contributions from today. The member for Moreton highlighted that while we're talking about cultural change, sometimes it's the physical change that also reminds you what a journey this place has been on. And he reminded us that it was this Parliament that turned a pub into a childcare centre, a sign of this building reflecting modern Australia. The member for Indi talked very intelligently about the fact that robust debate is a core function and job of the Parliament, but that needs to be balanced with our role as role models, and that doesn't mean we can't also engage in respectful debate. The member for Chisholm spoke about her contribution to the Set the Standard report from her experience as a staff member in this building a decade ago. She spoke very openly about people who've had their careers cut short in Parliament while others have thrived. And this is about changing that culture. The member for North Sydney highlighted that everyday Australians disagree that this building exists outside of community expectations. Indeed, we sit within those expectations and we should seek to raise those expectations. The member for Newcastle spoke, and the Deputy Speaker, about the work to land the behaviour codes and how much care was put into that. And I really want to thank the member for Newcastle and the Deputy Speaker for her work. She reflected ago that a decade ago you wouldn't have been able to get legislation like this through the House, and that's a positive reflection upon all of us. I also want to thank her for her work on the Parliamentary Leadership Task Force, something that she's given countless hours to, like many others, and it allows us to be in the position we're in today. I want to note the contribution from the Assistant Minister for Women, who acknowledged it's a unique workplace, but that mechanisms for transparency and the interaction with the Privileges Committee of the Parliament is so important to make sure that we don't use the fact that we are a unique workplace to not meet the standards of modern workplaces. And I wanted to just go to the Assistant Minister for Women's speech in one other thing that she noted that I want to echo, which is that she acknowledged all the staff who contributed their experiences, and she said really simply, for too long this parliament hasn't met the standards the Australian people expect of us, and that we have set standards for other workplaces while not meeting those standards ourselves. And again, in passing this, we will seek to walk in a different direction. The member for Warringah noted the importance of the skill of the commissioners, and I want to echo that, and also that it's important that this be a service available to those who need it, and there is an appropriate way to deal with vexatious complaints. And I echo that. Member for Goldstein talked about the importance of leading here in Parliament and how it lifts the standards for other Australian workplaces. And the member for Curtin, I really want to welcome her commitment to seeing the passage of this bill, and also her commitment to making sure that when people look at this place, they more often than not do, in fact, see the role models that they expect to see. And finally, I want to thank the Minister for Finance, Senator Gallagher, and her team. This bill is the hopefully final piece of the legislative actions that we need to take for the full establishment of the Parliamentary Workplace Support Service and associated functions. Her leadership has got us to this point. She has negotiated and consulted very broadly across the Parliament, recognising how important it is that we all go on this journey together. And again, I want to commend her and her team for that. In saying all of that, Deputy Speaker, I really do commend this bill to the Parliament. It is a credit to all of us that we've got to this point. I'm aware that there are some foreshadowed amendments, and we'll deal with those in the normal way. But I just want to thank all members for their constructive engagement, including members of the opposition. Thank you.
Thank you. The original question was that this bill be now read a second time, to which the Honourable Member for North Sydney moved as an amendment that all words after that be omitted, with a view to substituting other words. The Honourable Member for Wentworth has moved as an amendment to that amendment that all words after reading be omitted, with a view to substituting other words. The immediate question is that the amendment moved by the Honourable Member for Wentworth be agreed to. I put the question. All of that opinion say aye. Aye. To the contrary, no. No. I think the noes have it. No. Is a division required? Thank you. In accordance with Standing Order 133, the division is deferred until the first opportunity the next sitting day. The debate on this item is therefore adjourned until that time. I call the clerk. Call the clerk.
Government business, paid parental leave amendment, adding superannuation for a more secure retirement bill 2024. Resumption of debate on the second reading and on the amendment moved by the member for Deakin.
The question is that the amendment be agreed to, and I call the Honourable Member for Moreton.
Thank you. Thank you, Deputy Speaker. I rise in support of the paid parental leave amendment, adding superannuation for a more secure retirement bill. I'm proud to support these important reforms, which are essential to the economy, essential for families and essential for gender equality. You can always trust a Labor government to make the large-scale reforms that change Australian lives for the better, and this amendment to paid parental leave follows in that tradition. It builds on the Gillard government's introduction of paid parental leave way back in 2011. Who could imagine being in the Parliament way back then in 2011? I spoke in this place at the time about how proud I was of the introduction of 18 weeks of government-funded pay and how valuable it was to everyday Australians. For many parents, it was their first time they could access any paid parental leave. The 2009 Productivity Commission inquiry had laid the groundwork for paid parental leave initiatives and highlighted its numerous benefits. One of the key benefits was the improved wellbeing of families. In particular, there was a focus on the benefits for both child and maternal health, that were associated with an extended period of absence from work around the birth of the baby, and crucially, secure financial support during this period. Other benefits included women maintaining their participation in the workforce and the expression of community values. This included the belief that having a child and taking time out for family reasons is part of the usual course of work and life for many people in the paid workforce, including fathers. These points may all seem very obvious in 2024, but 13 years ago, this was a momentous legislation. As the Minister for Social Services said, paid parental leave is a proud Labor legacy and we will always work to strengthen it. Consequently, it has been one of the priorities of the Albanese Labor government to modernise the paid parental leave scheme. That's why from 1st of July last year, we enable more families to access the payment due to a more generous family income test. And it's also why we've made it easier for parents to share care and increased the flexibility of the scheme to help with parents' transition back to work. Some low-hanging fruit when it comes to productivity gains, Deputy Speaker. Most recently, the Labor government extended the length of the paid parental leave scheme. From 1 July this year, we increased it by 2 weeks, expanding the scheme from 20 to 22, and the scheme will increase by 2 weeks each year until it reaches 26 weeks of paid parental leave in 2026. This bill is a continuation of these significant reforms. It's acknowledged that women undertake the majority of unpaid care in Australia, whether that's looking after children, ageing parents or other family members for various reasons, and I certainly would like to commend my wife for doing that while I've been running around in Canberra. Had 2 young children, also got a law degree and changed careers at the same time. Amazing woman. Time spent away from the workforce during this crucial work unfairly affects women financially, and that is understating the effect. The Women's Budget from May described spending more time on unpaid care than their male counterparts impacts women's lifelong economic security by limiting their labour force participation, career progression and leadership opportunities. The Albanese Labor government not only recognises the long-term economic consequences of the disproportionate share of unpaid care work that women primarily do. With this bill, we are doing something positive about it. The Women's Budget Statement drew on the Working for Women, a strategy for gender equality, when it stated, to achieve in an Australia where people are safe, treated with respect, have choices and have access to resources and equal outcomes, no matter their gender, women and gender equality must be at the centre of Australia's economic plan. And that is what this bill does. The Albanese Labor government is investing $1.1 billion over the forward estimates to pay superannuation on government-paid parental leave from July 25. This will directly address the current inequitable situation where women with children experience an average 55% drop in income in their first 5 years of parenthood. This compounds over time and with more children to the point that women retire with around 25% less in their superannuation than men. Yes, 25%. This bill means that all eligible parents will receive an additional 12% of their paid parental leave directly into their super fund from the 1st of July next year and will continue to match the superannuation guarantee rate. The ATO will make the contribution annually after the end of each financial year. The payment will include an additional interest component to address any issues resulting from the payment not being made more frequently. We anticipate that around 180,000 families will benefit from these changes, and once the paid parental scheme reaches its full 26 weeks in 2006, a family will receive a superannuation contribution of around $3,000. Beyond the financial benefits, I think it's important to note that paying super on paid parental leave will go a long way to normalising parental leave. This means making it a standard in every workplace, like annual leave or personal leave. It also signifies that care work is highly valued, a much-needed cultural shift, and enables it to be shared between parents. Businesses, unions, experts and economists acknowledge that a key factor in boosting productivity and participation is to provide more support and choice for families, which results in more opportunities for women. The benefits for business include the retention of trained and valued staff, the reduction of recruitment costs and the enhancement of staff morale and productivity. This bill also contains some technical amendments. It ensures the parental leave framework in the Fair Work Act is in sync with the paid parental leave scheme. Deputy Speaker, this reform is in the tradition of the life-changing economic and social initiatives of former Labor governments. I'm talking about the governments who gave the nation Medicare, the Pharmaceutical Benefit Scheme and the National Disability Insurance Scheme. all devoted to helping the collective. Reforms in both unpaid and paid care are a key focus of Working for Women, a strategy for gender equality. The Women's Economic Equality Task Force stated that despite women's work, both paid and unpaid, acting as the backbone of our economy during the COVID-19 pandemic, today women's work is still undervalued. Superannuation on paid parental leave is an important way of addressing this issue, and narrowing the gap in the use of and access to paid parental leave is a key outcome. Paid parental leave supports parents when they're caring for newborn children. It helps families balance their caring responsibilities with work, and now it will support them when they retire. The Albanese Labor government's tranche of reforms is the largest expansion to paid parental leave since it was established by the Gillard government, and I commend the bill to the House.
The question is that the amendment be agreed to, and I call the honourable member for Goldstein.
Thank you, Deputy Speaker. More than 11,000 women in Goldstein have received Commonwealth parental leave pay since the scheme began in 2011, and they've lost out as a result of superannuation not being paid on the scheme. A fair paid parental leave system has the potential to be a game changer for families, the economy, and for women's economic security in this country. It's a bold statement, but not many policy levers have the power to bring about the sort of cultural change that's needed to elevate Australia's recent poor record on gender equality. Women don't start out behind. Australian women are among the most highly educated in the world and have similar levels of labour force participation to men until they have children. This triggers a pattern of unequal care and work during prime working years for both parents, with the responsibility of care falling more heavily on women. And this results in women's participation in the workforce sitting well below that of men. When mothers take time out of the workforce to care for their children, not only do they struggle to maintain a meaningful connection to work, but they can also go years without receiving any super. Unpaid care, part-time and casual employment, the gender pay gap, these are the drivers of the gender super gap. Leading up to retirement, the median superannuation balance for women is a third less than that of men. That translates to around $50,000 less. The super gap becomes evident around the age of 30, when women take time out of work and reduce their hours to have and care for children. The gap continues to increase until women are in their early 50s, when it's common to care for ageing family members. Women at this stage in their life are often caring for their own children and their parents, a life stage referred to as the sandwich generation. Progress in closing the gender super gap has been slow. Australian Tax Office statistics show that over the 8 years to 2021-22, the gap in average balances for those aged 18 to 59 has only narrowed by 5 percentage points, from 28% to 23% across all ages. However, for women in their 30s, the gap has failed to narrow, remaining around a stubborn 20%. Paying super on paid parental leave is one way to reduce the super gap and reduce the impact of parental leave on retirement incomes. The adding superannuation for a more secure retirement bill is another step towards a fairer system, and I commend the government for building on the changes to paid parental leave that came into effect last year, including expanding the payment to 6 months by 2026. Eligible parents with babies born or adopted from July next year will receive an extra 12% of their government-funded paid parental leave as an annual lump sum payment to their super fund. This will benefit about 180,000 families annually. Super Members' Council analysis shows that paying super on the government scheme could boost a mother of two's retirement savings by about $14,500. Paying super on PPL was one of the recommendations of the Women's Economic Equality Task Force. Central to this recommendation is a recognition of the value of care work and the need to better share caring responsibilities. While the number of men taking primary carer parental leave increased by 0.6% in 2022-23, women still make up 86% of employees taking the carer leave option, according to the Hilda survey of Australian households. The use of parental leave by fathers in Australia is very low by global standards. And because caring patterns are established in the first year of a child's life, that entrenches stereotypical gender roles. We should be encouraging men to take up parental leave, to normalise flexible work and shared care responsibilities, strengthen women's workforce participation and financial security. But it's not only good for women, it's healthy for men. When fathers take parental leave, fathers, their children and their partners all benefit from stronger relationships. This is why I strongly pushed for super on paid parental leave in this place and in my many conversations with families in Goldstein. As I've said before, it's time we stopped punishing women for the burden of unpaid care work that they carry. Taking time out of the paid workforce to care for a child should be part of the usual course of life and work for both parents. The evidence is clear. Accessible and well-funded paid parental leave is crucial if we want people to stay connected to the workforce. But it's also vital to support the health and well-being of women, men and children and to improve wider gender equality outcomes. I commend the government for adding super to paid parental leave, but there are also other things the government can do to reduce the super gap. The low-income superannuation tax offset, or LISTO, is not indexed. It's not kept pace with increases in the super guarantee rate and current tax brackets. The current cap means workers earning up to $45,000 are paying more tax on their super than they should be. Low-income women would be the biggest beneficiaries of updating the LISTO. Another policy area of potential benefit to women is adjusting the rules around catch-up contributions to allow women to put more money into super as they're approaching retirement. The Goldstein community elected me on a platform of gender equality, and at every opportunity I'll continue to work with the government to improve women's economic security. Adding super to paid parental leave goes some way to achieving that. Consider the more than 11,000 women living in Goldstein who've received Commonwealth parental leave pay since the scheme began in 2011. They've missed out on a combined $13.1 million in superannuation. About 850 women in Goldstein per year are set to benefit from the government's commitment to pay super on parental leave each year. It's long overdue, and I commend this bill to the House. Thank you, Speaker.
The original question to this bill be now read a second time to this. The Honourable Member for Deakin has moved as an amendment that all words after that be admitted with a view to substituting other words. The question is that the amendment be agreed to. And I give the call to the Chief Government Whip.
Thank you, Mr Speaker. The paid parental leave is an important and absolutely critical piece of legislation from this government. So it will add superannuation for a more secure retirement, and that, of course, is the name of the bill. Paid Parental Leave Amendment, adding superannuation for a more secure retirement bill, 2024. This is an important thing for women across the country in particular, because we all know that women finish work with less in their superannuation. In fact, half often of what men, the male population, finish work with. And some of that is about the childbearing years. Some of that is about the time out of work because they're caring for children. So this superannuation added to PPPL will make an enormous difference to the end outcomes for women. Adding, and of course we have the compounding interest impact of those superannuation savings over the course of decades, and that will make a difference in terms of what's happening to women's superannuation in their 20s and their 30s, all adding to a finish. Now, if I take my superannuation, for instance, I'm sure that in real terms, my superannuation lump sum is going to be very different to some of the men sitting in this chamber now, because I was a teacher, because I'm a mother of 3, because I took 6 years out of employment in my childbearing years to have my family. So my superannuation is already impacted by that because, of course, there was no paid parental leave superannuation when I was having my family. So, Mr Speaker, this is a critical piece of legislation. It needs to be passed in this chamber. It needs to ensure that it comes into law so that women can have the surety that their superannuation on retirement will come near matching those of their partners, those of their brothers and those of their fathers. Mr Speaker, it is a hallmark of this government that we take seriously women's participation in the workforce and women's financial security, not in terms of welfare for women, but in terms of women's earning capacity and their legitimate right to the same outcomes as the male population. And, Mr Speaker, it is not an accident that a 15% pay rise for the feminised workforces in aged care and in early childhood education are coming from this government, because it's a government with a majority of women. Women who are driving policy to improve the lives of women. That includes, of course, the financial lives of women, ensuring that they have similar retirement capacity as men. Mr Speaker, it is critical that this bill be passed through this House uncontested. I would suggest that anyone who stands in the way of this bill...
Members, in accordance with the resolution of the House, a scheduled test of the House of Representatives' emergency procedures is going to be undertaken. The member will have leave to continue speaking when the debate is resumed. I ask that sound and vision broadcasting now cease.